commencer. Merci d'abord de votre présence. C'est ma deuxième réunion en tant que présidente du comité. J'espère que tout ira bon train comme à la dernière réunion. Nous allons donc officiellement commencer la réunion. Bienvenue à la 14e réunion du Comité permanent de la justice et des droits de la personne de la Chambre des communes.
October 1, 2025, the committee is meeting to continue the clause-by-clause study of Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural places. Today's meeting is taking place in a hybrid format pursuant to standing orders. Members are attending in person in the room and remotely using Zoom, although I don't think they are. I'd like to confirm that the sound tests were made successfully. Before we continue, I'd ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, including and especially the interpreters. You will also note a QR code on the card which links to a short awareness video. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Is anybody on Zoom?
No.
Okay, I'll skip that part. Okay.
Except
Just Okay, so for those on Zoom, at the bottom of your screen, you can select the appropriate channel or interpretation, either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, Mr. Baber, do you mind? For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. We appreciate your patience and understanding. I want to welcome our witnesses back again for joining us today from the Department of Justice. Kristen Ali, Manager, Senior Counsel, Criminal Law Policy Section. Joanna Wells, Senior Counsel, Criminal Law Policy Section. And Marianne Breeze, Counsel, Criminal Law Policy Section. Now, before we get started, we are at Clause 4 debating BQ2 amendment, which is where we left off at the last meeting when it was adjourned. Also, I remind you that new Clause 1.1 and Clause 2 were also stood down. For the benefit of all members, once again, if you have sub-amendments or new amendments, please provide them in writing and in both official languages to the clerk. Now we're going to move to continue BQ2 at Clause 4. Sorry?
I don't believe we're in the right. I believe we're at Lib 1. That's all I
Oh, really? Okay.
To remove the word swastika. No, we didn't. We deliberately went to all of the offenses that related to the Attorney General, and we're supposed to come back. We passed Ms. Idlat's amendment, which was NDP 1, and then we rejected it exactly, and then we went through we agreed by committee to go through all the ones that were related to the Attorney General. And then we should be back at Lib 1, which relates to the swastika.
Right.
Lib 1 follows Block 2.
Okay, on my thing it didn't. Does it? Okay.
It follows it.
Okay, sorry. Then apologize.
Okay, we're all good? Okay, thank you. Just a reminder, there's votes tonight. Bells are expected around 5:15, give or take. We'll deal with that when we get to it. That's for me. Okay, all right. Okay, all right. So we are ready to resume then. So we are on Mr. Brock. We're on just to be
We're on
clear,
Block 2.
We're on Block 2. Yeah.
Yeah.
Okay. Now, just before we move on to Block 2, and I'll get back to Mr. Brock. If BQ2 is adopted, Lib 1. CPC 6 and CPC 7 cannot be moved due to a line conflict. Okay, now we're ready to roll. Did you have your hand up, Mr.
Yes, I did.
Okay.
Thank you, Chair. And I have several comments to make, but I'll summarize as best I can. It's clear that Bill C-9, and given the deal that has been worked out between the Liberals and the Bloc, has become a lightning rod to religious organizations right across this country. I have been inundated, as several of my colleagues at this table and several colleagues in my caucus, with concerned members of religious leaders of all kinds of denominations that this is a direct attack on the freedom of expression and the freedom of religion. Given how toxic and how divisive this block amendment is and will continue to be, and now with Liberal support, we are at an impasse. It's no small wonder that an additional 6 hours of resources have been devoted to this meeting. I also want to clarify a sense that the Conservatives have been deliberately blocking and filibustering any attempt on the government to prioritize and to move to study Bill C-14. That is an absolute lie. It has been circulated for at least 2 weeks now in and outside the House of Commons. One can only take a look at the dysfunction of this particular committee. Former chair of this committee had abruptly ended meetings, did not call meetings. I know our current chair also did the same last week. If that is not a deliberate stalling tactic on behalf of the Liberal government, I don't know what is. But it is clear that it is always and will always continue to be the priority of the Conservative Party of Canada to address the elephant in the room, and that is the explosion of violent crime in this country. Since my election in 2021, I have been singularly focused on strengthening provisions in the criminal code as it relates to bail and sentencing. I wasn't alone in this crusade. We've heard from premiers, we've heard from law enforcement, we've heard from victim advocacy groups, we've heard from municipal leaders, all advocating, pleading, and begging for this government to take real action. And what did the government give us? They gave us a failed Bill C-48, which did nothing to stem the tide. We had an election. One of the issues in the election was community safety. We all heard that knocking on doors. So it was a real surprise to me and to members.
Mr. Housefather?
Mr. Chair, is this relevant to clause by clause?
Yes, it is.
I'm not
I'm
sure.
getting to it.
I'll give Mr. Brock some latitude. I mean, he's been talking in anticipation of what may or may not happen in the
Yes.
future, but we're not quite there yet. So if you're addressing this clause, then Mr. Brock, you can continue.
So we had an election. A number of issues were front and center. Community safety and a government response to address community safety was front and center. We all anticipated that when we returned to the House in the spring, one of the first hallmarks of this Carney government would be the introduction of bail legislation to deal with community safety. That didn't happen. All through the summer, I anticipated that some proposal, some policy would be introduced that we would study in the fall. That didn't happen. Ultimately, C-14 was introduced. We studied it. We looked at it in the House. We debated it in the House. It passed second reading. It is now waiting in the wings to be studied here. So I want to make it abundantly clear to everyone who is watching this particular proceeding and to all of the groups who have an interest in community safety. I've always said and always will say that community safety is not a partisan issue. Regardless of your political ideology, everyone wants to live in a safe community. So given the impasse that we are at with respect to C9 and the block proposed amendment, I have a proposal. And that proposal is to seek unanimous consent from every member at this committee I'll read out the consent motion that I wish to adopt. That to improve public safety in our communities and to protect Canadians from repeat and violent offenders, the Committee A immediately prioritize the consideration of Bill C-14, the Bail and Sentencing Reform Act, and work together to report the bill to the House at the earliest opportunity. To B, sit through the winter adjournment to undertake meaningful consultations with victims, community leaders, police services and associations, and other relevant witnesses. And C, pause consideration of Bill C-9 to make room on the agenda for Bill C-14. With every day that we do not, as a Justice Committee, deal with Bill C-14, more murders are going to happen in our community, more sexual assaults, more extortions, more car theft. Victims are coming through loud and clear. They want this committee.
Mr. Brock, sorry, I have a point of order. Mr. Chang.
How is this relevant to the consideration of clause by clause of C9?
Thank you. It's not. It's not relevant at all, in fact. We're in the middle of clause by clause, Mr. Brock. I understand your point. The one point I take from your comments is that you want to move forward expeditiously, which I think we can all agree with.
I do, and I'm asking for unanimous consent, Chair.
But I don't think it's on point. We're dealing with clause by clause. Mr. Chang's point of order is accurate, and I agree with him. So we're going to move on to clause by clause.
Challenge.
So I'll give off. Okay, that's your right. But just let me finish. I'm going to then give the floor to Mr. Fortin to continue discussion on that. So, but that's my ruling.
But like you guys can just give consent.
Okay, Mr.
Do you not want to do C-14?
This isn't a debate, Mr. Lawton. There's been, hold on.
They don't care about the communities that are hurt by C9.
Gentlemen,
right?
please, all members on both sides, please speak when I give you the floor and not otherwise. Mr. Housefather, Mr. Lawton, applies to everybody. I would ask that you respect each other, respect the interpreters, don't talk over each other. I will give everybody an opportunity to speak when it's appropriate, but do not speak at the same time or when it's not your turn. I've made my ruling on Mr. Chang's point of order. Mr. Brock, you're challenging my ruling, is
Correct.
that? Okay. Mr. Clerk?
So thank you, Mr. Chair. Yes, thank you, Mr. Chair. So on the question, shall the chair's decision be sustained? We will go to a vote. Madame Lattanzio?
I want to sustain the judgment.
Yes, in favor would
In
be
favor to
sustaining
sustain it,
the
yes.
decision. I'm sorry.
Yes.
Yep.
Okay.
Thank you. Monsieur Housefather? Yes. Madame Dillon? Mr. Chang? Mr. Brock?
No.
Mr. Baber?
No.
Mr. Lawton?
No.
Mr. Gill?
No.
Monsieur Fortin?
So clearly the
thank you.
Liberals do not
Mr.
want
Brock,
to prioritize
Mr. Brock,
C-14.
you do not have the floor, Mr. Brock. If you will respect the chair and respect other members of the committee, when it's appropriate for you to speak and others, I will give you the floor. I would ask that you don't do it otherwise. Mr. Fortin, we are on your amendment, BQ2.
Point of order, Mr. Chair.
Mr. Jenis?
Could you just clarify what the ruling was? Is it that a member can't bring forward a request for unanimous consent motion?
My ruling was that it was not relevant to the amendment we were discussing.
Is your ruling that relevance is required for a request for unanimous consent?
We went through this the last meeting. The ruling was made.
No, I'm just asking what it was.
And it was upheld. So, Mr. Fortin,
I'm just
you have
asking
the
what it
floor.
was, Chair.
Well, and I've answered the question twice now. Mr. Fortin, the floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. Chair. So we're at BQ2, if I'm not mistaken. So BQ2 in C9 would replace at 4.2, where it says, where there is an offense, hate crime against identifiable group, displaying one of the following symbols, and we would replace this by one single symbol. say, a symbol that is used principally in the sense of the bill. This means that the offense would have to do with an identifiable symbol of a terrorist group and no longer swastika or some similar symbol. The reason for this is that the swastika is a symbol that was used not only for the grave crimes committed during the Second World War by the Nazis, but it is also a symbol used by certain religious communities. And we don't think that they should be ostracized or indirectly punished. And paragraph C says that the two could be confused. This seems rather vague and counterproductive. So what we propose is that we would forbid those symbols that can be identified with a terrorist entity registered in the criminal code or listed in the criminal code.
And,
Monsieur Fortin, Monsieur Brock. Merci. Je souhaite déposer une motion que le comité passe à l'étude du C14, loi portant sur la réforme de la liberté sous caution. C'est une motion dilatoire. Je demande qu'on passe au vote. On est à l'étude article par article. Une motion a déjà été reçue. Vous ne pouvez pas déposer une autre motion. Il s'agit d'une motion dilatoire. Je comprends. Les motions dilatoires ne peuvent pas être déposées à tout moment. Dans ce cas-ci, ce n'est pas possible. Si vous avez un commentaire ou des commentaires sur l'amendement proposé par M. Fortin, la parole est à vous. Rappel au règlement. M. Lawton. Monsieur le Président, pouvez-vous nous citer le règlement qui détermine que la motion est jugée non recevable? Vous voulez empêcher l'étude sur la liberté sous caution. Inaudible pour l'interprète.
okay. All right, Mr. Lawton, sorry I interrupted you.
I was just hoping you could say, it sounds like you're just trying to predetermine the outcome because the Liberals do not want to allow study of their own bail bill. So I'm just curious on what authority you're saying this motion is not permissible when we're saying we can and should move to a bill on which there is a lot more consensus than there is on C9.
Okay, that sounds like debate on a dilatory motion to me, but no, the editorializing isn't necessary. I understood what Mr. Brock was trying to do. I ruled that his motion was out of order because of the timing it was put on the floor, because we're in the midst of debating BQ2.
Point of order, Chair.
Mr. Jennings?
Yeah, Chair. I mean, very respectfully, the Green Book clearly identifies a series of dilatory motions, and I know you're in your second meeting in this role as Justice Committee Chair. It's page 1167 of Procedure and Practice, where the dilatory motions are listed. A motion to proceed to another item. You would only use that in a situation where you wanted to proceed to a different item from the one that was currently on the table.
If somebody wants to challenge my ruling, they're free to do so. We're not.
Could I invite
I'm not entertaining debate on the ruling I've already made.
Chair, I promise you, I'm not making things up.
I've already made the ruling.
It's
if somebody wants to challenge my ruling, that is their right to do so.
Procedure and practice.
This is not a debate.
Could the clerk clarify the rules at least?
No, the ruling's already been made, Mr. Jennings. I've set out the process we're going to follow here.
Okay, what?
Okay, thank you.
All right. You don't get to make things up, though, Chair. There's a book.
Okay, and you don't get to speak when you don't have the floor. So, Mr.
Okay,
Jennings,
I have a point of order, Chair.
Okay.
I have a point of order.
Okay, now Mr. Brock is going to challenge my ruling. That's fine. Okay, Mr. Brock.
Okay. So sorry. Okay, so on the chair's decision, the question is, shall the chair's ruling be sustained? Sustaining the decision will be voting in favor. So, Madame Latenzio?
In favor?
Monsieur Hosfather? Yes. Madame Dillon?
Oui, monsieur.
Mr. Chang?
Yes.
Mr. Brock?
No.
Mr. Baber?
No.
Mr. Lawton?
No.
Mr. Gill?
No.
Mr. Fortin?
Oui.
It's fine.
Okay, thank you. Is there any further debate on Mr. Fortin's proposed amendment? Ms. Latanzio?
Thank you, Mr. Chair. So with regards to the BQ amendment, which replaces the offense, so it only covers symbol used by the listed terrorist entities under section 83.11, removing Nazi symbols, SS bolts, and other hate symbols from the bill. The amendment removes almost all of the hate symbols that communicate hate, and asked, we've been asked, communities have come forward and they've asked us to address, including the Nazi symbols that we heard through the testimonies and other imaginary used images to intimidate people in public places. So groups have told us here in committee quite clearly that the problem they are facing is the open display of hateful symbols like the SS bolts, and narrowing the offense, that this would ignore what they've asked for, the specific amendment. So limiting the offense to listed terrorist entities would leave many of the symbols that the Jewish, Muslim, Black, LGBTQ plus communities and others have told us that are being used to threaten and harass them, really going against the spirit of this bill. So the terrorist entity list is small and slow to update. So this approach would make the offense far less useful and far less responsive to what is actually happening on the ground and in our streets. So we want this law to be practical for police and meaningful for communities affected, and thus this amendment would weaken it to the point where it no longer meets that goal. And so for that reason, we will be voting against.
Thank you, Mr. Latanzio. Mr. Lawton? Mr. Lawton, Mr. Brock, and Mr. Babber.
So I've cited an instance from a couple of months ago in my riding that is very germane to this a few times on this committee, which was that someone under existing criminal laws was arrested and charged for having a swastika mowed into their lawn. And there were no separate offenses in the criminal code, no additional police powers that were required for that. And this is an issue that, again, was another one of many crime stories that emerged in my riding. And I've had a great many conversations with police chiefs, with frontline police officers. And when they talk about what they want, not one of them has said they want C9. They talk about wanting bail reform. They talk about wanting legislation like we've put forward in the Jail Not Bail Act, legislation that we have tried to, in this very committee meeting, move our attention to because there is a lot more consensus on it. And I find it shocking that the Liberals will get up in the House of Commons, accuse us of blocking bail work while denying the opportunity to get to it, Mr. Chair, and you're silencing me again.
No, I'll give you the floor back. We have a point of order. Ms. Latanzio?
Mr. Chair, again, there's a question of relevancy here today, and I think it's quite clear the Conservatives do not want to proceed with C9. At every opportunity, we are invoking other pieces of legislation, which I am hopeful we'll be able to get to if we can finish with this one here before us. So we are very much looking forward to deal with other pieces of legislation that will come, that are before this committee and that will be forthcoming in this committee. But today, we should be, concluding our works on C9. And it is very clear by the interventions, Mr. Chair, at every turn, we are trying to, stretch the time and not have to deal with this clause-by-clause study. And it's, it's very apparent, and it's, and I would invite the Conservative members on this committee to move ahead so that we can move to the study of other pieces of legislation. You keep this up, we'll never get to it.
Okay, back to you, Mr. Law. I think it goes without saying, the sooner we get through this bill, the sooner we can get to the next bill.
Yeah,
I don't think we need to repeat that over and over again, Mr. Lawton. The floor is yours.
My point, and where it is germane, is it is about community priorities, it is about justice priorities, and I find it fascinating that the Liberal government is holding its own bail bill hostage and using that as leverage to force us to advance very bad legislation that will attack the rights of Canadians. I'm sure he does.
Mr. Chair, relevance to Block 2. This has nothing to do with Block 2.
I'm inclined to agree with you, Mr. Housefather. I mean, we've gone.
I cede the floor.
Thank you. Okay, Mr. Brock, I believe.
I see what the Liberal members are doing, Mr. Chair. They say one thing to the community at large. They say one thing to the House and accusing us, including the parliamentary secretary herself, accusing Conservatives of deliberately blocking the study of C-14. I have now brought forth a unanimous consent motion that could have dealt with prioritizing bail and sentencing. To my colleague, Mr. Lawton's point, I'm not done yet.
I know, Mr. Brock, with all due respect, and I really don't want to interrupt anybody. I don't want to.
Well, then why are you interrupting me, Chair? I'm not even done my point. No one has raised a point of order. You're supposed to be independent, Chair.
I am independent, Mr. Brock.
Not when you interrupt me, you're not.
And if you're going to continue making the same point you did on the point of order
earlier. How do you know?
Earlier,
because you're not allowing me to finish my comments.
Same thing.
You're not allowing me to finish my comments, Chair.
You just repeated
That's
the same thing.
completely inappropriate.
What I'm saying is you need to stick to the amendment we're dealing with right now.
And I'm speaking to that. If you'll let me finish,
okay,
I will speak to it.
As long as you keep it relevant to the clause we're debating, that'll be fine. Thank you, Mr. Brock. Continue.
Now, Mr. Lawton raised serious concerns about Bill C-9. Now, when we raise concerns about Bill C-9, that is extremely relevant to every clause by clause that we are about to consider. Because he is not narrowing his commentary with respect to Block 2 does not, by definition, automatically mean that he's not speaking with relevancy to the whole purpose behind C-9. That's where I object. That's where I wanted to support my colleague. That's where I wanted to call out these Liberal members who refuse to be honest with Canadians that we need to deal.
No, and I'm going to make this point whether it's a Liberal or Conservative or a Bloc member. If people are going to start calling each other names and using words like lying, this meeting is going to be really long, and I'm not going to put up with this. Well, Mr. Brock,
I'll sit all night, Chair.
And we might be.
Give me the resources, I'll sit all night.
I know better than that, and my colleagues on my right know better than that. Please, I'm just asking for a level of civility here. Do not use words like lying, ascribing sort of motive to people when they haven't been. It's out of line. So, Mr. Brock, you have the floor, but I'm pleading with you.
Well, and I hope,
sir,
Chair,
I will follow the same rules regardless of who's talking.
Sure, and I take your comments at heart, and I hope that when you hear your colleagues, particularly the parliamentary secretary in the House, using that type of language, that you will pull her aside and you will call her out. Okay?
Except we're not in the House. I can only control the process of the committee.
Right.
So let's move on.
I wanted to continue, sir, because I had some grave concerns, and that's why I challenged your decision, because I don't know what authority in the Green Book that you are relying upon to rule that my motion that I just indicated that I wanted to deal with, which was a dilatory motion, was not appropriate to be dealt with here and now. You made that ruling saying the block motion takes priority over my motion, and I wanted to ask you, perhaps in consultation with the clerks, what particular authority you are relying upon.
Okay, the issue's been dealt with, Mr. Brock. If that's the end of your submission, we can move on to Mr. Baber.
I'd quickly say, with respect to Block 2, that I'm mindful of the concern that Mr. Fontaine has articulated. However, that could easily be dealt with by an amendment that would remove the reference to the word swastika, as has been asked by various representatives of the Hindu community. However, I'd like to understand from the chair, and granted I am new here, nonetheless, this goes beyond our desire to talk about bail. I just want to understand the process here, and that is that if a motion is sought, every member it's I would almost think it's not just a matter of order, it's a matter of privilege that a member of this committee is able to ask for unanimous consent at any point. That would be a dilatory motion. But we have a situation here where the chair ruled, in my view, respectfully, incorrectly, and then is able to sustain his own incorrect ruling with a vote. So effectively what is happening here is you can dispose of decorum, you can dispose of the rules if the Liberal members vote in favor of doing such. And in that case, what's the point of having any rules? And so I'm asking the chair, please, to allow Mr. Brock to move his motion, and let's have a vote. Let's deal with C14, with bail and sentencing. Let's deal with that right now. But to vote to effectively to suspend the rules, to continue with this terrible piece of legislation, C9, is not appropriate.
Okay. My
Maybe-
ruling, to be clear, was that it was an inappropriate time to make that motion. If you or Mr. Brock or others want to make a motion at an appropriate time, that's different. But we have already moved on from that issue. So if you have other submissions on this amendment, the floor is yours. If not, we can move on to Mr. Gill.
Could you please clarify to me what is
No, I
appropriate
am
time
not-
and
I
what is
am-
not appropriate time?
Well, okay.
He can move a motion
Your
at
friend-
any time.
Your colleague back there has the green book. Mr. Gill?
Thank you, Chair. Thank you. And I would like to talk about what I am hearing in the riding where I represent. And every single person I'm speaking to is talking about that we should be looking after C14 first, because bail and sentencing is very important for all of us. And we all agree to a point that this is the legislation we have to put forward. And now we are delaying, and every single day we are delaying is causing problems in the neighborhoods, on the streets.
Point of order.
Mr. Chang?
How is this relevant to the clause by clause of C9?
It's not.
It is relevant, sir.
Well, no,
Chair,
because
it is relevant.
you're talking about a different piece of legislation. I'm imploring you, if you want to talk about C9, which is what we're here debating, please do so. I'll give you all the time you want. We have unlimited resources as far as I'm concerned.
I'm coming to it.
Okay, but you haven't addressed it yet.
If you will
So-
keep injecting
so
me
in the circumstances,
for these
Mr.
kind of
Chang's-
point of orders, then I would not be able to
Mr.
speak.
Chang's point of order, I've deemed appropriate. I'm going to give you the floor back. If you want to talk about this bill and this amendment, please do so.
Yeah, and it is important for us to understand what we are hearing at the ground level reality, and then we have to work accordingly. Our main purpose is to look after what people are in need at this point of time, whether it's C9 or C14. And you know, and we all know, in fact, that extortion calls are coming every single time. You know, gun shootings are happening every single day. People are scared. You know, families are being targeted. Businesses are threatened. These are the things that we have to look after. And I would suggest strongly that we should be looking after C14 right now, and we have to support the motion presented by my colleague, Mr. Brock, and we have to move
Point of
forward
order.
on that one.
Relevance again.
Mr. Chang?
Relevance.
I agree. Mr. Gill, you're still not talking about this bill or more specifically this amendment.
Mr. Chair, if that is the case, then I'll cede my time and then move on. But actually, you know, we should not be stopping anyone to speak when we are talking about the important legislation that need to be discussed at this committee meeting.
Thank you, Mr. Gill. Okay, any other further submissions on Mr. Fortin's proposed amendment? No? Okay, so before we put it to a vote, let me just remind you what I said at the outset. If BQ2 is adopted, Lib 1, CPC 6, and CPC 7 cannot be moved due to a line conflict. Okay, so we'll put it to a vote now. Mr. Clerk.
Yes. On amendment BQ2, I will go with Madame Latenzio,
No.
Monsieur Osfather,
No.
Madame Dillon, Mr. Chang,
No.
Mr. Brock,
No.
Mr. Lawton. No. Mr. Baber,
No.
Mr. Gill,
No.
Mr. Fortin,
Oui.
defeated 1-9.
All right, amendment defeated. Thank you. Okay, so now moving on to Lib 1. So I will give the floor to Mr. Housefather.
Chair, this is a simple amendment. The Hindu communities and some other communities, the Jain community, view the swastika as a holy symbol in their culture. We can refer to the Nazi Hakenkreuz, which is the symbol that used by the Nazis without using the word swastika in the English version of the bill. And so my amendment, all it does is remove the word swastika from the English version of the bill. And I hope that this is something that we can all agree on, given the community's representations. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Any other submissions on that? No? Okay, so we'll move on to vote on Lib Amendment 1.
On the vote.
On the vote.
Madame Natenzio?
In favor?
Monsieur Housefather?
In favor?
Madame Delin?
Oui.
Mr. Chang?
Yes.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Lawton?
Yes.
Mr. Gill?
Yes.
Mr. Fortin? Unanimous. Carried? Yeah, unanimous.
Okay, amendment carried, which takes us to CPC 6, which I believe is Mr. Brock.
And please read.
Hold on, yeah, hold on.
There is a note.
Mr. Lutz.
Yeah, hold on. Oh, yeah. Sorry, just before you get the floor, Mr. Brock. If CPC 6 is adopted, CPC 7 cannot be moved to a line conflict. Mr. Brock, do you want to speak to this?
Actually, it's Mr. Lawton's motion
Sorry, Mr. Lawton.
amendment.
Thank you. So we have raised in the course of our study of C9, study that has been sadly shortchanged because of Liberal obstruction, that there are grave concerns with a number of sections of this bill, how it will affect civil liberties, how it will affect, in some cases, the very communities that the Liberal government claims it will protect. And there have been several concerns raised specifically about the section on hate symbols. And we will be discussing those more thoroughly when we get to the clause at hand. But if we are to, as a committee and as a parliament, enumerate hate symbols, symbols that have vile meaning, symbols that carry a death toll that often bring up a lot of trauma to various communities, we need to be thorough with it. So I am proposing the following amendment, that Bill C9 in Clause 4 be amended by adding after line 3 on page 2 the following, B.1, the communist symbol known as the hammer and sickle, or B, by replacing line 5 on page 2 with the following, scribed in paragraph A, B, or B.1, that it is likely to be. So in layman's terms, this is adding the hammer and sickle, the communist insignia, to the list of hate symbols. Communism has a death toll of 100 million people around the world. People have died as a result of dangerous and harmful ideology perpetrated by that. I've had a number of concerns raised by people who have lived under communist rule in Cuba, in Eastern Europe, people who see this as being an incredible evil that needs to be stamped out. The Soviet Union under Joseph Stalin from the 20s to the 50s saw some of the worst mass repression in history and mass killings, from the Great Purge to Gulag forced labor camps, collectivization and terror famine, a death toll in the Soviet Union of up to 27 million. You have in China under Mao Zedong, the Communist Party carrying out massive repression, causing the deaths of tens of millions through executions and labor camps and man-made famines. You have Cambodia under the Khmer Rouge from 75 to 79. One of the worst episodes of mass killing in the history of the 20th century, with up to 2 million people killed, including, that's around 25% of Cambodia's population. So if we are to describe what hate symbols are in law, we need to acknowledge the death toll of the hammer and sickle. So I move this amendment for consideration, that it be added to the list. Thank you.
Thank you, Mr. Lawton. Anybody else? Mr. Barber?
I have to give it to my friend, Mr. Lawton, really. As some committee members have heard by now, I was born in the Soviet Union, and I lived in the Soviet Union until 1989. And frankly, when I look at the hammer and sickle, I'm scared. I appreciate Mr. Housefather's previous amendment, and I appreciate his sentiment, as we both come from the same community with family who was deeply affected by the Holocaust. But I can tell you that my family has also been significantly affected by communism. And I frankly do not see much of a distinction between the two. The hammer sickle represented collective oppression. If I could maybe summon my thoughts here, this is definitely interesting. I'm not sure if Mr. Lawton mentioned that it is estimated that subsequent to the World War, more than 20 million Soviet citizens were murdered by the communist regime. And it wasn't just confined to Jews, it was everyday people, Ukrainians, intelligentsia, anyone who had any type of microphone, press members, educators. And so I view it as a hate symbol, and I believe that it is a hate symbol because it drives the extreme of collectivist ideology, where the state says, not my way or the highway, but my way or murder. And I hope that all my friends from around the table will support this amendment. Thank you.
Thank you, Mr. Weber. Any other discussion on that point? No? Okay.
We're going to vote?
Yeah, there's no more? No, we're going to vote. Okay, so we're on,
CPC 6.
okay, Sal, CPC carry. CPC 6 carry, sorry.
On the vote? Yes, so Madame Latenzio? Mr. Housefather?
Against.
Madame Delin? Mr. Chang?
Against.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Lawton?
Yes.
Mr. Gill?
Yes.
Mr. Fortin?
No.
Defeated 5-4.
Okay, so
CPC 7.
CPC 7, which is Mr. Brock this time, I believe, yeah.
Oh,
Yeah, CPC 7.
okay, thank you, Chair. Yeah, so the majority, if not all of us at this committee are lawyers. We can all think back to first-year law when we took statutory interpretation, and the overriding rationale that I remember so long ago, several decades ago, was to always seek clarity when drafting laws. And it's no more important when it comes to the Criminal Code of Canada. In my view, after some almost 2 decades of prosecuting and about 14 years of defending, as the criminal code currently exists, there are so many areas that really require significant editing. So what I bring to the table as a parliamentarian now is the ability to ensure that there are no gray areas when it comes to statute interpretation, that we strive and we look at the criminal code in terms of what's black and what's white. And what is existing right now in C9, specifically subparagraph 2.2 sub C, as worded, a symbol that so nearly resembles a symbol described in paragraphs A and B that is likely to be confused with that symbol. I don't know what that means. It is so vague. There is no definition section as to what a like symbol would mean. What does likely to be confused with mean? Would that be an objective standard? Would that be a subjective standard? So in terms of the rationale for the amendment that I seek, it's to seek precision, to seek clarity, and to remove that type of language goes a long way. Thank you, Chair. That's my explanation.
Thank you, Mr. Brock. More than anything, you just reminded me how old I am. Mr. Baber, over to you.
I actually remember being taught over breath It was by a former cabinet Liberal minister, Mr. Bentley. Taught me first-year criminal law, and he made the criminal law come to life, for me at least. Of course, as the chair knows, I did not become a criminal attorney, but nonetheless, I appreciate Mr. Brock's input here. So if I just look at the section, and if we could please read it, and if I could please ask my Liberal colleagues to look at subsection C, which is what Mr. Brock's amendment is targeting. A symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be confused with that symbol. So my point is very simple. If it can be confused, then it should not be criminal. I'd like to offer an example. Some folks might say that if you take out the language inside the Canadian Tire triangle, it might resemble a symbol used by the Hamas terrorist organization. They sometimes use a triangle to indicate who the next target ought to be. God forbid. I would say I could probably get around that because that might be incitement to violence, right? Mr. Housefather, ironically, you could probably say that the Hamas triangle is incitement to violence. But I don't want to be watching a Christmas commercial for Canadian Tire thinking that it might be confused with a Hamas triangle. So may I suggest this amendment is really made in good faith to try and not be overbroad. And again, if it is likely to be confused with the actual symbol, then the word confused in and of itself should allow, not only is it confusing, it should allow for some degree of latitude and not be criminal. And also, maybe we ought to think about some first principles, as Labor Minister Bentley would probably say. We're talking about criminal conduct. And we should be very, very clear not to criminalize conduct unless it is clear that it's criminal conduct. Thank you.
Thank you, Mr. Paver. Anybody, Mr. Housefather?
Thank you, Mr. Chair. I appreciate that, and I appreciate these last two conservative amendments, which I think have been made in very good faith. The first one, just to be clear, Mr. Chair, we had no testimony to the effect that the hammer and sickle should be included, and there's a number of others, like the Ku Klux Klan symbol. I think this has to go to thought process to add other symbols rather than just pick one and not another. So that's why I voted against that one. This one, I think, is much more compelling in terms of a discussion about it. My issue is that I think what this is trying to achieve is the opposite. I think what this is trying to achieve is that there is a terrorist group, they have their symbol, and then they manufacture, because they know that the law has prohibited the display of the symbol, they themselves distort the symbol by one tiny iota so they can argue it wasn't the symbol. And the point of, I believe, this section is to capture that. And so I would like to ask the officials who are here, presumably this was drafted by the Department of Justice, can you explain what the intention is of this section?
Please go ahead.
Thank you for the question. And so, yes, confirming that the intention really is to capture symbols that are defined in paragraph A and B. So symbols principally used by or associated with a listed entity, or the Nazi Heckenkreuz or Nazi Doppelsinger-Rune. If there's a slight modification, for example, if the flag of a terrorist entity is a different color background, that if it's displayed for the the purpose of promoting hatred against an identifiable group, well, they're not precluded from using that offense to prosecute. So it's really on a technical basis, not excluding symbols that willfully promote hatred.
Sure, and then I'll give the floor to
Just to clarify then, the goal of the way that this is worded by our experts, presumably at the Department of Justice, is not to catch a different symbol that is not included in A and B. It is to take only the symbols in A and B where there is a deliberate attempt to distort that symbol in order to avoid or circumvent the law by the person using that symbol. It is not to catch a symbol inadvertently. Is that correct?
So, sorry, that is correct. It is to capture slight variations, modifications, where otherwise that symbol, it presupposes the definition of the symbols in paragraph A and B. It doesn't create new symbols. Is that helpful? Does that respond to the question?
Yes, thank you very much.
You done, Mr. Housefather?
Yes, thank you. I got my answers.
A little bit so I can see. Thank you, Ms. Breeze, for that explanation. I don't know if it satisfies my concerns. I know that maybe Mr. Housefather is concerned, but the way that you responded to his latter question about the slight modification, did you ever give some consideration to using that language, a slight or some type of modification to an existing symbol, as opposed, which I think is more specific, which as a prosecutor might assist me in making an argument to a judge. If I were a judge, may give me some comfort in knowing that it's a different standard that I'm applying by taking a look at the real symbol, taking a look at the closely resembled symbol to see whether there was a slight modification. I think that language might be better used than the language that so nearly resembles, which I think opens up such a gray area that would there be a prosecution, I can see most cases being dismissed, even on the WD standard that judges would apply in this particular case. It would leave them with a reasonable doubt, not understanding and not appreciating a subjective analysis to that type of symbol versus an objective analysis. So I'm wondering, would you be amenable to tightening up the language to make it a little more specific for prosecutors and to assist judges in adjudicating?
So thank you for the comments. I believe that's really a policy decision, and that's not something I can speak to. With respect to the drafting of this provision, as you pointed out, the objective that you spoke to, it using the words nearly resemble in conjunction with, could be confused with, is how the guidance provided in this legislation to narrow down the type of symbols that would be captured. So that was the policy intent and the legal effect of that provision.
Are you done, Mr. Brock?
Yes.
Only Mr. Baber had his hand up, that's all.
So first to Mr. Housefather's point, I think the real issue here, and this is also to Ms. Breeze, is the intent of the display. You might nearly resemble and not be exactly right, especially if you draw it and you're not good at it, and it'd be slightly off, but if the intent is a terrorist symbol, as we prescribe in this section, then it would be caught and be indeed criminal conduct, right? That's the point I'm making, is that you don't need to be concerned with the fact that someone made a slight alteration. You could think of an ISIS flag. A very good example is the ISIS flag. There are many variations of it, depending on where you're situated geographically. Some versions of an ISIS flag have more letters than others. At the same time, I think that if you're a law enforcement professional, you look at an ISIS flag and you are probably, and you know if it's an, well, I would hope that you'd know that it's an ISIS flag or not. So I'm not concerned with not being precise because it goes to intent. Whereas what this section is really doing, I think, is precisely what we're hoping, what this section hopes not to do, which is potentially criminalize behavior by inadvertence. Because what might happen here is you make, if the intent is not there, but to draw something else, then you're now criminalizing non-criminal behavior. I think I'm right on this. Ms. Brees, what do you think about what I just said?
Please go ahead.
I think you described well how a symbol is used within the hate propaganda offense, that it is the intent to promote hatred, so the public display of the symbol to promote hatred. I would, the reading of the offense, again, it would not expand the type of symbols captured. It would just specify, so that, I guess another way of seeing it would be that police officers on the ground would have to know with great precision that the symbols are caught by paragraph A and B. And if they get that wrong, then they are precluded from, charges or that going forward through prosecution. So that's the inverse, is that the question to the committee would be, do you want that great precision to be on law enforcement? Oh, sorry.
No, it's okay. So to your point, the problem is the word confused. If you listen to what Ms. Brees just said, and I kindly ask my Liberal colleagues to please bear with me, if I may. The problem is the word confused. What Ms. Brees is really saying, if you look at the section, if I could just redraft the section, is I would say a symbol that so nearly resembles a symbol described in paragraph A or B, that it is likely to be that symbol. That's what Ms. Brees is saying the section tries to accomplish. It so nearly resembles that it is meant to be that symbol, as opposed to be confused with that symbol. I'm right on this one.
Thank you, Mr. Bauer. Mr. Brock?
My colleague, Mr. Baber, is very confident in his legal understanding of statute interpretation. So to all the officials that are here, were any of you responsible for this final wording in sub C? Did you draft it? Did anyone draft that?
We did participate in the drafting. Sorry, Mr. Chair, if I may. Yes.
You did participate in the drafting?
Yes, that's one of our roles as Policy Council, is to work with our legislative drafters to put the minister's policy into legislative text.
So circling back to your latter comment about if there were amendments to the language, that would be a policy decision. So are you not policy decision makers at the Department of Justice, or are you just responsible for drafting legislation?
We provide advice to the minister, who gives policy direction, and then we put that into play.
Okay. So what was the genesis then of that particular clause? Did you consult with legal stakeholders? Did you consult with judiciary? Did you consult with academics, law professors, anything like that? Did it come from specific ethnic minorities? Were you persuaded one way or the other in terms of the language to be used? I'd be very interested in your response.
I can speak to this one again. And I understand the concern is specifically targeted to this particular provision. This was a provision that was developed, as Ms. Brees said, to try to close what was thought to be a risk of a loophole that could be created in the offense. Generally, we don't consult on the specific wording. in a type of offense like this, although I know there were broad consultations on the broader policy objective of Bill C-9.
So what real-world examples can you give me that would support the inclusion of this clause that came from law enforcement saying we are missing an important tool in our toolbox to tackle individuals who are demonstrating on our streets, harassing religious members of communities where they're demonstrating and they're using symbols, but we don't know whether it's an exact replica of something that is within the regs or whether there's been a slight modification. Did you get specific input, and do you have examples of cases where police officers were presented, should I or shouldn't I charge? And if they said, I can't charge because I'm missing a tool in my toolbox, is this designed to remedy that?
So thank you for the question. In terms of hearing feedback, generally feedback we have received is that police officers are looking for clear tools to address this type of conduct. A red line as to what type of symbols, for example, could be captured by this type of offense. In terms of examples of how this could materialize, again, if we take the Hezbollah flag or Hamas flag and say it were the background color were changed, and then that flag was being waved in a public place, and the person waving it was also chanting slogans that directly targeted an identifiable group. So,
but
if
wouldn't there be
oh.
criminal laws already in the books to address that particular example you just gave, an incitement to hatred?
So perhaps I could just finish this one first. So if there's a more limited definition of the symbols to A and B, then this offense would be precluded. However, to your point, there are other tools in the criminal code, other hate propaganda offenses that could potentially apply depending on the case at hand. Communicated statements for the purpose of 319 offenses include visible representations and signs.
See, here's the problem. And what I'm about to say to you right now is certainly not new to you, because if you've been following debate in the House, if you've been following debate here in this particular committee, we would love to completely reject every aspect of Bill C-9. It is a flawed piece of legislation because there are existing laws already that deal with the multitude of disturbances that we have seen over the last 2 years. So it's not an issue of a want of criminal legislation, specific tools for law enforcement. There's a lack of will from law enforcement. I have gone on a tour. I'm still touring across the country, talking to stakeholders. I'm absolutely just surprised and stunned at the number of examples of lawlessness on the streets where police have been directly told by their municipal leaders to abandon their number one sworn responsibility, that is to uphold our laws, to enforce our laws, and simply to be peacekeepers. And I'm not going to identify the city because I'm not going to out the police service, but I had spoken to a number of Jewish leaders in this particular community, and they explained to me example after example after example of protesters, pro-Palestinian, pro-Hamas protesters, specifically spitting on Jewish individuals who simply wanted to attend their synagogue, right in the presence of police officers. that's intimidation, that's assault. They've got the tools. They're not enforcing. So I really, and I appreciate your explanation. You've given me some hope that you have done your due diligence, and I would never accuse you of not exercising due diligence. This is a touchy area, but I'm just concerned that the police asking for more and more provisions to deal with thorny issues may not ultimately achieve what you're hoping to achieve, what this Liberal government hopes to achieve when we have a lack of will to enforce. The fact that we had demonstrations lasting 2 years in our country is absolutely pathetic, and it put this country in a real difficult position on the world stage. I've read and watched news reports from all over the world, and the ability for government leaders and law enforcement to take immediate concrete steps to deal with this lawlessness is something this country did not do, and it's shameful. And I'm disgusted as being a former member of the legal community that this happened in my country. So that's what I'm concerned about. If you give a provision, a new tool to law enforcement that I think is still wrought with confusion, is it up to police now to determine whether or not this is clearly in line with a symbol that falls within the regulation? Or something that closely resembles and that is confusing. I can see so many red flags in the mind of a young police officer, and despite leadership saying we want this, I don't think it's going to have the desired impact. All the more reason, in my view, to always seek clarity and precision and to strive for black and white language when we're dealing with anything in the Criminal Code of Canada. And I appreciate all of your responses, but I'm still not satisfied this is going to address the issues that present itself. Thank you, Chair.
Thank you, Mr. Brock. I've got Mr. Lawton and then Ms. Latanzio.
Thank you. So to the officials, we know that I want to, excuse me, I want to make this less abstract for the time being, because we know in the context of the last 2 years, there have been a number of protests on Middle Eastern politics in communities across the country. Let's say a listed terrorist entity claims as a symbol the keffiyeh, and this becomes a symbol that's very associated with a listed entity. Would a keffiyeh be viewed, or could it be viewed under this legislation as a hate symbol?
So thank you for your question. Taking a step back, we'd have to look back on, it's always a factual analysis, correct? And so the test here established in the provision would be, is it principally used or associated with? And so that would be, again, showing there had to be a close nexus between the group, the listed group, and the symbol. I can't provide a response as to yes or no whether that symbol would be associated. It really is a determination, again, for law enforcement based on available evidence, and I think that's as far as I can take it.
But by your answer, you're now saying that there would be a gray area where that could be. Because you can't say no, you're basically saying that a keffiyeh could be under this hate symbol if there was a listed entity that had associated itself with that symbol.
So if, based on available evidence, the facts at hand, it would be demonstrated that that symbol is principally used by and associated with the listed entity, and that's only a determination that can be made by law enforcement and prosecutors after a full investigation. Perhaps, but it's not a symbol. I cannot say today whether factually that is principally used by or associated with illicit entity. That nexus is a factual determination.
Iran has been acknowledged as a state sponsor of terror. Could waving an Iranian flag attract the same scrutiny? Could it be viewed as a hate symbol? Sorry, that was to the officials.
Can you repeat the question? Sorry.
Yeah, so Iran has been acknowledged as a state sponsor of terror. Could an Iranian flag be captured by this definition as a hate symbol?
So Iran is not a listed entity under the terrorism listing regime under the criminal code.
So when we talk about like symbols, and I realize we are discussing one particular amendment here, but we have to look at various points C9 in its totality. So if you'll indulge me, Chair, I do have to ask about other parts of the bill here, such as
Can I just
attorney.
interrupt you for 1 sec? There's a lot of conversations going on around the room, so I'm having trouble hearing Mr. Lawton and the witness, so if people don't mind. Go ahead, Mr. Lawton, sorry.
Okay, just come back.
So, sorry, we have to look at other aspects of Bill C9 here, in particular the removal or potential removal of Attorney General consent for laying charges. And the reason I bring that up is because you, in your previous answer, Ms. Breeze, mentioned law enforcement discretion as being a key part of this. So how do we, and if this falls outside of what the Department of Justice is able to comment on, I understand, but how do we expect law enforcement to make these calls? Sometimes this comes down to, as Mr. Baber alluded to, nuances in the Arabic language that might not be known. Sometimes it comes down to, very technical details. In some cases, there is complexity to what is on the list of terror entities in the first place. So I'm just wondering if you could explain how these things would intersect with this section, and with that in mind, why we're talking about trying to remove ambiguity here.
Thank you for the question. So, caveating, this is not my expertise. I'm not in law enforcement. But we would assume that police have tools. They have training to be able to identify. You have special counterterrorism units, for example. And so there are tools, even publicly available, databases of symbols. So, again, relying on that expertise of the police, their tools, their knowledge, this is how that factual determination would be made. And I would also like to always bring it back to whatever the symbol is. If you've established that the symbol meets the definition in the offense, again, it all has to be considered within the broader offense. Again, the willful promotion of hatred against an identifiable group.
So we heard testimony from, I can't recall her names precisely, but it was a lawyer with the Canadian Civil Liberties Association, in which she posited that this section, unamended, basically amounts to a strict liability offense, where the act of displaying the symbol itself, irrespective of motive, is going to be an offense. And I just want to, for clarity here, I'll read the section in question here. We are talking about page 2, lines, so page 1. Everyone commits an offense who willfully promotes hatred against any identifiable group by displaying in any public place. Now, the Canadian Civil Liberties Association's position on this was that the wording of this suggests that by displaying, that is in and of itself sufficient to say that hatred is being willfully promoted. What is your view on that?
Thanks for the question. I would respectfully disagree. I think it's quite clear that this offense, which, as you will see how it's structured, resembles the existing willful promotion offense. The display of the symbol, it's to be understood within the broader context of someone who is intentionally, willfully promoting hatred against an identifiable group by displaying the symbol. That displaying of the symbol is the communication. So it is not a straight ban on symbols, nor is it criminalizing the mere display of symbols.
My last question, did you or anyone in your department advise the government for or against the section that Mr. Brock's amendment seeks to remove, specifically the wording of resembles a symbol? Did you advise for or against that in your counsel to the minister?
So our role is always to advise the minister on the criminal law and Bill C-9 as it goes through the parliamentary process. And so within that ambit, we continue to provide advice on all matters related to the bill.
So, sorry, are you claiming or disclaiming responsibility for that wording? You can blame the minister.
If I may.
I won't hold it against you.
What I will say what I will say is that our role is to provide advice to the minister on issues related to criminal law. The content of that advice is subject to solicitor-client privilege, and so we're not able to be more specific in communicating the advice that we do or do not give.
You are paid by Canadian taxpayers, correct?
We are.
Okay. Thank you.
Thank you. Ms. Latanzio?
Yeah, Mr. Chair. We heard testimony here at committee, including the Edmonton Police Service, and I just want to put it on record just so that it's clear for everybody. And I looked up their testimony when they came before us and their take on this whole issue of symbols. So, and I quote, "The EPS also supports the additional offense of willful promotion of hatred against an identifiable group by displaying certain specific symbols like the swastika, the SS bolt, or symbols of listed terrorist entities. This section clarifies these types of symbols, but also reiterates the requirement that police establish that a suspect was willfully promoting hatred against an identifiable group in public." So I just want that to be on the record, that the Edmonton police force was very much in favor of this whole section in terms of symbols. That's it. Thank you.
Thank you, Ms. Latanzio. Anybody else on this, on Mr. Brock's CPC 7? No? Okay, so shall CPC 7 carry?
Madame Latanzio?
Against.
Monsieur Housefather? Madame Dillon?
No.
Mr. Chang?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Mr. Fortin?
No.
Defeated 5-4.
Okay. Thank you. Defeated. Okay, so now we are moving. Yeah, Mr. Faber?
Thank you, Mr. Chair. I'd like to move an amendment to the same section, specifically amending Clause 4 on page 2, line 6 only, by deleting the words "confused with that symbol" and substituting the words "a symbol described in A or B."
Can you read out the whole section, the amended
Yeah,
section?
so the amended section will be a symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be a symbol described in A or B.
Okay. Does everybody understand that? Mr. Fortin?
No.
Translate.
I agree.
Chair, can we just have it done in French and in English so that everybody can appreciate the amendment on the floor?
Okay, so what do
Point of
we...
order.
Sorry, was it Mr. Lawton?
Sorry, I don't believe that Ms. Latanzio heard Monsieur Fortin, but he said he agrees with it. So I believe he understands it.
All right, well, she's entitled to make the request.
No, I
on
know.
her
I
own
just
behalf.
didn't believe she heard that, Chair. That was,
Okay,
yeah.
fair enough, okay.
So
Okay.
suspend for a couple of minutes?
I was just going to say, why don't we suspend for a moment, yeah.
So, one second. We don't need to, I would propose not to suspend if there is a will on the part of the committee to stand my amendment down and to come back to it. It just, I'm in for a technical problem in that once we move past this clause, I'm unable to, which is why the time is urgent, but I don't want to hold up the committee.
Why don't we just suspend for a few minutes just to clarify this, and we'll come back.
Okay.
All right, so suspended. Yes, go ahead, Mr. Pepper.
Could I please ask the clerk to read? We had a further revised change to the initially proposed amendment, so the amendment has been unofficially amended. If we could please hear the new version and also in French.
You took the words right out of my mouth.
Thank you.
Thank you, Mr. Chair. I will read the paragraph C. A symbol that so nearly resembles a symbol described in paragraph A or B that it is likely to be a symbol described in paragraph A or B. En français, ça fait un symbole à ce point semblable.
A symbol similar to those described at paragraph A or B, similar to one of those symbols described in paragraphs A or B.
I appreciate an opportunity to weigh into this, and I appreciate the fact that the committee is entertaining this amendment at this time. I am very concerned with the voting down of the Brock amendment that Clause C will remain in its present form and will therefore criminalize, should this legislation pass, a symbol that so nearly resembles a criminal symbol that it is likely to be confused with that symbol. What that will do is it will confuse law enforcement, confuse lawyers, and also potentially get someone who did not mean to display a symbol referred to in paragraph A or B, but did so, and that depiction was confused with a symbol in A and B, and you have a otherwise innocent person charged with a criminal offense. I am mindful of the fact that, intent probably factors into this a little bit, so there may be some grace, but if I may, I referred to the previous Liberal minister who taught me criminal law. I'm reminded of Professor Graham at the University of Western Ontario, one of the leading jurists in our country on statutory interpretation. And I remember first week of school, first week of statutory interpretation, he told us about the mushroom case. And I apologize that I'm unable to cite the name of the case, but the proposition was simple. He asked, is mushroom a vegetable? And he said, well, look, I have a lot of experience ordering vegetarian pizza, and when I want a veggie pizza, I get mushrooms on it, so I would think that mushrooms are a vegetable. Well, the issue became prevalent vis-a-vis the question of whether mushroom growers ought to be paid minimum wage. And the case turned on the fact that if they are vegetable growers, then employers would be exempt from paying minimum wage as prescribed for vegetable growers. And if they're not vegetable growers, then there would be a mandate to pay them minimum wage. Mr. Housefather seems to think he might recall what I'm referring to. And so the case turned on the fact, the statutory interpretation turned on the fact that, well, we know that mushrooms are not really vegetable, they're fungi. But mushrooms were grown inside greenhouses as opposed to, outdoors, because those were commercial mushrooms. And as a result, the court asked, what is the intention behind the legislation? And that is, well, sometimes due to weather elements or the industrial carbon tax, the cost of mushrooms might be very prohibitive. But when you have all sorts of weather events, you might lose your crop. And so growers would be given some latitude not to pay minimum wage. However, because mushrooms are grown in greenhouses, then the grower doesn't have that problem. The mushrooms are not subjected to the elements. And as a result, the annual crop would come in and the grower would sell his mushrooms. And so there would be no need to exempt the mushroom grower from the application of the minimum wage. And so the question is, are mushrooms vegetables? The answer was, look at the intent of the legislation. The intent of the legislation is to exempt those that are risking losing their crops. The mushroom grower will not, because it's in a greenhouse, and as such, there is no need to exempt them from the application of the minimum wage, and not even answer the question of whether mushrooms are vegetables. So, in that spirit, I appreciate the latitude and the accommodation. I think it's very important that the intent of this legislation is clear. We, conservatives, tend to err on the side of caution, not only when we talk about moving issues that might be transformational without thinking it through, but we want to be very conservative in the application of criminal law because we preserve charter values, we preserve the presumption of innocence, and we certainly don't want a law that would be overbroad. As presently outlined, the law might criminalize conduct that it doesn't mean to criminalize. That is why my proposal that the conduct that the symbol displayed need to be so nearly resembling a symbol in paragraph A or B that it is likely to be the actual symbol referred to in A and B eliminates that ambiguity and therefore I think accomplishes what this section intends to accomplish. I'm grateful to everyone on this committee for entertaining this seemingly small change. I think it might actually save law enforcement a lot of time, but deny criminal lawyers an ability to argue the statutory interpretation of what this committee has otherwise intended. Thank you.
Sorry, apparently there was a slight modification to the translation.
Merci, Monsieur le Président. Simplement, je vais relire la...
Mr. Speaker, I'm going to reread the French version. We just got the translation. A symbol so similar to a symbol mentioned in paragraphs 1 and 2 to be confused.
Okay. We're good with that? Okay. Mr. Lawton, did you have your hand up? Yes. Yeah.
So just for context here, and I appreciate my lesson in statutory interpretation from my colleague, Mr. Baber. I've learned a lot, and I'm now hungry. The amendment, I think, look, it doesn't go as far as the original amendment, but the committee decided to vote against Mr. Brock's approach, and that's the way the mushroom bounces or something. But I do want to ask our officials, with the further amendment that's been put on the table, does this ameliorate your concerns that you raised in respect to the first attempt at this from Mr. Brock? No, ameliorate, mitigate. No, ameliorate.
Ameliorate.
I heard right.
We need statutory interpretation.
Concern.
See, we're all learning things today.
So I want to be helpful. When I spoke earlier, I was pointing to the policy intent and the purpose. Mindful that I can't provide advice on this amendment. Is there a specific question with respect to?
I'll rephrase it. Do you believe that the amendment that has been put forward by Mr. Baber keeps with the spirit of the policy in that section of the bill?
My mic is on. Again, I think that puts us in a bit of a difficult position to be able to respond directly to your question. It is certainly if it's up to if the committee thinks that that amendment is consistent with the policy intent of the bill, then we would invite you to proceed with your meeting. I think we were clear, and Ms. Breeze was clear as to the original policy intent of the language. This would maybe narrow it slightly, but the provision would remain on the books to provide maybe some support to Crown prosecutors and police who are looking for guidance on what symbols would fall under the offense.
Okay, I don't want to do the thing that I'm sure frustrates people. So what you're saying is, because I legitimately do not want to put words in your mouth, but would you view this amendment as diverging from the policy intention and the legislative goal of the section as it is? Because that's really what I'm asking here, is do you believe that this amendment is fundamentally altering the policy direction? So do you think this is a divergence from the intention that you and or the Minister of Justice had when drafting this section?
Again, trying to be helpful, I think the question is it the committee's intent that it change the policy which the department has shared at the outset?
Sorry, I don't mean to cut you off. I'm trying to not put you into that realm. I'm trying to ask, let's go back to first principles here. What is the policy intention of that particular section?
This was your...
What is the direction that your department was given that led to that?
Perhaps what I can do is just speak to technically what this amendment would do, as opposed to the policy intent behind the amendment that is being proposed.
Sure.
So if I were to read, for example, described A or B, that is a symbol, that is likely to be a symbol as described in A or B, I believe is, did I get that correctly?
Yes, that is likely to be a symbol as described in A and B.
So is likely to be a symbol in A and B would, at first glance, appear to mean the symbol described in A or B.
Mm-hmm.
So there's not, une marge de différence, I don't know how to say, between C. So you're basically, C would capture a symbol that resembles, that is a symbol that resembles A and B, and that is likely to be A and B. So again, there's not much difference, I would say, between A, B, and C. That's plain reading.
Realizing you are not in law enforcement, but if this were to come before a courtroom that you were working in, would you view this as being an amendment that provides greater clarity in how to interpret that offense?
I think I'm delving beyond my role as a technical expert in that type of question. What I can speak to, again, is the technical aspects, which I've just done. And if that is the committee's desired intent, interpretation, then I think that the committee would be best able to respond to whether that empowers law enforcement to better understand the provision.
Okay. Thank you.
Okay, Mr. Lawton, you're done? Mr. Brock?
I'm moving a sub-amendment to my colleague, Mr. Baber's amendment. I do this not out of disrespect to Mr. Baber. We're trying to come up with a solution here that will satisfy everyone at this particular committee and also addresses the overall concerns that I had at the outset in terms of my original amendment that was voted down. And I also appreciate the input from both Ms. Wells and Ms. Breeze. And I hope you are not concerned about us questioning you. I appreciate you can't give us legal advice. You can't provide us with a legal opinion. You are here to help. But what I'm picking up when I read between the lines is some degree of hesitation. I don't think you would support or not support a potential amendment. It's to the will of the committee. So I think there is a compromise here, and I wish everybody would pay attention and to hear me out on this. I propose that we take the existing language in sub C to now read a symbol that so nearly resembles a symbol described in paragraph A or B, period. No further explanation beyond that. And I think that provides a very clear direction to law enforcement. We still get into interpretation issues if this were a trial in terms of a subjective or objective analysis, but we don't have to worry about that. That's for a different day and a different discussion. But I think it clarifies your concerns, Ms. Breeze, that the amendment brought by Mr. Baber may be more confusing than clearer. So that would be my sub-amendment, and I don't have it drafted, but I can certainly do that when the bells are ringing. I understand that we are not providing unanimous consent. I think there's a will of both the Liberal team and the Conservative team to actually attend back at the House for the purposes of voting, and in the interim, I can actually draft this in both official languages.
Mr. Housefather?
I suppose that is not a sub-amendment that would be receivable on Mr. Baber's motion, which substituted words. Now you'd be cutting off the entire sentence that Mr. Baber had substituted. So I don't believe that's a proper sub-amendment on Mr. Baber's motion. I'd ask you to rule that way, Chair. I'm right on that.
All right. Okay, so the bells are ringing. Yeah, the bells are ringing. So we are going to suspend. Hopefully somebody's going to listen to me here. Mr. Baber, please. The bells are ringing. We're going to suspend. I think I have a solution that I might get us through this, which we can do during the break. But so we'll suspend till after the votes and ask everybody to be here 15 minutes after the last vote. Okay? Meeting suspended.
The tally of the vote is declared. Not after the last vote. After
Well,
the
if you want to get out of your chair, before it's, that's fine. Yeah,
No,
go ahead.
100%.
By all means. All right. Meeting suspended. order, please. Mr. Brock, yes?
Yes, just on a, you can either call it a point of order or just seeking clarification in terms of timing. I know that we have resources today until 11:30. I also heard from a reliable source that you plan on sitting tomorrow. I'd like you to confirm that, the time that we're going to start, the time that we're going to finish. I also heard from that reliable source that there'll be a full sitting on Thursday, starting as early as 8:30 in the morning and concluding at midnight. I'd like clarification of that, as well as sitting this Friday. I wasn't aware of the start time or the concluding time, but we all have other commitments outside of this committee room. Not only with respect to our commitments to our party, but our commitments to the riding. And obviously, travel arrangements will need to be adjusted if that, in fact, is accurate.
Your sources are better than mine, clearly. We have asked for additional.
There are worse.
Again, it's interpretation. But fair comment. We've asked for additional resources. I don't know where we've landed on it, but I'll give you an answer by the end of the meeting. Look, I have commitments too. We all have commitments, and I'm going to try to accommodate all of that. But it just reinforces the urgency. You know, the sooner we get this thing done, we can avoid all those problems if necessary. You know, so but I will find out where things stand as the meeting progresses, because we do have some time this evening to sort that out. And good news for members, there's more food on the way too. So, okay, so it brings us back to the meeting. When we left off, Mr. Barber, I think you had proposed an amendment, but Mr. Brock was on the verge of proposing a sub-amendment. So where are we on that?
I don't know if the sub-amendment is properly before this committee. I had the impression it was not. If it is, I'm prepared to withdraw the sub-amendment in its entirety and proceed with Mr. Baber's amendment.
Okay, so my understanding is it is not appropriate. But so there's two ways to proceed. You can either, Mr. Baber can withdraw his, you can introduce yours, or we can vote on Mr. Baber's, and then it's up to you what you do with yours, depending on the outcome of that. Okay, so are you not proceeding with your sub-amendment?
No.
Okay, all right. So we're on Mr. Baber's amendment. Does anybody want to speak to that before we move to a vote? Okay, so we're going to go to a vote on Mr. Baber's amendment.
Okay. On Mr. Baber's amendment, Madame Latanzio?
In favor.
Monsieur Housefather?
In favor.
Madame Dillon?
Oui.
Mr. Chang?
In favor.
Mr. Brock?
In favor.
Mr. Baber?
Yes.
Mr. Lawton?
Oui.
Mr. Gill?
Yes.
Mr. Fortin? Unanimous.
Okay. Amendment carried. Okay, which takes us then to new Liberal Amendment 2. And just to clarify that, if you recall last time there was some issue with page numbering. It was on, Liberal Amendment 2 was originally on page 11. It's now on page 12, and the reference is 137848838. And I'll turn the floor over to Mr. Housefather.
So, Mr. Chair, what I would ask to do, because these were discussed in the same context as Mr. Baber's CPC 1, 2, 3, and 4, and we parked those until the end, I would like to do the same and park this to be discussed in conjunction with Mr. Baber's amendments.
Okay, I'm told that that would require also parking, to use your language, other proposed amendments, and we'd have to move to clause.
That wouldn't make sense, but could I just, Mr. Chair, with respect, can I just understand that because there is no line conflict with my amendment, Lib 2, and any other amendments? It's simply language to be inserted after something. So there should be no reason that it would prejudice any other amendment from moving forward. The only thing that wouldn't be able to move forward is a vote on all of Clause 4. That would have to then wait until my amendment was heard. But there would be no line conflict, and it should not preclude any other amendment from going forward. I'd ask you to re-review that with the legislative clerk.
There's uncertainty, Mr. Housefather. I mean, we can move forward to clause 5 and then go back to it.
I don't think that was...
Or we can proceed and address any problem that arises as a result.
I would like to understand again, Mr. Chair.
Yep.
There are other amendments to Clause 4 that are not a line conflict with Lib 2. Why could those amendments not be dealt with in their proper order and park Lib 2 until the end and simply not vote on the entirety of Clause 4 until we come back to Lib 2 and Mr. Baber's amendments? That's all I'm asking.
Okay, we're going to suspend for just a couple minutes to get clarity, okay?
Thank you so much, Mr. Chair.
Mr. Housefather?
Thank you, Mr. Chair. Thank you, committee members, for this indulgence. I was hoping to have more discussions about this. Basically, you'll remember the last meeting where we had talked about the willful promotion of terrorism, and I strongly agree with Mr. Baber that this should be in the criminal code. And he had presented where amendments where this clause really should be, which is the terrorism section, but I don't feel that it was something that would be receivable in light of this bill, and I think it would have to be withdrawn, and I had other issues with it. So I put forward my own that would be in the hate section, where it was proper, but it's sort of like putting a round peg in a square hole. So I had some discussions with the Minister of Justice, and I'd just like to read his letter to me, because he said I could share it with the committee. So it's, Dear Anthony, thank you again for the thoughtful way you've engaged with Bill C-9. I appreciate your willingness to work with us in what has been an understandably intense and emotional debate. I share your concern about the glorification of listed terror entities in Canada, and I agree with you that the status quo is not good enough. I am committed to a serious, focused examination of how Canadian law should better address the glorification of terrorism. As the amendments proposed were not in the initial text of the bill or previously consulted on, I would appreciate more time to properly consult and to respond. Thank you again for your leadership on these issues and for your collaboration as we work to get Bill C-9 right and to address the broader legal gaps you have identified. Please feel free to share my request with the committee if desired. So this is the last that I have from the Attorney General and Minister of Justice, and as this is the last that I have, out of courtesy to him, I will not put forward the amendment. I will give him the space and the latitude to come forward with a consultation and then hopefully a legislative fix that which I would hope would arrive before Mr. Baber's private member bill, but if not, then I will be supporting moving Mr. Baber's private member bill to the House. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Okay, so. Oh, sorry, Mr. Baber.
I appreciate the predicament that Mr. Housefather is in. We currently have a situation where there's desire for a comparable piece of legislation on each side of the aisle. It's a rare occurrence in this place. And it's the right policy at the right time. So I understand that we have a process issue here that we can't get around. I anticipate that the Conservatives will put a motion to expand the scope at some point of this bill to try and accomplish the ability to pass Baber CPC amendments 1 through 4 and therefore have it placed correctly within the terrorism section of the criminal code. And I hope that there will be consensus from the other side to this. I appreciate your comments and your effort, Mr. Housefather, very much.
All right, thank you both. So that takes us then to BQ3, which I will now turn the floor over to Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Chair, Bill C-9 is meant to help in the fight against hate. And this is a fight that I am entirely for. Now, there is already a provision in the criminal code which talks about fighting hate crime. 317, Section 317 of the criminal code would create an offense for someone who would encourage hatred or anti-Semitism. It says both hate and anti-Semitism. Well, the thing with 317 is there is an exemption. There is a defense which is stated that no one can be considered guilty of an offense under this subsection A, B, C, and D. And if we go further, it says one can, in good faith, express an opinion on a religious belief. The problem with this particular defense, Mr. Chair, is that it creates a situation in which someone can commit actions or say things which would otherwise be forbidden under the criminal code, but which could be considered not forbidden if they're based on a religious text. For us, this is an exemption which should have no place in our judicial system, in our legal system. Now, there's something that's happened a few times that I've mentioned a few times, but I think it merits repeating, and that was the example last year of a Mr. Charaqui, a preacher who, in public, before people who were listening to him, said or cried out, Allah, Allah. He said, the enemies of Gaza, let us exterminate them. Now, we expected this person to be prosecuted, but he was not. And we suspect that the Attorney General, when he read Section 317, felt that this person would have a defense based on this clause. That is Section 317 of the Criminal Code. Now, if Bill C-9 is to truly fight hate crime, we have to remove this religious exemption. The amendment says that Bill C-9 at Section 4 be amended by adding after line 12 on page 2 the following: 1.1, paragraph 319(3)(b) of the Act is repealed. This is the paragraph that allows for a religious exemption. And 1.2, paragraph 319(3.1)(b) of the Act is repealed. And in that particular case, this is where the exemption, the religious exemption could be used as a defense for those fomenting anti-Semitism and Holocaust denial. And then B, by replacing line 19 on page 2 with the following: and it says no one can be found guilty of the no person shall be convicted of an offense under subsection 2.2 if the display of the symbol is for a legitimate purpose, including a legitimate purpose related to journalism, religion, education, and that is not contrary to the public interest. So this defense could be a defense for something which would otherwise be a criminal offense. If the symbol is used for journalism, education, or the arts, or for a something linked to religion, I think if we really want to fight hate, well, hate is something that is detestable. It's something we want to eradicate from our society. And the criminal code, when it puts forward things that should be forbidden in order to fight this, it can't allow defenses under under the guise of religion. Whatever the religious text, it could be the Bible, the Quran, the Torah, or any other religious text, should never be interpreted as allowing hate or allowing the encouragement of hate, and allows for a defense that is connected to religion. And this leads to confusion, and it leads to an unfortunate message saying that religion can foment hate. No, neither the Catholic faith nor any other Christian faith, not the Muslim faith, not the Jewish faith. It is not indicated in any of these texts that fomenting hatred is a good thing, but not everyone reads these texts in quite the same way, and it would be harmful if we allowed it by adopting C9 so that religious texts could be interpreted in a way such that the followers of these faiths could encourage hatred or anti-Semitism. And this is why I would propose that we adopt this amendment so that we can remove this defense. And this is why we propose that this be an amendment to C9. Thank you, Mr. Chair.
So I've got Mr. Brock and Mr. Baber, but Mr. Lawton, but was that from before or was that on this?
That was on this.
Okay, so you're first and then Mr. Brock and then Mr. Baber. And then Garnet. Sorry, Mr. Janice. Sorry about that.
It was clear during some of our witness meetings on Bill C9 that an amendment of this sort was coming. We heard Monsieur Fortin ask questions about this. We heard him cite those horrific and heinous words from a man who I will not even dignify by calling a preacher, Charkaoui, in Quebec. So it was easy to suspect an amendment like this was coming. Be that as it may, this is a significant incursion on religious freedom and freedom of expression for reasons I'll share in a moment. But the fundamental point is that this committee has not studied this. This committee has had no opportunity to call witnesses with specific expertise about this. When we learned through media reporting that this amendment was coming, I took it upon myself to reach out to some of our witnesses who had testified and invite them to submit further briefs, realizing it would be too late to have them circulated on the committee, but at least so that we would have the opportunity as members to have a little bit of insight about this. But I want to share a very important timeline on this, because there was a report in the National Post, I believe 8 days ago, indicating that the Liberals and Bloc Québécois had reached a secret deal to launch this assault on religious freedom, to exchange quid pro quo adoption of Monsieur Fortin's amendment in exchange for support from the Bloc on Bill C9, a bill with tremendous flaws that has been derided by pretty much every religious group in the country, that has been derided by civil liberties advocates, and for good reason. And now we have all of these issues with Bill C9 supercharged by this amendment, should it pass, and I have little doubt that it will, given what we've heard. But what was interesting is that the Liberals seem to not be willing to stand by this. And for the past week in the House of Commons, there have been attempts to get clarity from the government on where they stand, and the Minister of Justice, who has not yet decided to appear before this committee on his mandate and priorities, coyly said the committee will decide, as though the committee does not have any direction that it is given by either the minister, by the Prime Minister, or other operatives within the Liberal apparatus here. And beyond that, we had a rather interesting turn of events where at first it was not clear there was going to be this meeting today. We only got a notice on Monday, which was for an 8-hour meeting, and then we learned that meeting had been truncated to 2 hours, which, as we've demonstrated, would not have given us enough time to get there, suggesting that the Liberals could not agree on what they were going to do on this precise amendment. And then, evidently, they got a clear direction on this, and the meeting was extended again to 8 hours, to the meeting we are finding ourselves in right now. In the time that transpired, further media reporting, citing sources in the Prime Minister's office, indicate that the Liberals intend to support this amendment. Again, teaming up with the Bloc Québécois, which I realize has a very distinct political context in Quebec that it is responding to. And I realize 3 of my Liberal colleagues hail from Quebec as well, and that I don't know to what extent that is going to influence their decision on this. But evidently, there has been no desire to listen to the concerns that have been raised by Muslims, by Christians, by Jews, by Sikhs, by Hindus, by Buddhists. There are potentially other groups that have raised concerns as well that I have not yet heard, that this will come as a direct threat to their ability to practice their faith. And when we hear the example of Charkaoui brought up, a man who prosecutors in Quebec did not claim was spared from prosecution because of anything to do with the religious defenses that this amendment would take away. And the religious defenses do not apply to any of the sections of the criminal code pertaining to incitement, pertaining to calls for genocide, pertaining to threats. When Mr. Charkaoui is talking about death to Jews, even if it was determined that it was in good faith, and no call for violence can ever be made in good faith, it would not even apply, this religious defense, to the sections of the criminal code that would have been engaged had there been political leadership, and I would say courage, by prosecutors in that case. So to invoke Charkaoui to justify eroding longstanding religious protections from law is a red herring. It is either a misrepresentation, deliberate or unintentional, I won't speculate, on what the law says. But we do know what this will mean for people of faith. Your predecessor, Mr. Chair, who's now with the Minister of Canadian Identity and Culture, sat in that very chair and said that Christians and Jews who preach from books of the Bible and the Torah that he finds hateful should be subject to prosecution. The prosecutors could, to Minister Miller, be able to, quote, press charges, unquote, for people who dare to invoke scriptures the government finds offensive. Minister Fraser earlier today issued a statement in which he tried to claim that, well, really, this isn't going to have anything to do with religious freedom. But the Liberals have not stated on record, what their position is on this. So I'm grateful that we have officials from the Department of Justice. We also have in Ms. Latanzio, a high-ranking representative of the Liberal government, the Parliamentary Secretary to the Minister of Justice. And I will ask her right now, what is the Liberal Party's position on this amendment? She's willing to answer as a representative of the government.
Well, it's not appropriate, I suppose, if Ms. Latanzio wants to, but it's outside the course of procedure, Mr. Lawton. I think you know that.
If I may, with Ms. Latanzio's consent, will you agree to speak for the government right now?
I will not speak for the government. I will speak as a member of Parliament, and I'm very much looking forward to hearing you and hearing anybody else who wants to take the floor on this issue. And when everybody will have finished speaking, including myself, I will make my decision. And you will know my decision through my vote.
So is the position of the Liberal government that they have no position on this amendment that has been responsible for canceled meetings, extended meetings, shortened meetings, 8 days since the reporting? Is the Liberal Party claiming it does not have a decision on this?
Mr. Lawton, Ms. Latanzio was kind enough to respond to you, even though she's not required to do so. She's not a witness before the committee. You have the floor. If you want to continue with your submissions, you're free to do so.
Okay.
Sure, Mr. Housefather.
I do think it is only fair to recognize that we're all individual members of the committee who all make our own decisions, and we're not here as representatives of the government. So to ask her to add is just not fair.
That's fine. I answered it. It's fine.
Respond to that point of order, Chair. The Parliamentary Secretary is literally the Minister of Justice's representative.
Not in the committee.
Parliamentary Secretary is a member of the Justice Committee for the purposes of what we're doing here today.
Yes.
So, Mr. Lawton, if you want to continue, please do so.
Okay. So I will ask some questions hypothetically through you, Chair, that it would be wonderful if the Liberal government's representative on this committee, Ms. Latanzio, would answer, which is whether the government is okay disregarding the calls that have come from Muslims, Christians, Jews, uniting all religious, observant religious members of the Abrahamic faiths and other faiths as well, who are alarmed that this will infringe on their religious freedom. I would ask the Liberal government's representative here as well about how the government squares the fact that the Supreme Court has only upheld the constitutionality of Canada's hate speech laws in the first place because of these defenses, which exist to provide for a wide array of protections, understanding the importance of religious freedom and of freedom of expression. I would hope the government, in its submissions and in its comments here, would answer the question of what precisely they think it is doing, other than alienating people of faith, to have someone who's now a minister of the Crown look to Canadians and say that they should be prosecuted if they dare express a religious belief the government finds objectionable. And I would also ask the government why it has continued to respond to these questions with silence. Silence when the media was asking, silence when members of Parliament in question period were asking, and silence now when I'm asking, and these members are curiously glued to their phones, rather than deal with the fact that they are prepared to mount, with the support of the Bloc Québécois, a full-scale assault on religious freedom in this country. We have had tens of thousands of people that have reached out to us, that have signed petitions, that have sent emails. Members of Parliament from all parties have been receiving phone calls and emails and visits to our office for days now, because this is a red line. This is the government that was not that long ago entertaining stripping charitable status away from houses of worship, and is now deciding to take away religious freedom protections in the criminal code to protect people of faith who believe in good faith in religious scriptures from prosecution. It is not only shameful that this amendment has even been considered by a government that pretends to speak for Canadians, but it is all the more shameful that the representatives of the Liberals here on this committee do not have the courage of their convictions to state on the record what they are going to do.
You finished? Okay, thank you. Mr. Brock.
Thank you, Chair. And to further my colleague, Mr. Lawton's comments, and this is, I think, a direct response to Mr. Housefather's comments that we're only members of the Justice Committee. Well, if anyone actually believes that for a second, that is just garbage. You know, they take a position based on policy and direction directly from the Prime Minister's office, directly from the Justice Minister. And to have the Parliamentary Secretary for the Minister of Justice and the Attorney General claim somehow she's immune from articulating a position is absolutely disrespectful. And it's disgusting, quite frankly, because clearly there are Liberal... I said the comments are disgusting.
Doesn't matter. It's
okay?
Indirectly, you're saying what you cannot say directly. We all know this. Yes, we all know this.
Okay?
Yeah.
I mean, Mr. Brock, in fairness, I'm not going to rule on the point of order, but we discussed decorum earlier. If we could avoid, words like that, it might not be a bad idea to make the meeting run smoothly. You can make your point without.
But in any event, we all know what the Liberal Party's position is on this. Unnamed, numerous Liberal sources have confirmed to numerous news agencies that this Liberal government was so desperate to get Bill C-9 back into the House and becoming law that they were prepared to abandon their long-held principles on this particular issue. This issue regarding the removal of the religious defense is not the first time this government has heard of it. 2 years ago, in 2023, a Bloc member, I don't believe it was my colleague, Monsieur Fortin, but another Bloc colleague brought a private member's bill that did not pass first reading because there was no support. No support in the House, no support from the Liberal government. And now we have Bill C-9, and Bill C-9 did not remove it. The Minister of Justice did not give instruction to Ms. Breeze, Ms. Wells, or Ms. Alley to draft terms that would remove that religious defense? And just because I'm surmising here, I'm going to ask the question, because this is not protected by solicitor-client privilege. Your advice back to the minister would be, and I'm not going to get there, but did Minister Fraser inform you that he wanted to remove that religious defense? Yes or no?
Mr. Chair, if I may, what I will say is Bill C-9 does not, as drafted or introduced, contain a proposal that would withdraw or
I'm aware
remove
of
the
that.
defense.
Did Minister Fraser, during the drafting of this bill, during all of your consultations, maybe not you yourself, but other members in the department, including the minister himself, perhaps even Ms. Latanzio, did anyone from a political entity, whether it's the minister or the parliamentary secretary, give you instructions to explore the possibility of removing that religious defense? Yes or no?
I think the way that I can be helpful to the committee is to clarify that both the communications that we give to the minister and the instructions that we receive from the minister are subject to solicitor-client privilege, and I am not able to share any more on this than we have already.
The instructions he gives you is not protected. So I disagree with you on that interpretation. And perhaps if the minister, who obviously is probably following this, because he had a very, very uncomfortable week in the House of Commons, flip-flopping, not being clear with Canadians, backing himself into a corner, trying to appease the Bloc Québécois, who made it abundantly clear that you pull out of this secret agreement that we had, don't expect us to support any provision of Bill C-9. And that panicked the minister. That panicked the Prime Minister. That panicked these four members of the Justice Committee. So now they're playing coy. Now we want to hear from the committee. Well, to my colleague, Mr. Lawton's point, if that was truly genuine, they wouldn't have canceled meetings where we had witnesses lined up. And perhaps we could have explored by hearing from stakeholders as to whether or not this is an appropriate removal. But that was taken away from us. That was stripped from this Justice Committee, which I find deplorable. But it's clear the Liberals will do whatever it takes to pass this, even though it was never their idea, it was never their intention 2 years ago, it was never their intention during the hearing of the numerous witnesses that we've heard, until it became abundantly clear that they would be going into a winter break without the passage of Minister Fraser's signature piece of criminal legislation, the only piece of criminal legislation that he had brought forward to be studied at committee since the election, almost 8 months ago. So I wanted to put that on the record, Chair. I also have the utmost respect for my colleague, Monsieur Fortin, and generally we align ourselves very well on legal issues, but I do take exception to his interpretation of the Chikari case out of Quebec. I believe his words were to the effect that the Crown Prosecution Service in Quebec had come to the conclusion that the religious defense would not apply in that particular case. That is wrong, and I'll get into that for a moment. But again, I also want to clarify something that I think is important. Bill C-9, as drafted, references the defenses under subsection 2.2. The language in BQ3 talks about removing religious exemptions. This is not an exemption. This is a stated legal defense. There is a difference between an exemption and a legal defense. So I think to be accurate, that our nomenclature throughout this debate, however long it may be, should be referring to the defense as opposed to exemption. Now, I have a lot of respect for the folks at the Canadian Constitution Foundation, and in particular Christine Van Gen, who wrote a piece not too long ago in the National Post when this secret deal between the Bloc and the Liberals became public by leaking Liberal sources. So I'm going to read various portions of that article into the record at this time, but I'll start off specifically about the religious defense. The title is quite interesting. Changes to Bill C-9 aren't combating hate, they're criminalizing faith. Bill C-9, the Carney government's Combating Hate Act, would expand criminal prohibitions on expression and increase penalties for speech offenses, including online speech. Now the bill may also gut the defense that protects good faith religious opinion or speech rooted in religious texts. As Mr. Lawton had indicated, throughout these hearings, Bloc MPs were fixated on this defense. Their central example, repeated to nearly every witness, was a prayer delivered by a controversial imam, Adil Charkawi, at a Quebec pro-Palestinian rally in 2023. In that prayer, he had asked God to kill the enemies of the people of Gaza and take care of the Zionist aggressors. She says, these comments were rightly condemned. They are grotesque. Complaints about them were investigated, and the RCMP prepared a report. It was reviewed by 3 Crown prosecutors who concluded that no charges were warranted. As Quebec's Director of Criminal and Penal Prosecutions put it, quote, the evidence does not establish beyond a reasonable doubt that the words spoken constitute incitement to hatred against an identifiable group, end of quote, under Section 319 of the Criminal Code. One may argue that Zionist was just code for Jews. One may also believe that praying for death is morally abhorrent, but that decision not to charge Charkawi, excuse me, turned on the basic threshold of incitement to hatred, not on the religious defense. And even if it had invoked the defense, one inflammatory prayer at a political rally is not a justification for dismantling a safeguard that protects millions of Canadians from state intrusion into matters of faith. The religious defense has also been essential to the constitutionality of the hate speech prohibition itself. We've all been talking about the Keegstra decision at numerous times throughout this particular study. The Supreme Court wrote that the offense is a minimal impairment on the right to freedom of expression, in part because of the very presence of Section 319 sub 3 defenses, which includes the religious defense. The courts upheld the law because the religious exemption exists. Remove it, and the constitutional floor collapses. But even beyond constitutional risk, removing the defense is a profound moral and civil liberty mistake. We should not want, let alone empower, prosecutors to criminalize any form of prayer. Religious texts across traditions contain pleas for justice against enemies, metaphors for divine retribution, and expressions of anguish, symbolism, and cosmic struggle. That is not the realm of police. If the state begins parsing parsing Psalms or Hadiths line by line in a courtroom, then we have forgotten why the Charter exists at all. In practice, the defense is already exceedingly narrow. It has rarely been invoked, and based on, she says, my case law search, has never succeeded. Courts have also rejected attempts to cloak hateful speech in religious example. In the case of the Court of Appeal for Ontario, Regina versus Harding, a lower court's finding that the defense does not shield speech that willfully promotes hatred merely because it is embedded with religious language, because then religious opinion could be used with impunity as a Trojan horse to carry the intended message of hate forbidden by Section 319. Religious expression is messy, symbolic, and deeply human. It concerns the nature of justice, suffering, good and evil, the most intimate dimensions of identity and conscience. These are precisely the areas where the criminal law must not trend. We do not want the government parsing religious texts or religious speech, especially given that most of our political leaders are absolutely ignorant of religion, including in some cases their own religion. For example, and Mr. Lawton got into this, in a shocking display at the Justice Committee, former Liberal Chair Mark Miller claimed to Derek Ross, Executive Director of the Christian Legal Fellowship, that portions of the Bible are hateful. Miller then doubled down on X, writing, "I say this in particular because I am a Christian," which is in itself mind-boggling. It's dangerous for politicians to believe they can use statutes to sanitize Scripture they don't even properly understand. Criminal law is the state's most violent instrument. Let that sink in. It should not be swung at the human soul. The Bible is the most banned book in history precisely because it is powerful and points to an authority beyond the reach of government. A government that fears religious speech is not fighting extremism, it's fighting competition. And what better way to summarize the actions of this Liberal government over the last long 10 years? The proposed amendment to Bill C-9 would take Canada down a dark path. We should never have criminalized belief in the first place. Strip away the religious defense, and Canada will not be combating hate. It will be criminalizing faith. The defense must be maintained.
Point of order. Mr. Fortin. Mr. Chairman, I don't know what the rules are, but can my Conservative colleague, for whom I have a great deal of respect, is going to be taking up our time, all our time? There are 4 Conservative members in principle, but now I think there are 6 here, or 7. Well, I think, apart from those 4 who sit on this committee, well, I understand that my amendment does not suit the Conservatives, but I think that a minimum of respect would be in order and would allow me to work. Thank you, Mr. Chair.
So is your objection to them sitting at the table or to the comments he was making?
Make any comments.
Mr. Fortin?
I would ask Mr. Chair if you could do what is necessary and perhaps ask our colleagues to sit somewhere else and not come and sit right here.
I mean, is there...
Is there no rule or regulation on the number of people? Because these Conservative colleagues, you know, if they all wanted to sit here, well, but Mr.
Here, but you're not obliged to sit on my files, and your colleague neither.
I think maybe Mr. Janis. Okay.
I understand, but I'm a member of the committee.
Members of Parliament are entitled to sit around this table, but I would request that those of you sitting near Mr. Fortin show him some courtesy and respect and allow him some space so that he does have room to do what he needs to do as a regular member of the committee.
If I may, Mr. Chair, because I feel like some of these comments were directed to me. I made no comments to the member. I sat down.
I don't think.
And if I might finish,
Go ahead.
as you said, members are entitled to sit here. How many spaces does my colleague need for his work? If he could establish that, this was an open chair. I don't see the problem with sitting in an open chair.
Really? That's the discussion you want to have? Okay.
I don't. I didn't raise this discussion.
Okay. I was hoping we could deal with this in a professional and courteous manner. Technically, yes, members are allowed to sit around the table. If you want to sit beside Mr. Fortin, you're free to do so. There's also chairs on the other side of the table. You're more than welcome. You're more than welcome to sit over there or sit elsewhere. All I'm asking you to do, sir, as a courtesy, be courteous to Mr. Fortin. If he needs a little bit more elbow room, we're going to be here for a long time. You can argue this nonsense.
I'm not
going to
argue it. I just reject the premise that it's being uncourteous to sit in an open chair.
I didn't suggest you were being uncourteous. I just suggested that we respect Mr. Fortin's wishes. I'm going to end it there. This conversation is ridiculous, frankly. Mr. Brock, you have the floor.
Thank you. I'm prepared to cede my time at this time, Chair.
Thank you. Which takes us to Mr. Baber.
Thank you, Chair. So now we truly get to see how terrible this bill is. Because if this is the price that the Liberals had to pay in order to get this bill passed, then they truly understand how difficult it was, and for good reason. This bill has received an extraordinary amount of attention, and it will continue to do so, particularly because of what's happening right now. I really don't get it. We had such interest in this bill. We had so many witnesses that wanted to speak to it. We had 2 meetings canceled by the Liberals in time when we could have heard from witnesses. Now, fast forward, and we're making a fundamental change to a key section of the criminal code without any testimony. Surely you can't tell me that this is appropriate process. I would ask my Liberal friends to please, let's hear from witnesses on this issue. This is a major impact on religious communities and potentially on a lot of Canadians. I want to ask my friend, Monsieur Fortin. I have developed a good working relationship with Monsieur Fortin. If I could kindly ask MP Genius to lean back. Thank you. Monsieur Fortin, I heard you say in your remarks that the reason you're bringing this amendment is because of Adil Charkawi and his pronouncements in Montreal. Did I hear you correctly?
No, I said it's an example, a good example.
It's a good example. But I would suggest to you respectfully that it's not a good example. We have, again, I very much respect your professionalism, I respect your experience, and I respect you as a lawyer. And I think we should be entitled to ask each other to be professionally frank. I'm going to refer you to a CBC article, all right? I think the other side likes the CBC. Posted on May 17th, 2024. Crown won't file charges over controversial pro-Palestinian speeches in Montreal. I will endeavor to send you a copy of this article, Mr. Fontaine. Scroll through, and the article states, the Crown said the statements analyzed must target an identifiable group as defined in Section 318, sub 4, namely, any section of the public distinguished by color, race, religion, national or ethnic origin, age, sex, sexual orientation, gender identity, or expression or mental or physical disability. Under the circumstances, the provisions of the Criminal Code do not allow for charges to be laid in this case, the Crown says. The DPCP concludes that the evidence does not establish beyond a reasonable doubt that the words spoken constitute incitement to hatred against an identifiable group within the meaning of the applicable criminal code provision, given the interpretation thereof by the courts. The Crown's news release says. Clearly, the Crown said publicly that it's not the religious defense that saved Mr. Charkawi, but that the elements of the offense were not met, in that he did not call for the killing of an identifiable group of people. So I'm wondering why, if the Bloc truly believes in this amendment, do they need to be so aggressive on these facts that they tender, that do not bear out, Mr. Fortin, with respect? The statement put forth by the Attorney General himself on page 2, paragraph 4, states that in nearly 20 years of this defense existing, we're not aware of a single case in which courts relied on section 319 sub 3 sub b to acquit an accused. This has never happened. We're dealing with a defense that has never been successfully argued. But the challenge with it, as the challenge with all hate law reforms, is that when we lower the threshold, when we start going down the road of criminalizing more and more speech, we create a chill on free speech, because we may place folks in a situation where they do not know if they are offending the law or not. They may be at legal jeopardy. You see, when Mr. Miller says portions of the Bible are hateful, then what am I to make of that? How do I know now what would be hateful? Maybe one of them might be more hateful than another. The point of this discussion is not even the fact that religious people may face prosecution because this defense does not exist. The point is that removing this defense in and of its own may chill religious speech. We should not be entering a zone where folks are in legal, may feel that they may be in legal jeopardy. I learned a lot since I was elected. I was elected in April 2025. I previously served as a provincial member. There is no a Bloc Québécois party in Ontario's parliament. And I've learned a lot about our country, about bilingualism, about French Canada, about our conventions, about your culture. And we respect each other immensely. And I respect your proposition to honor the laicity of the state. I get it. But laicity of the state is laicity of the state, not of everyday Canadians. And to force them to potentially fear for quoting religious scripture is definitely not something that state should engage in. I'm also offended by what's happening here, because I read the criminal code, and the problem, respectfully, Mr. Fortin, that you're trying to solve, and the problem that the Liberals are suggesting they help you solve, does not exist. Please look at the criminal code. Section 318 is the one dealing with advocating genocide. The example being used in this room, in the House, is someone calling for genocide, someone calling to exterminate the Jews or anyone else. But the religious defense does not apply to Section 318. It's not found in the section. You advocate genocide, there's a definition of genocide, there's consent of the Attorney General, and And there's a definition of identifiable group. No defense. The situation we're discussing does not arise. All right, let's go to section 319. It's the hate speech section. We have two operative sections in section 319. We have the first one, where someone incites hatred against any identifiable group, where such incitement is likely to lead to breach of the peace. All right, so identifiable group, breach of the peace. And the second one, willful promotion of hatred. That's the classic one we're familiar with. Everyone who communicates statements other than in private conversation willfully promotes hatred against an identifiable group of people. Then you go to the defense section, and you see in subsection 3 of section 319 that the defenses listed in section 3, including the religious defense, which the amendment proposes to remove, only applies to willful promotion of hatred. Subsection 3 reads, no person shall be convicted of an offense under subsection 2. Please, read section 319, sub 3. It only applies to sub 2. And that is the willful promotion of hatred. It does not apply to the first section, which is the public incitement of hatred. I'm so tired that there is no nuance. Sometimes I feel like there's no nuance in this place. For goodness sakes, look at how much money we're spending here. And there's no professional thought. I've always felt that we've got to inject a little bit more professionalism into politics. You don't need a fancy lawyer. We need someone to read the section. The problem you're trying to solve does not exist. You cannot defend yourself with a religious exemption after inciting hatred or inciting violence. And I would ask everyone to please stop saying that. I will have further submissions down the road. I implore you to please not do this. Thank you.
Thank you, Mr. Weber. Mr. Jennings, the floor is yours.
Thank you, Chair. I appreciate the opportunity to be at the Justice Committee, and I will. I don't want to give people the impression that I only come to committee to discuss procedural issues, but I will start with a couple brief procedural issues in relation to this amendment that I wanted to highlight in response to the discussion, and then I will cede the floor for reasons I'll explain, but I'll ask to be added back onto the list to make those substantive comments later on. The first procedural issue I wanted to raise is just regarding a statement that my colleague, Mr. Lawton, referenced from Minister Fraser. I noticed in that statement that it says, today, as part of its study of Bill C-9, the House of Commons Standing Committee on Justice and Human Rights is set to discuss an amendment repealing Section 313, sub 3, sub B. And I wonder if you could provide a ruling, Chair, on whether the minister's announcement of that amendment that I don't think was made public by the committee or had been moved yet constitutes a violation of the privileges of committee, or at least if you could rule on whether this is a question that touches on the issue of privilege.
I haven't seen the minister's statement, to be honest with you. So you want to suspend for a second? I can.
Chair, if you want to consider that question, and I can.
I'm happy to do that if you want to continue.
Continue for the time being. It was tweeted by the minister at 3:07, and I do believe this is a matter that touches on privilege. He specifically is claiming that a particular amendment with particular provisions is coming before the committee, and I don't think you can do that. The second matter of process I wanted to raise is regarding the role of parliamentary secretaries on committee. There was a time, actually, when, and I don't know if Ms. Chagger is still in the room, I saw she popped in earlier, when she, as government House Leader, made forceful arguments about the unique role that parliamentary secretaries play on committees because they are representatives of the government. I want to quote her verbatim from the House of Commons in 2017, where she was arguing that parliamentary secretaries should be present on committees but should not be voting members and should be understood to be speaking particularly for the government. She said, this is June 15, 2017, this is exactly why I believe that part of the mandate we've been given by Canadians is to strengthen our institutions. A parliamentary secretary not only stands in for the minister but has access to information that would benefit members of the committee. Imagine that. That's why I'm suggesting that the parliamentary secretary be able to share that information. They could be equal members of the committee but not vote and not move motions. That way they could travel with the committee so that information is being shared with all committee members, which I believe would contribute to the level of discourse and decision-making that takes place here. The challenge with parliamentary secretaries voting on committees is that often we see them as just the voice of the minister of the government of the day. And oftentimes there is this perception that you need to vote exactly the way the PS does. That shouldn't be the case. So my colleague, Mr. Lawton, has asked Ms. Latanzio specific questions about the position of the government. This has been described as an unreasonable insinuation by her colleagues, but this is precisely the position articulated by the government House Leader, namely that the role of parliamentary secretaries is to speak for the government in place of them in parliamentary context. So we are all eager to hear Ms. Latanzio do exactly that, answer the questions that have been put before her in terms of the government's position. I understand she said she would be speaking on it, so I'll end my remarks there. If I can be re-added to the list to make a few substantive comments as well, but I'll await her response and also your ruling on the matter of privilege, Chair.
Fortin, back to you.
Ça va, Monsieur le Président. Je retire.
I'm fine, Chairman. I will abstain.
Plutôt, je suis prêt.
Or I'm ready to vote, actually, if it's possible.
Thinking. Ms. Latanzio and then Ms. Gross.
Merci, Monsieur le Président. Donc,
thank you, Chair. I wanted to add my voice and perhaps a few words on this amendment. We know that the rise in hatred is extremely concerning, and we recognise that. It is important to send out a clear message. The defence of the religious exemption has never been used and will never be used to justify hateful propaganda. Freedom of religion is fully protected under the Canadian Charter of Rights and Freedoms. This is a legal clarification. The defence of the religious exemption cannot be invoked to justify a discourse which would otherwise meet the very important definition of hateful speech. That was not the case when the defence existed, and we are clearly closing the door to any future interpretation in this direction without infringing on the rights that are already guaranteed under the Charter. Of course, we will continue to respect and protect freedom of expression and religious freedom, and both of these are guaranteed under the Canadian Charter of Rights and Freedoms. The withdrawal of the religious exemption will not in any way affect the capacity of people who have a faith to teach or practice or actually confess their faith. Thank you.
Thanks, Melissa Tanzio. That takes us to Ms. Cronus. You're down there. Okay, well, everybody keeps deferring. We're going to get right back to you. Back to Mr. Janis. There we go.
You want to go in first?
Okay. Sorry, if I can be re-added to the list, I'd like to give Mr. Lawton the opportunity to speak ahead of me.
Well, Mr. Lawton's next on the list.
Okay, so I'll defer to the bottom again.
I'll start a new list then.
Thank you very much, and I appreciate Ms. Latanzio earlier in her unwillingness to answer my question, said she would be listening to the interventions of members of this committee and sharing thoughts of her own. She has had the opportunity to listen to interventions from this committee, and I did not hear in what she said a clear position on where the Liberals will be voting on this amendment. Now, I don't know whether she wrote her own remarks or whether Minister Fraser did the courtesy of it, but I do not believe for a second that she is speaking as a rogue member that has not consulted with the minister that she represents and the prime minister she represents. Now, we did learn earlier in media coverage that the prime minister's office and the minister of justice were apparently not in line on this issue, and that may have led to some of the subsequent cancellations, postponements, extensions, abbreviations of meetings. But we are talking about a fundamental altering of not just the criminal code, but of longstanding religious freedoms in this country. The kind of decision that, if it is to exist at all, should have been a standalone bill. And it was. And when it was a standalone bill, the Liberals rejected it because they realized that this does not belong in a pluralistic country that represents people of all faith backgrounds and a House of Commons that represents people of all faith backgrounds. So my request of the government right now, my request of Ms. Latanzio as the Parliamentary Secretary to the Minister of Justice is to have the courage to state that they will be voting for this, if that is in fact their decision, or to have the even greater courage of standing up for religious liberties and vowing to reject this.
Thank you. That takes us back to, well, who wants to speak? Ms. Cronus, you're done, okay. Mr. Genis is not at the table. That exhausts the speaking list then. All right.
No response?
All right. We're going to put it to a vote.
Good. Okay. So vote on BQ 3. Madame Latanzio. Oui.
Wow.
Mr. Chang.
Surprise.
Madame Dillon.
No idea that was coming.
Mr. Housefather.
Oui.
Mr. Baber.
No.
Mr. Brock.
Absolutely not.
Mr. Gill.
Big no.
Mr. Lawton.
Absolutely not.
Monsieur Fortin.
Okay. BQ3 carries.
Point of order.
Yes, Mr. Lawton?
I have an amendment pertaining to the matter at hand that I would fit into the line now that's being circulated with the clerk. I just wanted to, that may not be a point of order, but it should go in now logically with where we are.
So the matter at hand being the clause by clause?
Sorry, the matter at hand being where we are in the order for amendments. It fits into where we are now in the bill.
Okay, well, maybe we can suspend for a moment or two so we can have a look at it.
Well, I can read it and you can make a decision.
Well, why don't you read it and then
Okay.
we'll suspend because I assume you don't have it translated.
Yeah, we do.
Okay.
This was prepared by legislative drafters. And I should just, by way of context, the reason it was not in our original amendment package is because we had not seen the block amendment at the time, so it only emerged when we saw that this was coming up. The amendment is as follows, in French, que le projet de loi C9
That Bill C9 under Section 4 should be amended by addition after line 2, page 3 as follows. 6.1. This section cannot be interpreted or applied in a way that it would actually infringe on the freedom of expression or religious freedom.
C9 in clause 4 be amended by adding after line 2 on page 3 the following. 6.1, nothing in this section is to be interpreted or applied so as to interfere with the freedom of expression or the freedom of religion.
Okay, we'll suspend for a moment now. Thank you.
I just sent it. Je viens juste de...
Hope everybody got some food. And I believe Mr. Brock, you were, or no, sorry, Mr. Lawton. I missed Larry so much while he was away that I.
That's okay.
You know.
So on the amendment?
Yeah.
Okay. So, thank you very much. And I just want to be very clear here. This amendment does not undo the harm that was just inflicted on Canadians by the Liberal members of this committee. This amendment does not undo the assault on religious freedom that we just witnessed moments ago. But it does provide a very important and very necessary opportunity for this committee to recenter its efforts. And I want to go back to my maiden speech in this House of Commons back in, I guess it would have been the tail end of May. And I said in describing what I hope to achieve as a Member of Parliament representing the wonderful riding of Elgin St. Thomas, London South, that I wanted to make Canada a freer place. And I was motivated in large part by some of the assaults on freedom of expression and freedom of assembly we've seen from this Liberal government in the last decade. And I had hoped that they had turned a corner. We often heard from the Liberals this position that it was a new government. It was not the government of Justin Trudeau that decided it would freeze the bank accounts of political dissidents. It was not the government of Justin Trudeau that was going to attack the charitable status of places of worship. It wasn't that government. And then we saw Bill C-9, a bill which had a lot of shades of Bill C-63, the Online Harms Act, which had been introduced in the preceding Parliament as well as Bill C-36. And I warned a lot of Canadians that reached out to me that agreed in spirit with what Bill C-9 was trying to do, that there was a significant risk that if this bill were allowed to go to committee, it would come out worse than it went in. We now know, beyond a shadow of a doubt, that that is exactly what is happening. If Bill C-9 is allowed to exit the Justice Committee, with this baked-in deal between the Liberals and the Bloc Québécois that the Liberals have held up their end of, and I suspect that the Bloc will hold up its end, should this bill proceed to the House of Commons, it will be a full-fledged assault on religious liberty. Now, this is something that we as a party will not stand for. Mr. Brock, at the very beginning of this meeting, said very clearly what Canadians have cried out for is not a government that's going to police their tweets. It's not a government that's going to legislate on what can be said from behind a pulpit. They want a government that's going to get serious about the challenges facing Canadians. Affordability challenges. Challenges with crime on our streets. Now, the Liberal government has finally, and I'm so grateful for this, they've acknowledged this problem they've created over the last decade in the revolving door bail system, and they've introduced a bail bill, C-14. There are some good things in that bill. There are some things that are very concerning in the bill, and there are things that are not in the bill that should be in the bill. These are the kind of conversations that members of this committee in good faith can deal with, and I suspect would be able to. I agree wholeheartedly with Mr. Brock that there is a lot more consensus around Bill C-14 than there is around Bill C-9,
Point of order.
Especially now. Mr. Chang, yeah.
How is this relevant to C9 again?
Chair, you'll find it. If you give me 60 seconds, it will become very clear where it is relevant.
You have your 60 seconds, but I would like you to get to the point.
Of course. So the reason I bring that up about C-14 is to give the Liberals an opportunity to do the right thing. We, as Conservatives, are not going to allow this assault on religious freedom and freedom of expression to become law. And I am prepared to speak for as long as it takes to stop this from taking place, to make good on a promise that I made to my constituents, to Canadians, and
Point of order.
Frankly,
I represent Burnaby, which is a very diverse community in Canada, and
You haven't heard his. Hold on. You haven't heard what he's going to say.
Is there any
Apparently
standing order
long lead up to your point are acceptable. Mr. Chang, go ahead.
my constituent believes that C9 and C14 are equally important.
Not a point of order.
He's 5 words into his point of order. Allow the member to make his point, and then I'll decide whether it's a point of order or not.
Chair, is there somewhere specific I should sit?
Do you really want me to answer that question? I'm happy. Can I be candid? Make yourself comfortable.
There's a seat right there.
Mr. Chang? Mr. Chang? You're done? Okay. All right. Thank you.
Thank you. So,
Getting ready for being in government.
as I was saying, we are prepared to do what it takes to stop not just bad law, but dangerous law from being enshrined in Canada's criminal code. The Liberals can do the right thing at any point, agree to prioritize C-14. If not, they are holding critical bail reforms hostage to justify their assault on civil liberties. And it is not something we will stand for. Thank you.
Okay. Who is next? I think Mr. Jenness, you were next on the list.
Well, thank you, Chair. I'm very grateful for the opportunity to speak here at the Justice Committee. And I've been observing with great interest the discussion thus far on Bill C-9, and in particular, the discussion on the issues of religious liberty that have been raised by this Liberal bloc amendment that have passed and now are further discussed in this amendment from my colleague, Mr. Lawton, aimed at protecting religious freedom. And Chair, as I talk about religious freedom, I do want to just acknowledge the presence of people in the room who have come to Parliament Hill to observe these discussions, people who are concerned about religious freedom issues. I know I saw people here that I know from the Muslim, the Jewish, and the Christian communities, all who came to observe these discussions. And I certainly wouldn't want to put words in their mouth. They can all speak for themselves in various fora. But I want to thank people who care about religious freedom for being here. And I know there are many people watching these discussions online who care deeply about religious freedom. And I want people who are watching to have maybe a sense of something you can't see on the video feed. And that is that normally at committees, the Conservatives would have 4 members sitting around the table who are the regular members of the committee. And right now, I count 10 Conservatives sitting around this table. We've even had issues raised of people sitting too close to each other, which is something we can work out. But it illustrates the point that we have many Conservative members of Parliament who are here in the evening and who will be here as long as it takes. Because we care deeply about the defense of religious freedom. So I know there are people watching who are fighting on this issue, who are writing letters, who are emailing their members of Parliament, who are talking to their faith leaders, who are even door knocking in their own communities to raise awareness about what's happening with Bill C-9. I want to thank Canadians from all faith backgrounds and from coast to coast who have worked hard to make their voices heard. And I want you to know that Conservatives are here in force. We hear you, and we will stand with you, making the case for religious freedom and for freedom of speech. And we need people at home, people across the country, people who care about religious freedom, to continue making their voices heard, to continue contacting members of this committee and members of Parliament, to continue talking to their neighbors and friends. It has been incredible to see the speed and the scope of mobilization that there has been in this country in response to this bloc Liberal deal attacking religious freedom. Communities have reacted with lightning speed. They have just been moved so much faster than I have ever seen before, and I know that mobilization is only beginning. And it was in response to this mobilization that the government initially appeared checked in their plans to attack religious freedom. As recently as this week, there was an article quoting multiple government sources that looked like it was people within the Liberal Party trying to throw the Justice Minister under the bus and say this whole thing was his idea cooked up without consulting others. But whatever the genesis of this bad idea within the Liberal Party was, I guess today they have decided to close ranks in their attack on religious liberty. We have just seen members of the government line up all to support the bloc amendment attacking religious freedom. And if members think they've started to receive a public response, if they think they've started to see Canadians concerned, I would say you ain't seen nothing yet. You're going to be hearing in the days, weeks, and months ahead from Canadians who take their religious freedom and their freedom of speech seriously, and who will be responding in force. In particular, I know that the Prime Minister has tried to suggest that he would be more open or more friendly to communities of faith than the last Liberal Prime Minister was. But with this amendment being adopted, that false impression has been totally blown out of the water. Prime Minister Mark Carney has shown with the vote of MPs today that he is willing to go even further than his predecessor in attacking the basic religious liberties of faith communities. And I know that faith leaders in every community will take note tonight of the fact that the Prime Minister has allowed this to happen, has supported his Justice Minister, and that the government, notwithstanding whatever second thoughts they may have had, has followed through on this attack on religious freedom. The Conservatives are the only party that is defending religious freedom, and we will maintain that stand. We will stand for what is right. We will stand alone if necessary. We will stand against Bill C-9, and we will defend the fundamental freedoms of Canadians. Religious freedom is deeply important. It is part of our Constitution. As has been noted, it's part of the Charter of Rights and Freedoms. It wasn't new with the Charter of Rights and Freedoms. The defense of religious liberty is part of the Bill of Rights. It's part of the implied Bill of Rights dating back to our founding as a country. It is fundamental to our political tradition. It is also in our commitment our commitment to the Universal Declaration of Human Rights, reading from Article 18. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. I want to observe Article 18 of the Universal Declaration of Human Rights underscores the nature of religious liberty. It is not just a right for communities to preserve their traditions. It is not just a right that applies to people who are themselves religious. Religious freedom is for all people, whether they consider themselves religious or not. It is the freedom of thought, the freedom of conscience, the freedom of the individual to consider their humanity, to consider their place in the universe, to consider questions of ultimate meaning and truth, to, in the process of that consideration, come to their own conclusions that reflect their conscience, to deliberate about those conclusions, to change their conclusions, to forcefully debate those conclusions with others, and to live in accordance with those deeply held convictions. In that sense, religious freedom, as outlined in Article 18, can be thought of as the first freedom, the most foundational freedom, because the freedom of thought, the freedom of conscience that is linked to freedom of religion in Article 18 of the Universal Declaration of Human Rights is the foundation, the ability to form one's actions based on conscience and conviction is the foundation of all other freedoms. It is the basis of our humanity that leads us to further actions. And it is these provisions in Article 18 that have been attacked by this Bloc Liberal amendment. Now, while I'm speaking, if one of my colleagues could get me a glass of water or two, I would be extremely grateful. Mr. Chair, speaking of Article 18, I have worked a great deal in Parliament over the last 10 years on issues involving religious freedom. Issues of religious freedom have always been deeply important to me as a person of faith, as the grandson of a Holocaust survivor. And as someone who has, in their time in Parliament, come to know closely many different ethnic and religious communities in this country who have faced attacks on religious freedom. When I was first elected, our leader at the time, Rona Ambrose, gave me the great honor of taking on a role in our caucus that was called Deputy Shadow Minister for Human Rights and Religious Freedom. Nobody who I told initially had any idea what that was, but it was a role within our caucus that involved advocating for human rights and, in particular, religious freedom. Excuse me one sec. Now, it's interesting, back in 2015, when you took on a role called Human Rights and Religious Freedom, it was sort of a given that you were talking about issues in other countries. Because back in 2015, it was assumed that that religious freedom was something that we had in Canada and that we had protected in Canada. Of course, I've mentioned that Canada is a party to the Universal Declaration of Human Rights, and our various constitutional documents underline the importance of religious freedom. This is well established in our law, and I think the argument, by the way, just parenthetically, the argument you hear from the government in response to concerns about this amendment, about the previous amendment that we were discussing, the Liberal Bloc amendment, is don't worry because religious freedom is protected in the Charter. Now, the argument they're making essentially is don't worry about a statute that would appear on the face of it to violate religious freedom because religious freedom is protected in the Charter. As if the existence of the Charter establishes some law of physics which prevents legislation from passing that violates it. No, that's not how the Charter works. The way the Charter and constitutional protections on religious freedom and other rights work is laws can still get passed that violate those rights, and those laws are in force until they are struck down, until a judicial process intervenes. And in fact, they can create a chilling effect that limits the free practice of religion, that limits freedom of speech, that establishes other limits on practice and behavior, and those laws can persist in place unless and until there is a case that challenges them, and that case establishes that previous law was unconstitutional. Then and only then is that previous statute overturned. But I think we have seen, I think we saw during the pandemic period in particular, for example, that you can have the passage of laws that are unconstitutional, and those laws can remain in force for a while. And sometimes the subsequent determinations that those laws were unconstitutional come so far after the fact as to not be as immediately relevant to those who were victims of the human rights violations in the first place. So the argument of the Justice Minister, repeated by the Parliamentary Secretary and other Liberals, that don't worry, we have the Charter, well, that is not an argument for passing unconstitutional laws or laws that violate religious freedom. Those laws are still in effect, and they remain in effect until they work their way through the process. And furthermore, the existence of a judicial process for addressing violations of human rights does not obviate members of the obligation to consider issues of human rights during parliamentary debate, to consider the implications of the decisions they make for the protection of fundamental human rights. Our legislature has a responsibility to deliberate about matters of human rights and to come to consider judgments about them. We did not cease to have a legislature when the Charter of Rights was adopted, and we did not cease to have responsibilities as legislators for considering questions of fundamental human rights. And yet that does appear to be the implication of much of the rhetoric from the government. Again, don't worry, we have constitutional protection of human rights. So if you think the government passes legislation that violates human rights, don't worry, someone could fund an expensive charter challenge, and maybe a few years or decades down the line, we'd come to the conclusion that this bill shouldn't have passed. But in the meantime, of course, the damage has been done. That is an obvious problem, and I would encourage members of Parliament to do their jobs. That is, to consider the implications for fundamental human rights, and to vote on amendments and legislation in the context of that reality. So I'll just go back. I was speaking about kind of the origins of my engagement on the topic of religious freedom. When I was first elected as a member of Parliament, taking on this role within our caucus focused on human rights and religious freedom. And this was to advocate at the time, the understanding was human rights and religious freedom. That's something that we're concerned about in other countries, because generally speaking, in Canada, we have good protection for religious freedom. That was where we were in 2015. That was the general expectation. And I was pleased to take on this role at a time when the role was very personal for me for another reason, and this is that Canada had established under the Stephen Harper government an office for protecting religious freedom, and the Office of Religious Freedom was embedded within the Department of Foreign Affairs, again, based on the understanding at the time that challenges to religious freedom would primarily be in the international domain. More recently, when I talk about the Office of Religious Freedom, a lot of people tell me, well, we could really use one of those focused on Canada, focused on domestic threats to religious freedom. But at the time, this was an office embedded in foreign affairs. And from what I understand, the genesis of this idea for Prime Minister Harper, Shahbaz Bhatti, who had been a minister in the Pakistani government, a minister for minority affairs.
Can I interrupt you for a sec? The interpreter's telling me you're talking too fast, and you can probably see that because you're looking at yourself on the screen. So I would ask that you slow down a bit for the benefit of the interpreters.
Thank you, Chair. I'm sorry. I was under the impression that the committee wanted me to move as quickly as possible through the remarks, but I am willing to speak slower.
On that note, since we've paused for a moment, I have good news. We've secured resources for tomorrow and Thursday from 3:30 until midnight, and the notice will be going out shortly if it hasn't gone out already.
Thank you, Chair. When I graduated from high school, the motto was "In omnia paratus," which means "prepared for all things," and I've taken that motto to heart in my service in Parliament. So, pardon me, Mr. Chair. Okay. Were you saying it wasn't that long ago?
Yes.
Yeah. Okay.
Point of order.
I say that out of envy more than anything.
Yeah.
Point of order.
Thank you.
Yes. Go ahead.
Just on programming, so you said that resources have been secured for tomorrow and Thursday, so I suspect meeting notices will be forthcoming. I just want to know, are we going to be continuing with clause by clause of the Liberal censorship bill, or will they agree to let us study bail on Bill C-14 in one of those meetings?
You'll have to wait till the notice comes out, but we're continuing with clause by clause on C9.
Okay.
A point of order. I also wanted to clarify whether there are resources available Friday and next week as well, so we can get through this. Thank you.
I believe the answer to Friday is yes, and we'll see about next week.
For next week. Okay, thank you.
Thank you.
Want to listen to 5 days, me, Andrew? Because I got lots.
What about the 25?
Well, they're criminalizing Christmas anyway, so.
Yeah. Freedom of religion is no
Thank you.
more.
Well, thank you, Chair. Just on the issue of working on the weekend, I think there is a relevant scriptural text I can reference about that, and I do so with some trepidation, wondering if this could lead to prosecution. But there is I believe there's a passage where it's discussed whether it is permissible if your cow falls in the well on the Sabbath to pull it out. Implication being that, yes, even if on an obliged day of rest, your cow falls in the well, it is still permissible to pull it out. So from my perspective, the passage of this Liberal bloc amendment is the equivalent of a cow in the well, and I will be prepared to work through the weekend and through whatever other holidays and holy days intervene in order to pull the cow out of the well as best I can. I hope the Minister of Heritage won't seek my prosecution as a result of that reference. Now, anyways, back to the point I was making, and out of great respect for our interpreters, I will endeavor to speak a little bit more slowly. So some of the context on issues of religious freedom. The point being that taking on this role in 2015 at a time when Canada had an office of religious freedom, that office was embedded within the office of the Minister of Foreign Affairs and did important work. The office was inspired by the work of one Shahbaz Bhatti, who had been the Minister for Minority Affairs in the Pakistani government. And he was an advocate for the rights of minorities in Pakistan and an advocate against a blasphemy law that was used aggressively to prosecute religious minorities for a form of speech crime. That is, for somebody speaking in a way that was that led to a that was deemed inappropriate. Of course, there's all sorts of issues of false accusations, etc. But Shahbaz Bhatti was involved in speaking against the misuses of the blasphemy law, effectively a form of speech crime used to target religious minorities. He was advocating for a woman named Asia Bibi, who had been arrested on a series of trumped-up allegations that arose as a result of a personal dispute. Mr. Bhatti was in Canada, and he met with members of Parliament, and he spoke about issues of religious freedom in Pakistan, and he asked Canada to do more to respond to this issue of violations of religious freedom. And he also talked about, while he was here in our Parliament, about the fact that he believed his life was at risk as a result of his advocacy. And I know he met many of our colleagues. I don't think there are that many folks that are still around, but I know he met many of those who were members of Parliament at that time who were very touched and inspired by what he said. And people asked him, well, why don't you stay here in Canada if your life is at risk? And he said, no, for the defense of religious freedom, I must return to my country, and I will advocate, continue my advocacy on issues of religious freedom. Minister Bhatti returned to Pakistan and was assassinated within 2 months. And I remember this vividly because it was, I think, around that time that my wife and I got engaged, and her family are Christians from Pakistan, so followed these issues of minority rights in Pakistan very, very closely, and by extension, I was starting to follow these things as well. And Mr. Bhatti was an incredibly heroic figure, somebody who knew the risks, who talked about how he knew the risks, and nonetheless continued his fight for religious freedom. As I recall, he met Prime Minister Harper while he was here in Canada, and following this assassination, the Harper government launched the Office of Religious Freedom, an office designed to facilitate advocacy by Canada on international issues around religious freedom. And the office had a number of functions, one of which was to speak publicly about religious freedom issues internationally. Another was to inform the Department of Foreign Affairs to ensure that public servants were aware of the situation around religious liberty and how it may be intersected with other work that they were doing. And the third function was to run concrete programming. And I think today about some of the issues that are now getting a bit more attention, such as the severe persecution of Christians in Nigeria. And in many cases where we hear about the persecution of religious minorities, Canada's Office of Religious Freedom was actually running specific programs on the ground in those countries aimed at advancing religious freedom. And really, they were active more than just at dealing with kind of acute cases of abuses. They were dealing with looking at causes and looking at prevention. For instance, trying to help get pro-pluralism content into books. Trying to the project in Nigeria was around facilitating dialogue between Christian and Muslim leaders in that country, so that when there were kind of flare-ups of violence, there could be the activation of these networks of leaders that could address these kinds of issues. The Office of Religious Freedom, for a relatively small amount of money, was doing great work overseas. And I think, as I recall from time to time, there were people who might have asked them to comment on domestic issues from time to time, but that was not part of their mandate. They were focused on international religious freedom and helping support Canada's ability to be a voice for freedom and justice on the world stage around these religious freedom issues. So after the election in 2015, when I was first elected and also the Liberals took office, the government decided that they were going to eliminate the Office of Religious Freedom. And this probably should have been, in a way, a sign of things to come, that the government immediately chose not to renew the mandate of the Office of Religious Freedom.
Mr. Housefather?
Relevance, Mr. Chair. He's straying farther and farther away from an amendment to the bill and Clause 4. Like,
Sorry,
we're not now debating whether or not the Office of Religious Freedom should be renewed or not renewed. This is getting very far away from where we're going, Mr. Chair. And I don't mind. I understand that the amendment has the words freedom of religion in it, but I think you need to just rein it back so it deals with the Criminal Code of Canada and the bill. Thank you, Mr. Chair.
I agree with Mr. Housefather.
Yeah, well, that's
I sort
not
of lost the
correct,
thread there a while ago myself. Maybe it was after high school, I think, when you mentioned. But if you could bring it back towards what we're talking about.
Chair, if you've lost the thread, I'm happy to go even slower than I've been speaking now.
Let me rephrase that. I don't think there was a thread. But if you could bring it back closer to what we're talking about, we'd all be grateful. Thank you.
I have been led to believe that these issues of religious freedom are important in your constituency as well, especially the assaults on religious freedom that we've seen against the Tibet community.
Yes, your aunt, who's one of my political allies, I work very closely on there.
No family's perfect, Chair. But the
she tells me that all the time.
Thank you, Chair. Sure, I mean, to Mr. Housefather's point, let's just reiterate the amendment that is before the House, before the committee. The amendment says nothing in this section is to be interpreted or applied as to interfere with the freedom of expression or the freedom of religion. And so I think it is fairly obvious that arguments pertaining to the nature of religious freedom are not only tangentially relevant, but centrally relevant. They are not only part of the issue; they are the issue. And I think the point initially is to note how there has been a sort of progressive pattern on the part of government in terms of the incremental attacks on religious freedom. When the Office of Religious Freedom was removed, we should have maybe seen the writing on the wall. And I hope I can say the writing on the wall without being prosecuted, because that is also a scriptural allusion. It refers to a passage in Daniel, for those who are less familiar. But we've seen over the course of the life of this government the gradual furthering of an agenda that attacks religious freedom, that attacks the positions of faith communities. And I think some people had thought, because of the professions of the new prime minister, that he would be different in this regard. But actually, what we're seeing today is that the approach of the current prime minister is actually, in significant respects, worse than the approach of his predecessor. So we saw this government attacking or removing the Office of Religious Freedom, and I think doing so, claiming that, well, don't worry, we can advance religious freedom or advance human rights in other ways. We can use other vehicles. And notably, they had promised at the time to maintain an advisory board that was associated with the Office of Religious Freedom. And I think this advisory board was actually a very positive kind of aspect of the work of the committee as well. And the advisory board did important work bringing together faith leaders from various communities to consult with the government provide advice on various issues. And I think it reflects the reality that it's good for the government to be talking to and engaged with leaders from a variety of different backgrounds, including faith leaders. So we have seen this progressive series of attacks by the government on religious freedom up to this point. And, Chair, I will have much more to say about this, so I wonder if I can be added to the bottom of the list. But I have been advised that some of my colleagues have some context they'd like to add before I go further, so I'm happy to do that. But just before I cede the floor, Chair, are you planning on ruling on the question of privilege that I raised earlier regarding the Minister Fraser leaking confidential material from the committee?
I will let you know. Okay, so we have Ms. Cronus.
Well, Chair, can I just say I raised that's a question of the privileges of the committee. I raised that issue.
I understood
at
that,
this point
and
an
I
hour and a half
understand that
ago.
now, so thank you.
You're
Ms.
continuing
Cronus,
to think about it, eh? Okay, well, I haven't ceded the floor yet, Chair.
Well, you just said you were
But
ceding
now
the
I will
floor,
cede the
but
floor.
don't make up your mind.
No, but I said before I cede the floor, I wanted to hear from you on the matter of privilege, and
And I answered your question, so are you
you
done?
said you said you have no answer.
Are you done?
You're still thinking about it.
I said I will have it. I'll let you know when I have an answer. Are you done?
Do you have a rough timeline, Chair?
Are you finished, Mr. Jennison? We could sit.
Well,
we
not-
could sit
not-
here and have this very
not,
interesting
not yet.
banter all night if you
I'll
want.
tell you when I am. But are you
Oh,
planning?
Okay, keep talking then.
Okay. Are you planning on ruling on the matter of privilege
I already
tonight? Or?
answered the question. You keep talking.
Okay. Well, it sounds like you plan to be as forthcoming as Ms. Latanzio was. So that at this point, I will cede the floor, but I'll ask you to add me to the list.
All right, Ms. Cronus.
Thank you, Mr. Chair. Thank you, Mr. Chair. I appreciate the opportunity to contribute to the committee's deliberation of this bill and to the debate about this clause, which removes important safeguards for freedom of expression and religious freedom in particular. And I'm going to focus in on the idea that it behooves this committee and all the members of this committee to vote against this clause because of the fact that we should always vote against laws that we believe are unconstitutional. And I would submit to members of this committee that this clause, as it's proposed, amends the criminal code in a manner that is, in fact, unconstitutional in every way. It violates the Charter, it violates the Constitution, and in my remarks, I will explain how it arguably even violates the principles of natural justice. So in addition to doing that, when combined...
Sorry, we have a point of order, Mr. Host.
Yes, I love Ms. Cornish, but the yeah, she's a wonderful person. I am a huge fan of Ms. Huge fan. But I think she's speaking to the wrong amendment, right? Unless she's arguing that Mr. Lawton's amendment removes all of these rights, she's not speaking to the amendment that's right now on the floor.
Well, I actually will be arguing that Mr. Lawton's amendment is important because it restores these rights.
I understand, but you were just at this amendment, so I just wanted to
Oh,
clarify
thank you
that you
very
weren't
much
speaking
for
to
the-
Mr.
for the
Lawton's
clarity.
amendment that you're arguing is doing that.
Oh, well, I thank you.
We're all feeling better now. Okay.
We're all widely, trying to achieve the same thing.
We're all
in
getting
different
very
ways.
emotional now. Please continue.
So thank you for your many kindnesses, and as my late father would have said, thank you for everything. So this amendment is necessary in order to make it so that this bill is consistent with the Charter and the Constitution and these principles of natural justice. Because without it, this bill, especially when it's combined with the proposals to remove the Attorney General's consent to private prosecutions, which this committee did reject, but which the House could always revive, as we've seen in some cases when bills come back from committee, parts of them are revived. The bill, as written, has the power to amplify and unleash a wave of anti-religious animus and quite frankly, both inter and intra-religious conflict across this country as people use these provisions to litigate the idea that the state, through the courts, should effectively be able to edit the Bible, the Quran, and the Torah and other religious texts to ban the parts that offend them.
So even if we have been successful in restoring the need for the Attorney General's consent for private prosecutions, the reality is that everything gets weaponized on social media. And this means that public assertions that various people should be arrested because of the things that they say at the pulpit and in other religious spaces will proliferate. And this is especially distressing considering the fact that these calls are already not uncommon in some of our communities. So I'd like to explain how my colleague's amendment helps. So the separation of church and state is a very important subject that sits at the heart of Canada's constitutional identity. It is a fundamental governing principle of our society, but one that developed over time and one that actually influenced the development and the creation of the defense of sincerely held religious belief within our hate propaganda laws. And so to understand why that defense exists and why Parliament has preserved it across decades and across governments, we need to focus on something deeper. We need to understand how Canada came to adopt a model of state neutrality in matters of faith and the caveats to that, a model that protects both freedom of religion and freedom from religious coercion, because these are ideas that did not appear suddenly. They emerged slowly through centuries of negotiation, conflict, and constitutional development. They do also reflect the unique character of our political history here in Canada. So when we look back to the earliest chapters of the Canadian story, we do see that long before Europeans arrived on this continent, Indigenous peoples had rich spiritual traditions that were deeply embedded in their community life. These traditions, of course, varied from nation to nation, but they shared important themes. They recognized individual spiritual autonomy, they recognized collective responsibility, and they were not controlled by a central political authority. They were part of life rather than being dictated by the state. And it's important to remember this because it shows that the idea that belief is personal has very deep roots in this land. Haitchka, for this we are grateful. The arrival of European colonial powers, of course, introduced different models. Under French rule in the 17th and 18th centuries, the Catholic Church, of course, played a central role in administering education, healthcare, and social services. Church and state were really intertwined during that period as mutually reinforcing institutions.
This sounds like a history class. Relevance.
Exactly. You should pay attention.
Learn something.
All right.
May I continue, Mr. Chair?
The comments from the peanut gallery aren't helping. I realize it's getting on into the evening, but I think we can show a little respect for each other at a higher level than that, if you don't mind.
Thank you, Mr. Chair. I've actually worked.
I understand there's a continuing request to keep it focused on the amendments in the bill, and I think that's fair. So, but
well, and I am doing that. I actually worked hard on these remarks, Mr. Chair. I spent a good amount of time researching this, and I think that if you look at the way that our courts consider the constitutionality of various provisions in our legislative history, that it is actually not unusual to see comments like these and to see remarks like these. I mean, look at the Cowichan Tribes decision, which was just issued. It was 800 pages and had hundreds of pages of history. And so if my honorable colleague doesn't want to hear about that, then I'm sorry for that, but it is actually part of our constitutional history to recognize, our constitutional litigation system to recognize that history. So I'm just trying to see where I was here. So these arrangements which shaped Quebec society did continue even after Britain took control of New France in 1763. We, of course, had the Quebec Act of 1774 protecting Catholic rights as a means of ensuring political stability. And this is where we really do continue to see this recognition of practical necessity and a unique flavor and character to our laws as they developed. And, of course, as as Canada developed, waves of settlers brought diverse faith traditions. There were Protestant, Catholic, Jewish, Muslim, and other communities, Hindu, that came and lived side by side, sometimes peacefully and sometimes, of course, in tension. And in the 19th century, these arrangements did come under increasing scrutiny as our populations diversified. I mean, we've had to find ways to live together, secular, religious, since the beginning of our constitutional grand bargain, to coin a phrase. So when Confederation was established in 1867, this question of the separation of church and state was already very complicated. There's, of course, the protection in our Constitution Act, protecting denominational school rights that existed at the time. And this is, again, another political compromise rather than that preserve the peace between various communities. And that spirit of compromise has been fundamental to our communities. Now, in the decades that followed, several events continued to shape Canada's approach to this issue. And of course, as my colleagues from Manitoba know, one of the most important was, in fact, the Manitoba schools question in the 1890s. Manitoba, of course, had ended public funding for Catholic schools, which sparked a national debate that involved, not unlike this one, by the way, that involved Parliament, the courts, and the public. Eventually, Manitoba's decision, of course, stood in that case, and there was a shift towards secular public schooling that became more pronounced across the country. And that debate showed that Canadians were increasingly accepting the idea that public institutions might not be tied to the doctrine of a particular faith, but it, of course, did not do away with the idea that faiths and sincerely held religious beliefs needed to be protected, even in circumstances where we might vehemently disagree with them. Now, by the middle of the 20th century, our social landscape had changed significantly, and the hospitals, universities, and social services that had once been governed by religious institutions became integrated into those publicly funded systems. And that, of course, laid the groundwork for the modern understanding of church-state separation, which is a government, and this is where I come back to this bill, and this amendment. It's a government that neither imposes religious doctrine nor interferes, and this is the part that's very important, that it doesn't interfere in religious practice. This is foundational, and this conversation that we have had over the decades in this country is fundamental to our being a society that respects diverse beliefs while protecting individual rights. And of course, the adoption of the Charter in 1982 brought constitutional clarity to this concept. Section 2A protects freedom of conscience and religion. Section 2B protects freedom of expression. Section 15 requires equality before the law. And together, what these provisions did is they codified what had already been developing for over a century, which is the idea that the state must remain neutral in matters of faith. It must protect the right to believe, the right not to believe, and the right to express beliefs peacefully. Now, one of the most painful reminders of the danger of church and state, well, why don't I just go? When Parliament enacted Section 319, which prohibits that willful promotion of hatred, it had to navigate the same delicate balance that had shaped our country's development and that I've been expounding and explaining through my remarks. On one hand, the state has a duty to protect vulnerable groups from hate propaganda. On the other hand, Canadians have to be free to express their religious beliefs, to teach their doctrines, read their scriptures, and engage in theoretical debate. Parliament at the time did not want clergy or people of faith to fear prosecution for simply expressing traditional beliefs, no matter how outdated or how wrong we might think they are. And that's where the defenses that we're discussing came from. The solution to this was the inclusion of several defenses, including the one that has become known as the defense of sincerely held religious beliefs. So this defense protects statements made in good faith on a religious subject or based on religious opinion. And the key words there are in good faith. The defense does not protect malice. It does not protect hostility or efforts to encourage hatred. It protects genuine attempts to express or explain religious doctrine. And that, Mr. Chair, is something that I feel has been lost in this debate. That there have been people, and there has been some encouragement from both the Bloc and from my Liberal friends across the aisle, and in this case, mostly across the table. There has been an effort to make it as if the removal of this defense is necessary to be able to protect vulnerable groups. But in fact, the words in good faith that are embedded in this defense actually do that job for us. And this defense, and it fits, the defense fits in that way squarely within Canada's unique and long history of the separation of church and state. Because what a neutral state does not police doctrine. A neutral state does not decide which theological views are permissible. A neutral state does not suppress good faith religious teaching, however distasteful it may be. To coin a phrase that one of my rabbinical friends has used, we all have our beliefs, but none of us have met God yet. And so it's hard to know who is actually right. Now, at the same time, a neutral state can and does have an obligation to address the deliberate and harmful promotion of hatred. And the criminal code as it exists today draws that line carefully. And I would submit to you that it behooves us as parliamentarians not to erase that line recklessly or through these provisions. Because when the charter arrived, the courts have already reviewed these provisions. In the Keekstra case of 1990, which I was actually involved in as a high school student, the Supreme Court upheld the constitutionality of hate propaganda laws, but emphasized that the religious defense was an important safeguard. The court pointed to the requirement that prosecutors prove willfulness and the availability of good faith religious expression as evidence that Parliament had respected both freedom of religion and the need to combat hate speech. The balance was tested again. And it was tested again when Parliament decided to expand the list of protected groups. In 2004, when sexual orientation was added, Parliament examined whether the religious defense would continue to offer adequate protection. Members across the political spectrum at that time acknowledged that people of faith must remain free to express their beliefs without fear of criminal prosecution. The same debate resurfaced in 2017 when gender identity and gender expression were added. In each instance, Parliament concluded that the criminal code's existing safeguards were strong, principled, and consistent with Canada's constitutional tradition. The concerns that we are discussing today in this committee are echoed in recent reporting and in the principles of free speech and freedom of religion that we held dear when I was a human rights advocate many years ago and involved in all three of the historical references that I just talked about in terms of that litigation. As the Toronto Star noted this week, even some of the strongest advocates for equality and for social justice have historically defended both freedom of expression and freedom of speech as a universal safeguard. And 2 decades ago, I'm reminded of this because Gilles Childon was quoted in the article, and he, of course, is a former executive director of EGAL, and he was a mentor of mine in my human rights work. And he reminded Canadians that freedom for all means freedom for each. And he said this while he was defending the expressive rights of an Alberta pastor whose views he described at the time as being misguided and vitriolic. And I remember having long conversations about this when this was going on. Because what mattered to Gilles was not the content of the speech, but the principle of it. The idea was that if the state could silence one unpopular voice, who might be next? And this was, by the way, this was before social media, before people took to social media to say that this person should be arrested or that person should be arrested because they quoted this thing or that thing. The fact that the person might not be arrested didn't mean that we haven't had a proliferation of defamation suits, human rights suits, and all kinds of litigation around these concepts. Gilles' point has lost none of its force today because protecting the rights of people we disagree with is in fact still how we protect the rights of everyone. So the article does go on to warn, as I have in these remarks, that Bill C-9 risks abandoning the careful constitutional balance that we have built over decades and that I have explained in some detail this evening. The bill would expand police authority to lay hate-related charges based on a far broader and more subjective definition of hate. And depending on how the amendments work to various definitions in here, it actually could get quite broad. And as we know, there are other countries right now that are really struggling with this. Legal experts and civil liberties groups rightly caution that this proposal appears less as a tool for protecting marginalized groups and more as a broad expansion of police and state power with a high risk of misuse. And critics from across the political spectrum fear that the legislation would chill legitimate dissent, restrict peaceful protests near religious institutions, and place expressive freedom in the hands of law enforcement officers who are already struggling and will continue to struggle to distinguish political slogans from criminal acts. And so, Mr. Chair, this approach undermines the very compromises that our courts and parliaments have worked to maintain. Instead of strengthening social cohesion, it risks deepening division by criminalizing speech rather than confronting hatred through democratic debate, education, and community resilience. And, you know, when we forget our history in this country, when we don't want to listen to it, when we want to go for the soundbite and the social media thing today, it makes it difficult. And I just want to I'm working towards the end of my remarks, but I want to emphasize that the religious defense has never been a blank check in this country. Courts have been very clear here that good faith has always meant sincerity. It has always meant that the purpose of the expression has to be to explain, interpret, or discuss a religious subject, not to demean or target an identifiable group. Judges, and I've been an adjudicator myself, and I've been in a position where I've been able to mentor other adjudicators and to learn from them. And I can tell you that judges do examine tone, context, and intent. They look for, in these kinds of circumstances, they look for whether the speaker is genuinely engaged in religious expression or whether they're attempting to use religion as a shield for conduct that the criminal law seeks to prohibit. It reinforces the balance that Parliament seeks to maintain. We have a system that's working. And if we step back and consider that broad historical arc, we can see how consistent Canada's approach has been up until this point. From Indigenous traditions that recognize personal conscience, to colonial debates over denominational schools, to charter jurisprudence, to modern discussions of hate propaganda, the underlying principle of this debate has always been the same. It has been that the state has to remain neutral. It must not impose belief, but it also cannot suppress belief that is expressed in good faith. And at the same time, we have managed, at least up until recently, when enforcement has become a real problem, to protect our citizens from hate and discrimination. So that defense of sincerely held religious belief exists. because Parliament, the very institution that we are a part of and that we're expressing ourselves through today through committee, because Parliament recognized that hate propaganda laws, which do serve an important purpose, must not inadvertently undermine the freedoms that define our democracy. So the separation of church and state is not traditionally listed, of course, as one of the principles of natural justice, which in the common law is focused on procedural fairness. But natural justice addresses how decisions must be made, not how the institutions of the state must be structured. Its core principles are the right to be heard and the right to an impartial, unbiased decision maker. These rules exist to ensure that government acts fairly, transparently, and without favor, and don't prescribe a particular constitutional arrangements between religious and institutions and civil authority. And it's very important that we keep it that way. So, as we continue to work in committee, it's worth remembering that Parliament has revisited this issue many times, and that the legacy of the separation of church and state in Canada is actually the foundation upon which the religious defense in Section 319 rests. It is a legacy of balance, Mr. Chair, a legacy of restraint and respect for pluralism, and it is a legacy that takes into account the rich history of this country that helps us understand why the defense was created, why it has been preserved, and why it remains an essential part of the criminal code. It also helps explain why I have received so much email, so many phone calls, and so many texts and other messages about this bill and these provisions. People are genuinely offended that the Bloc and the Liberals have made this deal to remove protection for religious freedoms in this context, and I urge the members of this committee to heed their sentiments. Thank you, Chair. I am done.
Thank you. That's a tough act to follow, but Mr. Gill, it's up to you.
I'd love to speak. Thank you, Chair. So we are hearing our point of view on religious freedom and freedom of expression, and I'll tell you, thank you for the opportunity to speak in length. And I'm going to mention this because to avoid unnecessary point of orders that I'm talking about Class 4, a bill and the amendment which my colleague has presented here. And yes, and just to start with, I will read the amendment as well, that nothing in this section is to be interpreted or applied so as to interfere with the freedom of expression or the freedom of religion. And we all know that freedom of religion or freedom of expression cannot be attacked. Canadians must remain free to worship, teach, and share Scripture without fear of charges. Sacred texts are foundational to our cultural identity. Criminalizing them is unacceptable. What my colleague has mentioned, that it seems like that there is a political deal. The report confirms that the Liberal government struck a deal with Bloc Québécois to secure support for Bill C-9 by removing this safeguard. In real-world consequences, if you are going to see, we will see that whether it's pastors, imams, or priests could face charges for teaching traditional doctrine. This amendment goes to a very heart of what Parliament is supposed to do, protect Canadians while preserving their fundamental freedom. It should not be controversial. It should not be partisan. And yet, here we are debating on this issue. And we all know that we don't want hate crime or any other crime. We are against those ones. It is necessary to explicitly protect freedoms that are already guaranteed under the Canadian Charter of Rights and Freedom. Conservatives believe this language is essential, not optional. And I will tell you by going through these things, this amendment is not about fighting hate. It's about criminalizing scripture. So we have to deal with it. Canada is a free democratic society. That freedom does not flow from government permission. It flows from the inherent rights of individuals. Rights the state is obligated to respect, not redefine or weaken through vague legislations. Freedom of expression or freedom of religion are not.
Sorry, Mr. Gill, I'm going to interrupt you. Your own colleagues don't seem too interested in listening to you because they're all talking, so I'm going to ask if people can just keep the comments down in the back, so Mr. Gill has the floor.
Okay. Freedom of expression and freedom of religion are not abstract legal concepts. They are lived realities for millions of Canadians, for people of faith, for cultural communities, for newcomers, for parents, for teachers, and for anyone who dares to express an opinion that may not align with the views of the government of the day. Clause 4, as currently drafted, expands criminal code provisions around mischief and intimidation relating to places of worship, schools, and community institutions. Conservatives agree that vandalism, threats, harassment, and violence against these spaces are reprehensible, that must be punished. There is no disagreement there, but the concern, and it is a serious one, is that poorly defined language combined with an activist enforcement culture can lead to unintended consequences. And when it comes to criminal law, unintended consequences are not academic, they affect real lives. Religious leaders are already under pressure to navigate complex social issues. These amendments add the risk of criminal charges simply for quoting scriptures. Sermons and Friday prayers could be scrutinized by prosecutors. This is unprecedented in Canadian history. Parents and families are going to be worried. Teaching their children scriptures at home could be accused of promoting hatred. Family traditions of reading sacred texts together could be chilled by fear of legal consequences. Digital age concern is also there. The bill's publicly display provisions could extend to digital platforms. Posting scriptures on Facebook, YouTube, or TikTok could be treated as a criminal act. Faith communities rely on live streams and online teachings. This amendment risks criminalizing those practices. Even Charter of Rights guarantee freedom of conscience, religion, thoughts, belief, opinions, and expression. Removing the exemption undermines these rights and invites constitutional challenges. Canadians should not have to fight in court to defend their right to read scripture. Mr. Chair, I would like to say this. It ensures that Clause 4 cannot be interpreted in a way that chills speeches, punishes beliefs, or interferes with religious practice that is peaceful and lawful. Canadians are already uneasy. They see professors disciplined for unpopular opinions. They see faith leaders dragged into legal battles. They see protesters treated differently depending on whether their message aligns with the government narrative. This amendment says plainly expressing beliefs, even strong ones, even uncomfortable ones, is not a crime. Preaching a faith-based view is not criminal mischief. Peaceful protest is not intimidation. Public debate is not hatred. If the government truly believes that these are the things that are necessary, then I would say government need to think, we as a legislators need to think about all these things The language in this bill as currently drafted risks blurring the links between criminal conduct and lawful expressions. Canadians are increasingly worried that expressing sincere held beliefs, whether religious, moral, or cultural, could be interpreted by the state as harmful or criminal.
Point of order. This member's extended remark risks mischaracterizing the amendment.
Say it again.
How is I forgot something to say like expressing your.
Do you have a point of order? You have to make a point of order. You don't have to ask point of order.
Hold on. I will not tolerate people mocking somebody's ability to speak a language at this committee.
Oh, that's
what just happened.
That is not what happened. That's not what happened. That is not
Anyway,
what happened.
Mr. Chang?
Speaking of privilege, are you going to rule on the previous question of
I've
privilege?
taken it under advisement. You can keep asking until you're blue in the face. I'll get back, you'll get an answer at the appropriate time.
Yeah. This member's remark was not speaking to the amendment. Not at all.
Is it a point of order?
No, carry on.
Point of order is relevance.
Yeah, that's relevance.
Yeah.
Make the point.
All right, thank you, Mr. Chang. Again, this is a theme that's come up over and over again tonight. If we could try to stay focused. You started out well, Mr. Gill, by saying what the amendment was, and that's what we're going to be talking about, which is more than I can say about some other people who have spoken tonight. But if we could try to keep it focused, we'd all be grateful. Thank you.
I'll take your advice as a consideration, but let me finish. So my other colleagues can start speaking as well. So I would say one thing. Legislation does not exist in a vacuum. It operates within a culture, and right now that culture is increasingly hostile to dissent. That is why we as a conservative insist on clarity. When laws are vague, enforcements become subjective. When enforcements become subjective, freedoms become conditional. This amendment says plainly expressing beliefs, even strong ones, even comfortable ones, is not a crime. And preaching a faith-based view is not criminal mischief. Peaceful protest is not intimidation. And I cede my time now. Thank you so much.
Thank you very much, Mr. Gill. Okay, Mr. Bexley.
Thank you, Chair, very much. I appreciate the opportunity to speak. I'm not a regular member at this committee, but nonetheless a member, and I appreciate the ability to exercise my privilege.
Thank you for joining us.
Thank you to the witnesses for bearing this out tonight and keeping your attention wrapped. And I'll do some work here to see if we can engage you in this process. I want to make it very clear that I want to talk to the committee today about Bill C-9, and which, if passed with Amendment BQ3 alone, would strip away long-standing protections for freedom of expression and religious liberty in this country. You know, this goes directly to supporting the amendment by my colleague Andrew Lawton in this latest amendment. This bill represents the most significant assault on Canadians' ability to speak openly about their faith, perhaps since the Charter was written. And it comes at an especially telling moment. And I can't tell if this is ironic or disturbing or deliberate or accidental. But during the Advent season, and at a time when Christians reflect on Scripture, hope, and the coming of Christ, we've witnessed the astonishing spectacle of the previous Liberal Justice Committee chair declaring that parts of the Bible and the Torah contain clear hatred. He singled out Leviticus, Deuteronomy, and Romans, and that is not a random commentator. That was the individual responsible for overseeing the Justice Committee, and just last week he was promoted to Cabinet as the Minister responsible for Canadian identity and culture. Only this Liberal government would reward someone for asserting, essentially, that God himself is hateful. I would encourage the new minister to revisit the preamble of the Charter of Rights and Freedoms, which affirms that Canada is founded upon principles recognizing the supremacy of God and the rule of law, as well as our national anthem, that God keep our land glorious and free. The Liberal government frequently boasts about defending the Charter, yet they conveniently ignore the Charter's protections for freedom of religion and expression, as well as its own explicit acknowledgement of God in the preamble and the national anthem. This hypocrisy is the backdrop of everything in Bill C-9. At the center of this bill is a political deal between the Liberals and the Bloc Québécois. In exchange for the Bloc's support, the Liberals have agreed to eliminate long-standing criminal code safeguards, namely sections 3193B, 319 3.1b, that protect Canadians from being prosecuted for, in good faith, expressing an argument on a religious subject or a belief rooted in sacred text. These protections are not loopholes. They are constitutional guardrails upheld by the Supreme Court and ensuring that Canada's hate speech provisions remain consistent within the Charter. My colleagues before me have gone to great lengths and with great eloquence, far more eloquence than I could muster, to express this point quite poignantly. But the Liberals and the Bloc want to tear these protections out by the roots. The Bloc justifies this change by referencing a single case. Montreal Imam Adil Shakouri Imam, who in 2023 used a prayer to call for the extermination of Jews. This is abhorrent. His statements were vile and deeply anti-Semitic. But the simple truth is that what he said was already illegal. Illegal under Section 318 for advocating genocide and under 3191 for public incitement of hatred. This is another example of the government failing to act and failing to execute on laws that already exist on the books in the protection of Canadians and their fundamental rights. The religious text defense does not apply to either provision, and there is absolutely no evidence prosecutors declined to charge him because of that defense. The only reason he was not charged is because authorities failed to enforce the law. This is unbelievable. Instead of fixing that enforcement gap, the Liberals and the Bloc have chosen to target law-abiding religious Canadians. That is hypocrisy of the highest order, especially as they claim this bill is meant to protect the very communities it would most deeply wound. For nearly a decade, this government has repeatedly marginalized Canadians of faith. They've attempted to strip charitable status from religious charities and pro-life organizations. They imposed the Canada Summer Jobs Values Test, punishing groups that refuse to renounce their core religious beliefs. And this is unbelievable and unconscionable. I will note that this ideological overreach is not new. In fact, in an early 2022 report from an advisory panel to the Department of National Defence, recommended that Canadian Armed Forces not employ chaplains whose religious traditions do not align with the government's ever-shifting vision of equality and inclusion. And this panel singled out the entire Abrahamic faith traditions. Those traditions that reserve priesthood for men and those that believe in the traditional view of marriage as being incompatible with serving in the military. Think about that. Really, we need as legislators to think about this. That a government that claims to champion diversity and inclusion was actively entertaining the exclusion of religious Canadians from serving as chaplains precisely because of their beliefs. Shameful. This is not tolerance, it is blatant liberal double standard. Diversity is celebrated only when it mirrors the government's ideology, and the Charter of Rights millions of Canadians are dismissed as an inconvenience. Now, Bill C-9 directly targets their freedom of expression. Yet the Liberals still claim to be the party of the Charter, even as they systematically attack the very freedoms the Charter guarantees. And we're getting close to the part where we engage the witnesses. Witnesses who appeared before Justice Committee debunked the Liberals' claim entirely. Numerous constitutional experts explained that the religious text defense is narrow, specific, and constitutionally necessary. It is not a blanket protection. It applies only to good faith expressions of sincerely held religious belief, not to violence, not to incitement, not to hatred. The courts have been clear on this point for decades. But Liberals now believe they know better than the constitutional jurisprudence and better than every witness who testified before them. Their ideological agenda matters more than evidence or constitutional balance. If C9 passes, the consequences will be severe. And I have a question for Liberal and Bloc members of this committee. Would a priest reading the scheduled Sunday Mass, a reading set years in advance, face persecution or prosecution if the passage is deemed offensive?
No.
Would a rabbi teaching Torah commentary, a Muslim parent quoting the Quran to explain moral teaching, could a Sikh, a Hindu, or a Buddhist teachers be targeted simply for articulating traditional beliefs?
No.
Any person of faith quoting their sacred text could face up to 2 years in prison if the government or a prosecutor finds their belief objectionable. In a country like Canada, home to such rich religious diversity, this is chilling. A free society debates and engages. It does not imprison people for sincerely held religious convictions. The Liberals insist their bill protects religious Canadians from hate, while simultaneously displaying a deep disdain for religious communities who express views different from their own, and this contradiction is staggering. Let us also remember the historical context the Liberals prefer to ignore. It was a Conservative government led by John Diefenbaker that first enshrined these fundamental freedoms into Canadian law through the Bill of Rights. The very criminal code the Liberals are rewriting was drafted by Sir John Thompson, a devout Catholic and Conservative Prime Minister who understood the criminal law must restrain real harm, not police belief or censor sacred texts. He even initially declined to become Prime Minister due to the intense sectarian hatred of his time after converting to the Catholic faith. But today's Liberals lecture Canadians about rights while gutting the rights that Conservatives and historically even Liberals worked hard to establish and protect. Removing the religious expression safeguard in Section 319 will not make Canadians safer. It will not stop real hate. Genuine incitement and advocacy of genocide are already illegal, will remain illegal, and must be prosecuted by the system that already exists. This bill will succeed in one area, though. It will expose millions of peaceful, law-abiding people of faith to criminal prosecution simply for quoting scripture or expressing long-held religious convictions. This is chilling. That is not who Canada is supposed to be. It is not constitutional, it is not just, and it is not worthy of a free society. I urge every member of this committee to accept the amendment from my learned colleague and defend the freedoms of religion, expression, and conscience that form the foundation of our democracy. The Liberals may have forgotten these principles, but Canadians haven't. And I have one question for the witnesses. That if passed in this restrictive form right now, the government has made, and the government side and the Liberals and the Bloc have made great statements to the fact that it doesn't matter, right, that the Charter exists, that there won't be prosecutions. But could the government use the notwithstanding clause to maintain enforcement, even though we have been assured that we need not worry about this infringement because of freedoms found in the Charter? And I would love to hear a comment from all three of you.
Thank you for the question, Chair. So I can speak generally to the requirements of Section 33 of the Charter, which is that a declaration, if made, must be done expressly by the legislature under this section in order to have the effect that such operation of the Charter rights would not apply but for, that the declaration must be done expressly would apply for only sections 7 to 15 of the Charter, and would apply only for 5 years. So it's my understanding that the federal government has never invoked the notwithstanding clause, but those are the requirements of form in terms of the declaration needing to be specific by the legislature.
I don't have anything to add to what my colleague Ms. Ali has said on the scope of Section 33 of the Charter. I don't know if there was another question.
It was the same question. All witnesses, you know, that could the notwithstanding clause be used to defend C9 in its current form prior to the amendment from my colleague across the way, if it was struck down by the court?
I think what I can say is that there's nothing in the bill as introduced that suggests that the government intended to invoke Section 33 of the Charter.
I understand that. But if this is enacted and proclaimed, and then subsequently found to be not constitutional by the court, could the government use the notwithstanding clause to maintain enforcement?
We're here to speak tonight about what is in C9 and the impact of the amendments that are before the committee, but not to opine on what would happen, what the government might do in a situation where a law is struck down. That is not the role of a Justice Department official. So thank you.
Okay, thank you. At least I got you speaking, right? So I appreciate that. I want to close a little bit with some commentary that I've been contacted by numerous faith leaders in my riding over the previous few days. And I find it very hard to express how deeply afraid they are of where this might go and what this portends for their faith, for their traditions, and for their how the chilling effect has fallen on top of them at the beginning of the Christmas season. And so I want all members to think very deeply into their souls on what this portends. And with that, Chair, I cede my time.
Thank you. We are Mr. Jackson. Don't make me miss Larry McGuire even more than I
No,
already do.
Chair, I would never
could you
do
just
that.
read the list before we, would you mind reading
never
the
do
list
that.
out before we go on to the next member?
You're on the list.
But just what is the list? Can we know?
The list of us, it's a long list. Go ahead, Mr. Jackson.
So if you're not willing to do that?
Do you really want to read who's on the list? Okay, it's Mr. Rowe, Janice, Lawton, Holman, sorry, Kurt, Goodrich, Jensen, Mantle, Brock. Does that make you feel better?
It's not about how I
Mr.
feel, Chair. It's
Jackson,
just
over to you.
about being kept informed of what's happening during proceedings. Thank you for doing your job. I appreciate it.
Thank you, Mr. Chair. I'm sure my predecessor is looking fondly on our interaction today. He may even be watching. Who knows? He is a bit of a political animal. Actually, Chair, I wanted to start with a bit of a procedural question that I have for you as I am new here. Not long ago, although a little bit of time has passed, I didn't want to interrupt my colleagues. An individual approached the table and took a picture of the proceeding here. And then he went and sat down, and I noticed someone from the Liberal staff team went up to the individual and asked him, I'm assuming asked him to delete it, although I did not hear that. That individual has now left the room. I had to Google him to find out who he is, and I believe it was John Paul Danko, who is a member of Parliament, and that individual has now left the room. It was quite obvious to me that he was holding his cell phone sideways, right here at this angle of the table. And so I just want to make sure, Chair, that you would investigate this and ensure that photo was in fact deleted. I would hate to see it on social media, and knowing that this was a member of Parliament that did it is deeply concerning because that is against our rules. So I just wonder if you would investigate that and report back.
Thank you, Mr. Jackson. I wasn't aware of that. It is not allowed. It may have happened during the time when we were suspended, which we were suspended a number of times. Anyway, I will look into it. I'll find out about it. If it did, in fact, happen, I'll make sure the picture's deleted.
Okay, thank you very much, Mr. Chair. Secondly, I do have a copy of Mr. Lawton's amendment here, so I just want to make sure I'm going to stay as best I can on topic to that, Chair. Listen, I have been astounded by the debate since Bill C9 was introduced, and just the general direction that the Liberal government has decided to go on this. Like, as a relatively new member of Parliament, you know, I don't speak loudly about faith often, or my faith in particular, but I certainly, am a person of faith, and the outpouring of deep concern regarding this bill has been, well, I haven't seen anything quite like it since I was elected, certainly. And, some of the most, different faiths are more politically active than others, I would say. And that's okay. That's their right to certainly participate in that, in politics or in commentary on the issues of the day. But we've got a joint statement here, Chair, and I'm not sure if the committee's received it, signed by a number of multi-faith organization and civil liberties organizations. It was dated December 1st. And it is certainly calling for, I could read the whole thing. We, the undersigned multi-faith civil liberties and community organizations, collectively reject Bill C-9, an act to amend the criminal code, the so-called Combating Hate Act. They further write, as Bill C-9 proceeds through the parliamentary process, we emphasize that this bill shouldn't be passed. The risks it poses to protest rights, labor rights, and public accountability are too serious and too far-reaching. Bill C-9, far from protecting communities, criminalizes protest, suppresses dissent, and expands police discretionary power at a time when over-policing, surveillance, and disproportionate targeting of racialized communities are already well documented. They also, our demands, with number one, withdraw Bill C-9 in its entirety, number one. Number two, affirm the right to protest as a cornerstone of Canadian democracy. Number three, end the expansion of police powers and discretionary authority, protect communities, not institutions. And number four, commit to evidence-based approaches to addressing hate. It goes on and on for some time. It's two full pages there. I won't read the whole thing, Chair, I promise. But the reason why this really stood out to me, I was raised in the United Church of Canada. Some of my fellow Christians like to call us Christian light, affectionately. Sometimes it's affectionate, sometimes it isn't. And that's okay. We take that quite well as members of the United Church in this country, based on, of course, the Methodist faith. And we don't, the United Church of Canada is one of the most center-left politics, and they weigh into politics all the time as a central organization for the church, always supporting liberals, and sometimes even going further to the left of the spectrum of that. And I often have debates with people within my own church community and our faith leadership about why our church chooses to be so public about their political views and why they're always with the liberals and not on the left. Even they, Mr. Chair, have signed this statement asking for this bill to be pulled out. It's that bad that, the liberals have even managed to tick off us nice folks in the United Church. I don't understand how the Liberal Party could be so off base with this bill that they have lost their biggest advocate in the faith community, which is, in fact, the leadership of my own church. Part of the foundational principle of our church under John Wesley is, the famous quote, now made famous by Hillary Clinton, something that won't endear me to my conservative colleagues on her election campaign for president in 2016, but who could say no to Morgan Freeman's voice, is do all the good you can, by all the means you can, in all the ways you can, in all the places you can, for all the people you can, as long as ever you can. And yet, even the United Church is saying this is not the right path to do that, folks. You need to pull this bill back and have a sit-down. Have a sit-down with the Center for Free Expression, the Independent Jewish Voices, the Canadian Muslim Public Affairs Council, the Canadians for Justice and Peace in the Middle East, the Chinese Canadian National Council Toronto chapter. Like, it goes on and on. The signatories to this statement saying that this bill is an abject failure. It's a total disaster. And these are people with very different political views on every topic that matters, except for this one. Here they agree that this and their faiths are all at risk by this piece of legislation that has been made worse tonight by the Bloc Liberal Separatist Coalition. And like, I just don't, I really have a hard time, I'm going to have a really hard time going home and justifying to my constituents in rural Manitoba how this is supposed to make their life better. I really don't see it, because you've got all the experts saying that this is in fact going to make life much, much worse. And, you know, I'm still not really sure what this is going to achieve. Like, I've heard from the experts. I'm filling in for Mr. Baber now. I was here before that. They've already admitted on the record that all the serious crimes that can be done and have been done are already a crime. It's already criminal to incite violence against a criminal. It's already in the criminal code to incite violence against another religious group based on their religion, as well as any other matter of factors when you're trying to incite violence against a particular group in this country. And so what exactly does this achieve? I've yet to hear an answer. You know, we had some Liberal members trying to answer questions when they, of course, didn't have to be on the record about it. I don't know, anybody want to answer that question? Like, how is this actually going to make it better than what's already illegal to do in this country? We are. We are talking about another amendment, an amendment that's supposed to protect people, right, from the impact of this bill, which is an overreach. So I'll move on, Mr. Chair, but I am deeply concerned about that. You know, I think there are people in this country, there are a few still left, although they're getting fewer, that went, you know, in the course of a world war and in peacekeeping missions, and they fought to defend these freedoms that this country stands for and that our allies around the world stand for. Freedom to believe what you want to believe and to believe in any religion and any faith. You know, my grandfather's a Second World War veteran. He left the farm in Margaret, Manitoba, population 100, and went to fight for freedoms against hateful people. So it's not that conservatives are opposed to this bill because we're all of a sudden wanting hateful acts and hateful language to continue to get spread all over this country. Like, that's exactly the opposite of what we believe. And you know, I think the vast majority of my constituents would expect me, though, to be here standing up for their freedom to believe what they want to believe, and that they and generations before us from our region have put their lives on the line to defend that, not just in this country, but around the world, for religions that they didn't even know or understand at the time that they were getting on a boat and shipping over there. And so for this now, you know, it's shocking to me that we have a group that wants to, you know, remove these types of freedoms and protections in our society. I think Mr. Lawton has an important amendment here that really is trying to at least balance what is happening. And you know, I think Mr. Baber and Ms. Cronus also brought important context to light when they were sharing their deep legal understanding of the law, being both practitioners of it themselves. Of course, our shadow minister, Mr. Brock, as well. These are folks that understand this deeply, and I think probably more deeply than maybe even some of the Liberal members. But I digress, Mr. Chair. I really do want to stress the fact that Manitobans understand standing up against hateful acts. We've seen challenges with, you know, ethnic communities in Winnipeg being targeted by hateful acts, particularly with the rise of the conflict in the Middle East. Hateful protests outside the Jewish Folklorama Pavilion, where people take their kids to celebrate faith. I mean, Manitobans are not strangers or isolated from these activities that are disturbingly going on in our country. We see them, but we believe that the provisions to protect Canadians from these actions already exist in Canadian statutes and in Canadian law. We have a problem with enforcement in this country, which, you know, is a problem that stems across many different types of crimes, thanks to Liberal government over the last 10 years. And this is just another example of a failure to enforce and prosecute existing laws that already exist. So I would encourage the Liberals to pull back on this bill, abandon their partnership with the Bloc, which shouldn't really have to be said, but apparently it does in this context, and rethink this, because, you know, I think we really need to make sure that this country, by the way, the generation that fought for these freedoms in other countries came back after the Great Wars and said, we need to solve this problem on our own. Like, we need to make sure that these things that we just went and fought a war over to protect can't happen here, which is why you got the Bill of Rights, like a colleague mentioned, and why the Charter was patriated, and it came back to Canada, and all of these provisions were added to protect the freedoms that Canadians deserve, and they were brought here onto Canadian soil and into Canadian law. I don't understand why the Liberals are trying to find a problem where none exists. We have a lot of problems facing this country, as I have learned very quickly since getting elected to the federal level. There are a lot of challenges, but the state policing the religious beliefs of its people, like, that's something that we leave to, well, other countries around the world, some of which the new Prime Minister seemingly gets along very well with and spends a lot of time flying around the world to see and discuss with, and maybe there's some commonalities there, I don't know. I'll leave that up to him to justify to his constituents in Nepean and across the rest of the country. But the fact is that those principles have no place here. They don't belong in this country, and that's why Mr. Lawton's amendment should pass, because it really does strengthen a terrible act, but it makes some improvement in as limited a fashion as is possible, given the deeply flawed nature of the original draft. You know, I think it's heartening to see that at least within our Conservative team, which is made up of members of Parliament from many faiths, of which many are around this table, and many of which I am proud and pleased to serve in this Parliament with, that we are at least unified in hearing from the communities that we represent, that where the Liberals are going with this, what they're proposing to do with it is wrong, and that Canadians will not stand for it. And so I appreciate, Chair, that you've mentioned that there's resources to discuss this further for the rest of the week. I think that's important, because Canadians have a lot of concerns. There's a lot of use to share. I have gotten, literally, this is like the first, you know, discussion point publicly that I've had hundreds of calls on from people from Brandon's longest religions, First Baptist Church, just celebrated their 140th anniversary in the city, to members of the community who just opened the very first Gurdwara in Brandon's history just earlier this year. And unified, they are reaching out to me with deep, deep concern and fear, suggesting that this bill in fact reflects bills that came into force in countries that they purposefully fled to Canada to avoid. And now they're seeing it reflected here in the Canadian Parliament. And so to my Liberal colleagues, I will end with this and reprieve the committee of further Grant Jackson interventions for now. But well, thank you, colleagues. It's very, you know, I appreciate it. Flattering. Deeply flattering. I noticed the chair didn't join in. You know, maybe next time I'll try harder, Chair.
I smiled.
Oh, thank you. Appreciate that very much. So, you know, to my Liberal colleagues, I ask that, given everything that's going on in this country, for young people, for seniors, for actual criminals and actual victims of crime, can we not take a reprieve from this bill and get on with the business of locking up criminals, of bringing safety back to our streets that is not being infringed upon by preachers and other religious figures and just general people trying to get an understanding of faith? Can we not get back to dealing with real criminals, to lock people up, bring back safety to our streets? Let's put the people of this country first, do all the good we can for as many people we can, as quickly as we can, and I am sure that this committee will still be here to deal with this ridiculous bill when we have achieved some actual results to make communities safer in this country. Thank you, Mr. Chair.
Thank you, Mr. Jackson. I'm going to suspend for 5 minutes, and then we're going to come back with Mr. Rowe. resume the meeting. Mr. Rowe, over to you.
Point of order.
Sure.
Thank you, Mr. Chair. Earlier, my comments from my colleague, Mr. Jackson, he made some very concerning comments regarding somebody potentially doing something that is very much against our rules in this committee. And so I'm just wondering, I know you are holding back on providing any kind of guidance on the point of privilege from my colleague, Mr. Genis, but perhaps could we have an update on that? Like, this is very serious. People are not allowed to take photos of these proceedings. And so if a photo was taken, has it been deleted and deleted from the deleted file? And do we have assurances from the WIP's office?
First of all, I'm not holding back on anything. I took Mr. Genis's point under advisement earlier. On the point regarding the picture, I take this very seriously, as I did then and I do now, but you know where I've been sitting since the issue was raised half an hour ago, and I have somebody looking into it, and I'll let you know as soon as I find out. So, Mr. Rowe, over to you.
Yeah, but before I get into it, I think this is a point of order as well. There was an accusation made to a Conservative colleague that he was making fun of someone's language here. It was very evident that we were, having a discussion about the merit of the conversation and the debate, and I think it was very insulting to both my colleague and Wade Chang here, who speaks better English than many people, probably than myself, right? And his perfect English, and I think it was insulting to even say that we were making fun of his English when he speaks perfect English. And I think that that kind of language is not appropriate, and those are big accusations to be made towards members at this table. And I will continue on, whether it was a point of order or not.
I take your comments very seriously, and as the point I made earlier, I take that very seriously. And if I see you or any other member in this committee, whether it's on your side or the Liberal side, I will address it. I saw what I saw. We can review the tapes. Let's move on. I understand your point. Thank you.
Okay, but point of order, Mr. Chair. On the question of whether this photo does or does not exist, whether it has or has not been, we just got back from being gavelled. I am very concerned. This allegation was brought up at least 15, 20 minutes ago. You're telling me that no one from the Liberal Whip's office has been able to
investigated.
get
I've been sitting in this chair.
the
I went to
information
the
and get it
bathroom
back
on the
to you.
break. I will give you an answer as soon as I have one. I have more than one person looking into it. Raising the point over and over again isn't going to accelerate the process. Mr. Rowe, the floor is yours.
Well, thank you, Mr. Chair. I've been the last few hours and few days trying to get words to paper on this issue, and it has been challenging because it's so frustrating. My leads and my pencil keep breaking. And there's this, it's so frustrating because you've got to ask yourself why. You know, as my friend Grant Jackson mentioned, our ancestors fought for freedom of religion. They went overseas and they fought. They were in the trenches, shoulder to shoulder fighting. And it was alluded by some members of the Liberal caucus that we may be here during Christmas and over the holidays. And I think they said it sarcastically, maybe they never. But, you know, if that's what it takes to make sure that we're fighting for freedom of religion, I know I'll be here. And I'm willing to bet there's going to be 3 or 4 or half a dozen, and maybe even dozens of Conservatives that will be here shoulder to shoulder with me, because it's the least we can do out of respect of our ancestors, out of respect for all Canadians and all people in the world who fought for freedom of religion, and we will continue to do that. And I know I will be here come hell or high water. You know, it's very strange. I'm not here to argue, although my passion may seem that. I'm here to try to bring some reason. When C9 was introduced, I would ask myself, what's the purpose of this bill? It almost, is everything that the bill tried to do, current laws could already do. So it was very interesting. And it almost makes me wonder if this whole amendment backroom deal with the bloc was the actual intent to actually confuse Canadians so that they wouldn't understand what the amendment was, because the amendment wasn't released until later. And a lot of times things like this happen amongst confusion, and it's very difficult. So I'm hoping that we can make some clarifications and things, and I think we've made some clarifications tonight. And you may say, Jonathan, no, things are very clear. But we've got a situation where the PMO, Prime Minister's office, said that the committee went rogue and made a backroom deal with the bloc and gave Mark Miller, but yet they gave Mark Miller a promotion after saying the outrageous thing that the verse in the Bible should be considered hate speech. I mean, he alluded that he believes there are certain verses that could never be used in good faith. So after that comment was made, they promoted him to be a cabinet minister. How is that? How is that not in line? You would not promote someone that went rogue. So I find it very hard to believe that this was against the PMO's wishes. And then what we see here tonight is that block amendment was actually voted on. So if it was a rogue agreement against the PMO, why was it voted on yesterday? And to me, that shows the need of Mr. Lawton's amendment to make sure that religion of freedom is protected. And it's very, very important that that is. So I made a video and put it on my social media a while ago, sounding the alarm on C9 and the block amendment. And what was interesting was there was very much confusion and people saying, well, Jonathan, you're spreading conspiracies, you're spreading misinformation. And I'm thinking, gee, I wonder, am I? And I looked in the mirror and I had a hard conversation with myself. Maybe I'm in the conservative echo chamber. Maybe I'm on Parliament Hill every day and hearing, the circle of echo chamber. But then I see that we have 23 news articles. And pretty well every one of them is against C9 in one way or the other, or raising alerts about C9. So I don't think I'm in the echo chamber. And then I did manage to get this on paper, and I want to read it out. There are so many groups in Canada, the same groups that this bill C9 and the amendment, they say it's a Trojan horse. Oh, this bill is going to protect these groups, going to protect religious groups. The same religious groups that says it's going to protect are the ones coming out against it. I mean, we have a broad nationwide coalition of religious, civil liberties, labor, and community organizations have mobilized against C9 and the proposed removal of the religious text exemption. Among faith groups, dozens of Catholics, dioceses, and parishes, led by the Canadian Conference of Catholic Bishops, have issued coordinated calls to action joined by multiple Jewish and Sikh advocacy groups, and by 40-plus Muslim and Palestinian community organizations in joint statements, warning of threats to religious freedom and civil liberties. Multi-faith networks have also weighed in, with a cross-country coalition of more than 20 Christian, Muslim, Jewish, and secular justice organizations signing a unified appeal to halt the bill. Civil society opposition is equally extensive. A 37-organization civil liberties and legal coalition led by the BC Civil Liberties Association has condemned BC9 as a threat to protect rights, academic freedom, and due process, while national labor bodies, including major public sector unions, have warned that the bill will criminalize legitimate worker and community demonstrations. So it's just mind-blowing that this is not just conservatives waving the blowing the horn. This is the whole country is speaking out. And I would not want to. I don't know how you can get here in this committee and say that there's no need for Andrew Lawton's bill, for amendment to this bill. And then we see that they're talking two sides of the mouth. Oh, well, we don't need this. It's okay because it's protected under Charter of Rights and Freedoms. Well, if that's the case, if religion of freedom is protected by Charter of Freedom, why not have Andrew Lawton's bill introduced? And why take out the religious exemption to begin with? So I will leave it there for today. Maybe I'll come back another day and express some more concerns. But thank you very much, Chair, for having me.
All right, thank you. Back to Mr. Janis.
Well, thank you, Chair. I do have a lot that I want to say on this subject, but I am also so encouraged by the fact that we have 14 Conservative MPs that are here. It's after 10 o'clock here in Ottawa, and we have a committee needs 4 Conservatives at any given time. And I count around the table 14 Conservative MPs that have come out to fight for freedom of speech and freedom of religion. And I want to encourage folks at home that there are so many Conservatives, far more than need to be here, that want to be here to fight for your rights and your freedoms and to oppose this attack on religious liberty. So I've already spoken a bit tonight. I'm going to cede my time now because I want to hear what so many of these other great folks around the table have to say. But Chair, I'll ask you to re-add me to the list at the bottom. And also, if you can, before we go to the next member, give us an update on your deliberations on how the Justice Minister violated the privileges of this committee by leaking confidential information, and when you plan to make a decision on that. Thank you, Chair.
Thank you, Mr. Janis. Okay, who we have? Mr. Lawton. Sorry, I couldn't read the writing.
I think members of this committee will know that I think freedom of religion and freedom of expression are incredibly important issues. And I've said on the record, and I will say again, that Conservatives will stand firm and defend these fundamental liberties for as long as it takes. But I want to reiterate, in the interest of working across party lines, in the interest of collaboration, that we would much rather focus on issues that are not so divisive and toxic and, quite frankly, unconstitutional. We would love nothing more than to not have to debate my amendment to Bill C-9, that a specific carve-out is needed defending freedom of expression and freedom of religion. So at this time, I move to proceed to clause by clause, or move to consideration of Bill C-14, so this committee can do work that is far more relevant to Canadians in fixing the broken Liberal bail system.
Okay. What's the motion again, Mr. Lawton? Sorry.
We proceed to consideration of Bill C-14, the bail legislation.
It's a dilatory motion, so yes. Over to you.
Everybody here just
Ms. Latancio? I'd like to continue on C9, so my vote is no. Mr. Chang?
No.
Madame Dillon?
No.
Mr. Housefather?
No.
Mr. Jackson?
Yes.
Who's he here for?
He's here for Baber.
He's here for.
Yeah. Mr. Brock?
This is exactly what Canadians want. My vote is absolutely yes.
Mr. Gill?
I would say strong yes to this because C-14 is very important and this is what we need to do at this point.
Mr. Lawton?
We need to fix the bail system. I vote yes.
Monsieur Fortin?
No. Okay, so Mr. Lawton, thank you. So we're now on to Mr. Holman.
Thank you, Mr. Chair. First of all, I would like to just say I speak here in honor on behalf of the people of London Fanshawe, but also for all Canadians, as attacks on freedoms is detriment to the democracy we live in as we speak. When there is concerns with regards to the freedom of religion and freedom of expression on the table, I, like my Conservative colleagues, will stand up shoulder to shoulder to defend the freedoms that all of our Canadians do not take for granted, but we do take it as part of the day-to-day process of being Canadians. With regards about myself, yes, I was recently elected as Member of Parliament for London Fanshawe back in April of this year, 2025. But I come from a small town of Forest, Ontario, in between London, Ontario, and Sarnia, and it is a population of 2,800. Forest is famous for being the oldest running movie theater in the world. It was opened in 1917, just before the age of the talkies, and the reason I bring up the opening age of 1917 is, yes, it was Canada then, and we had the freedom of religion. Fast forward to 2025, and now there's concerns at this committee where we will lose aspects of freedom of religion and also freedom of expression. On top of that, growing in a small town, I went to an elementary school, a Catholic elementary school, where yes, it was a Catholic elementary school, but we did learn the various religions that are in modern Canadian culture even to today. Various Christian religions, Catholicism, baptism, Anglicanism, the United Church that my fellow colleague MP Jackson mentioned. There's also religions of Muslims, Sikhs, Hindus, Buddhists, etc., etc. And now we stand here at this committee with concerns about those religious freedoms. And that is why I'm speaking here with the concern regarding Bill C-9 and the block amendment of BQ3 and the attack of freedom of religion and freedom of expression. The concern that people of faith could be imprisoned for expressing deeply held religious beliefs that the government finds offensive. What the government may find offensive is so vague, it is alarming. That's it. Just whatever the government may find offensive. And so on that note, there's a few items that stand out. Though some may find these beliefs objectionable, old-fashioned, or even hateful, a free country does not criminalize the expression of sincerely held religious doctrines. 2, we debate. As a civil democracy, we debate people we disagree with, not silence or attest them. 3, the courts have been clear that violence and calls to violence are not and never have been protected as free expression and are not in good faith as the defense requires. And 4, this change will expose people of faith to criminal prosecution for the simple act of quoting their own sacred texts in person, in public, or online. I also want to share some testimony quotes that was shared with the committee. First of all, from Derek Ross, Executive Director of Christian Legal Fellowship. And he says, quote, "The courts have been very clear that one cannot simply embed a hateful message in a so-called prayer and expect to receive the benefit of that defense. The courts have specifically said that it is not permitted." Second quote, from Noah Shack, Chief Executive Officer, Center for Israel and Jewish Affairs. I'll just say that the jurisprudence is clear that the religion defense cannot be used as a Trojan horse to allow otherwise hateful speech to come through. And another statement on regards of Imam Adil Chakari. He committed at least 2 offenses. There's the willful promotion of hatred against an identifiable group, and he has also committed the offense of inciting hatred against an identifiable group likely to lead to a breach of the peace. I heard the position was taken that he was expressing a view on a religious subject. That's nonsense. The defense would not be available to him. It wasn't made in good faith, and it was simply the willful promotion of hatred. That quote comes from Mark Sandler, one of Canada's most respected and prominent criminal lawyers. So additionally on that note, inciting violence from one person to another group or another person is part already embedded in the criminal code, not protected by freedom of religion. So with regard to this bill of C-9, why are we even here tonight? What is the point of this bill when the aspects that we're debating about is already part of the criminal code? And I also want to add, I've received many letters from my constituents in London Fanshawe, and I want to share one of the letters that was emailed to me. It was from a gentleman named Paul. It says, Bill C-9 represents an unacceptable assault on free expression in Canada. This bill would give the government the power to criminally prosecute Canadians for their opinions, lower the bar of what legally constitutes hate, quote unquote, and strip away vital safeguards that keep authorities from weaponizing laws against dissidents. It risks turning controversial memes into crimes and silencing open debate through fear of prosecution. As a constituent, I urge you to take a clear stand for freedom of expression and do everything in your power to stop Bill C-9 from becoming law. And to Paul, again, I am here at the Justice Committee. I'm agreeing with you that we have to defend the freedom of religion and we have to defend the freedom of expression. We, as in my conservative colleagues, standing up for these freedoms. And as I close, another concern I have is the Liberals and the Bloc going down a slippery slope, slowly taking away these freedoms. And I have to ask, what's next? It is December. It is the holiday season. Should we be concerned that the role of singing traditional Christmas songs, will that be viewed as hatred? Like, for example, the songs that we hear every year, such as O Holy Night, Hark the Herald Angels Sing, All Come All Ye Faithful. And I'm not talking about just Christian songs. Adam Sandler's Hanukkah song, which has been around for 30 years now. If I sing that, do I have to fear of being prosecuted, going to jail, going to prison? So I just want to end on saying I applaud my colleague, MP Lawton, for his amendment, and I'll say the amendment, quote the amendment, For section 6.1, nothing in this section is to be interpreted or applied so as to interfere with the freedom of expression or the freedom of religion, as myself and my fellow conservative colleagues are protecting as we sit here tonight. Thank you, Mr. Chair.
Thank you, Mr. Holman. Okay, Ms. Jansen.
Thank you, Mr. Chair. I must say I am disappointed that I have to be here to speak to the need for religious freedom protection. But I'm very thankful to my colleague, Mr. Lawton, for the amendment that he's put forward to actually protect that freedom of religious expression. There are days in Ottawa when the bills we debate come and go, barely remembered by the time we leave the committee room. And then there are days like today, days when the very soul of our country is at issue. Because what we're really dealing with right now is not a technical adjustment or a procedural tweak or a footnote in the justice system. What we're debating is whether Canadians should be free to speak from their conscience or whether that freedom can be stripped away because a government of the day finds those beliefs uncomfortable. Today's one of those moments that will be remembered long after the politics of the day have faded. A future generation will ask us what we did when they are going to ask us what we did when the freedom to speak one's faith was put at risk. Incredibly, the Liberals and the Bloc have struck a deal to remove key safeguards in the Criminal Code, safeguards that protect Canadians who speak in good faith about their religious beliefs. Safeguards the Supreme Court of Canada has already said are necessary to keep our hate speech laws constitutional. Necessary, not optional. After the amendment supported by the Liberals and the Bloc passed, we're now in a situation where key safeguards in the Criminal Code have been stripped away, safeguards that protected Canadians of faith. Those protections existed for a simple reason, because people of faith in this country hold deep, sincere beliefs about morality, about human nature, about right and wrong. And some Canadians agree with those beliefs, while others disagree. But in a free society, we debate ideas. We don't jail people for them. With the earlier amendment now adopted, the risk is real that people could be investigated and prosecuted, even face up to 2 years in prison, for simply quoting a verse from the Bible, the Torah, the Quran, the Guru Granth Sahib, the Vedas, or the teachings of Buddha. In other words, quoting the very scriptures that shaped their lives. Mr. Chair, this is not the Canada our grandparents built. This is not the Canada my family came to from the Netherlands after World War II, or the Canada generations of immigrants chose as their home because this country promised something rare in the world, freedom of conscience and freedom from religious violence. That's why Mr. Lawton's amendment is so important. His proposal would add a new subsection 6.1, making it clear that nothing in this section is to be interpreted or applied so as to interfere with the freedom of expression or the freedom of religion. This amendment doesn't undo all the damage of the previous change, but it does put a clear statutory road sign in front of prosecutors, judges, and police. When you apply this section, you must not trample freedom of expression and freedom of religion. It's a line in the sand that says, on the face of the law itself, that these charter rights still matter. Now, the Bloc and the Liberals have justified their earlier amendment by pointing to the case of the Montreal imam. In 2023, he prayed for the extermination of Jews. What he said was vile, anti-Semitic, and hateful. And it was already illegal. There's no religious defense for advocating genocide, and there is no religious defense for public incitement of hatred. The authorities could have charged him, should have charged him, and they failed to enforce the law. And that failure is now being used as an excuse to criminalize ordinary Canadians who simply express their faith sincerely. You don't fix one injustice by creating another. We're now left to mitigate the damage. Mr. Lawton's amendment is one of the only tools left to this committee to send a clear message that Parliament does not intend this section to be used to interfere with core freedoms. I want people to picture something for a moment. Imagine a mother standing at a school board meeting, reading a passage from her holy book, trying to explain a belief that her family has lived by for generations. Imagine a priest or a rabbi or an imam preaching a sermon drawn from their ancient texts. Imagine a Sikh leader explaining a teaching that's over 500 years old. Imagine a Hindu teacher quoting the Bhagavad Gita, imagine a Buddhist sharing the words of a sutra. In the wake of the amendment that's just passed, those Canadians are now looking to see whether Parliament will offer any reassurance, any guardrail at all, that they will not be treated as criminals for speaking from their own scriptures. This is what this amendment does. It doesn't solve every problem, but it tells them this section is not supposed to be used to interfere with your freedom of expression or your freedom of religion. What troubles me even more, Mr. Chair, is what was said in this very committee last week. The Liberal Chair, Mark Miller, looked at scriptures cherished by billions of people, the Bible, the Torah, and said there is clear hatred in them. He singled out Leviticus, Deuteronomy, Romans, and then he said prosecutors should be able to press charges when Canadians quote those books. Think about that. A senior Liberal in charge of shaping our laws believes quoting scripture should be grounds for criminal prosecution. If you want to understand why we need Mr. Lawton's amendment, it's exactly because those are the kinds of views that will guide how this law is interpreted. Without some explicit protection, we move toward a country where the government decides which verses from the Bible are acceptable, where the state chooses which teachings of the Quran may be spoken aloud, where prosecutors decide which parts of a sermon are safe and which are hate. Mr. Chair, when the state starts policing scripture, it's no longer protecting citizens, it's controlling them. We already see this pattern across the country. In Ontario and elsewhere, doctors with religious objections to euthanasia have effectively been told, violate your beliefs or leave medicine. In Quebec, the government has already banned many public employees from wearing religious symbols. Now they try to restrict public prayer in parks, revoking accreditation from religious schools, scrub religious symbols from communications. They say it's neutral, but neutrality that bans faith is not neutrality at all. It's state-imposed secularism. There's an old Dutch statesman and thinker named Abraham Kuyper who wrestled with this exact problem more than a century ago. How a diverse society protects freedoms when people don't all believe the same things. Kuyper would tell us something very uncomfortable for modern governments. There's no such thing as neutral regulation of speech. When the state claims neutrality, but quietly decides which beliefs are acceptable to express, it's not neutral at all. It's picking a side. Secularism, for all its polite language, is not an umpire. It's a worldview like any other. And when the state permits every ideology under the sun, political, cultural, even extreme, but suddenly tightens the rules when speech is rooted in faith, the problem isn't religion. The problem is honesty. A society that allows every belief except religious belief to speak freely is not pluralistic. It's selective, and it's pretending otherwise. True pluralism doesn't protect only comfortable speech or carefully edited convictions. It protects speech that's real, lived, sometimes unpopular, speech that actually costs something to say. That's the whole point of freedom of expression. And that's why we should all be cautious, very cautious, about vague hate speech laws that are untethered from objective harm. Because when freedom depends on saying the right things, it isn't freedom anymore. A government confident in a pluralistic society should not fear religious voices. It should trust Canadians enough to hear them and strong enough to govern them without silencing them. Here in this Parliament, instead of resisting that trend to prohibit free speech, the earlier amendment raced to meet it. Mr. Lawton's amendment is, at the very least, a way for this committee to say, we've gone too far, and we need to reaffirm in black and white that freedom of expression and freedom of religion still matters in this section. Let me say with the deepest conviction, when a government declares that faith must retreat behind closed doors, it shackles the soul of its own people. Imposed secularism is not neutrality. It is the state asserting its own creed, insisting that the wisdom of our past, our ancient writers, must change, allowing a single arrogant generation, which is a tiny slice of history of the world, to impose its small ideas on the past, present, and future of mankind. We ignore our ancestors' wisdom at our peril. History teaches us a hard truth. Time and again, we see that oppression comes dressed in the language of progress, safety, and uniformity. But beneath that language lies a quiet demand that the principles of the individual must bow down. It is the cold hand of power reaching into the conscience and soul of citizens, demanding obedience. And once that line is crossed, the state does not stop. It grows bolder. And a people who once spoke freely begin to whisper instead. When coercion enters the public square dressed as tolerance, we must speak with courage and clarity. Mr. Chair, witness after witness have told this committee that the good faith religious defense was narrow. It didn't protect extremists. It didn't protect violence. It didn't protect hatred. It simply protected sincere people of faith who speak honestly from their traditions. That fence has now been removed. The least we can do is build another safeguard, an interpretive safeguard that tells courts and prosecutors not to use this section to interfere with fundamental freedoms. I want my colleagues to understand this. Freedom of religion is not a niche freedom. It's not a private hobby. It's not something you do only in your home or your place of worship. For millions, it's the framework of their life. It's their moral compass. It's their sacred duty. It's the source of courage, forgiveness, charity, perseverance, hope. This safeguard has existed in law for decades. It's not some Harper-era carve-out. A Liberal-era parliament under Chrétien chose to expand, not shrink, the ability of people of faith to express good faith opinions based on their scriptures. Successive governments, including the current prime ministers, left that safeguard in place for 2 decades. No federal government, Liberal or Conservative, moved to repeal it until now. For the first time, a government is now not just enforcing hate speech laws in case of genuine extremism. It's stripping away the explicit protection for good faith expression rooted in religious texts in the criminal code's hate propaganda provision. This is a major shift. And if we're going to do something that serious, the very least we can do is adopt Mr. Lawton's amendment to signal that Parliament does not intend this section to be used to trample freedom of religion and expression. So, Chair, for all of these reasons, I support Mr. Lawton's amendment. It's not everything we wanted, but it's an important line of defense left to this committee. I would urge colleagues, whatever your party, whatever your ideology, whatever your personal beliefs, to ask yourselves a simple question. Do I want to live in a country where this section can be interpreted in a way that interferes with freedom of expression and freedom of religion? Or do I want the law itself to say that it must not be interpreted that way? If the answer is that you value those freedoms, then I would respectfully urge you to vote in favor of Mr. Lawton's amendment.
Thank you. Thank you, Ms. Jansen. Okay, now over to Mr. Mantle. Over to you.
Thank you, Mr. Chair, and thank you for the opportunity to speak to Mr. Lawton's amendment. I want to begin by saying, I come to this committee, and I think most come to this committee this evening with a shared goal of combating hate acts and acts that propagate or normalize hatred. I think that is a laudable goal. I think that is a goal that is shared by all parliamentarians, regardless of political stripe. But unfortunately, the amendment that was passed to Bill C-9, which Mr. Lawton's amendment seeks to undo rightfully, the Bloc and Liberal amendment doesn't do that. And that's why we need Mr. Lawton's amendment to bring us back to safety. I came to Parliament, Mr. Chair, for many reasons. Of course, to represent my constituents and residents in the riding of York-Durham, but also to defend the liberty of Canadians, of all Canadians across the country. And I'm glad that I did, because I have seen time and time again a pattern of anti-religious and anti-Christian bigotry from this government. And they may call themselves new, but they are just like the old anti-Christian bigoted government. Hear, hear. Whether it was our values test to receive summer jobs grants, whether it was this amendment to remove an integral part of our hate speech and anti-hate framework, whether it was to seek to remove the charitable status of religious organizations. Time and again, when given the opportunity, the Liberal government chooses anti-Christian and anti-religious bigotry. And so I'm glad that I'm here to defend the liberty of all Canadians to express their faith and their sincerely held religious beliefs. And that's exactly why the protection of the defense in Section 319 of the Code is needed to protect and defend Canadians from the type of attacks that we have seen from the Liberal government. And it has been described as a defense, Mr. Chair, and it certainly is listed as that in the Code. But I think there's another way to review or look at this provision, and it's an integral part of our entire anti-hate framework. It's not just a defense. It's not just a defense because the idea that we circumscribe the freedom of expression, the fundamental freedom of expression, I'll remind members that it's in the Charter, it's listed as a fundamental freedom, and we should give effect to that, and we don't. To curtail those freedoms requires careful balance. And the inclusion of this defense is an integral part of that. And the inclusion of it was a powerful signal by Parliament to Canadians and to the courts that the expression of sincerely held religious beliefs, including those based on a religious text, should not be subject to criminal sanction. And so it is equally a powerful signal, Mr. Chair, when Parliament decides, or as the Liberals and the Bloc members have decided, to remove that protection. That sends a signal to Canadians and to the courts that that protection is no longer afforded to people who express those beliefs. And when Parliament acts through legislation, courts are required to give that effect. That's a basic premise of understanding and interpreting our law. So for the Liberals to suggest that this doesn't mean anything and which freedom of religion is already protected, as the minister did in his letter before this committee tonight, is fanciful, wrong, ignorant, and is frankly unfortunate that the Minister of Justice would hold such view. Now, there have been accusations by the Liberal members of hate against Conservatives. I see it all the time in the House. And now we see the Liberals and the Blocs going to remove protections from those who express religious beliefs. And so I wonder if accusations of hate can now be prosecuted if we are coming vanishingly close to the idea of prosecution for a difference in political belief and religious belief by one party against another. And I want to say, Mr. Chair, that I and my Conservative colleagues will defend Canadians' freedoms to debate, to challenge, to criticize, without fear of sanction or censure by Liberals, by Bloc members, or by anyone else in Canada, their freedom to express their sincerely held religious beliefs, including from their sincerely held religious beliefs derived from a religious text. And so as long as I have to sit here, Mr. Chair, for as many nights and as many hours as you wish to hold up your own agenda with this bill, I will be right here defending Canadians' liberties. Thank you.
Hear, hear.
Okay, Mr. Brock, back to you.
Thank you, Chair. I think this is my third intervention of the night. And I want to share a personal story in this intervention. I think a few colleagues have probably heard this before, but I don't know if my Liberal colleagues have, or whether my Bloc colleague has heard this. But I really enjoyed my time as a Crown prosecutor. But I was seeing things in my small community that upon reflection was happening in communities right across the country. And I saw firsthand, post-2015, the ever-increasing crime levels. There was a point in my career where my city of Brantford, the largest city in my riding, approximate population of about 115,000, hadn't had one homicide on its books in about 5 years. It was something that we were very proud of as a community. But what I saw was the ever-increasing tide of organized crime moving from the GTA to southwestern Ontario. And before you knew it, we saw an increase in drugs, we saw an increase in weapons, we saw an increase in human trafficking, an increase in violent stabbings and shootings. And before you know it, homicides were on the rise. When I left the Crown's office in 2021, we had 12 homicides on the books, of which I had carriage of 4 as the senior Crown attorney in that office. But I came to the conclusion that I was muted as an Ontario public servant in terms of advocating for change. I knew what was wrong, and I don't want to get into those issues because those issues are going to be properly dealt with whenever we get to the study on C-14, but possibly tomorrow. But bad Liberal policies and bad Liberal laws I saw firsthand. And I said, if I'm going to be an instrument of change, I'm going to have to do it as a legislator. I couldn't do it as a public servant for the province of Ontario. So I left. And it has been my #1 mandate since my election in September of 2021 to be that instrument of change. And I have been advocating strongly for 4+ years, pushing the government, recommending to the government, actually sitting down with the new justice minister, literally within days post-election after our return in the spring, sat down with him for close to an hour and a half, gave him a laundry list of ideas that could immediately improve community safety across this country. I said, steal my ideas, take it, call it your own, I don't care. As I said earlier, I'm going to repeat it again, community safety ought not to be a partisan issue. But never did I think, as I've been singularly focused on community safety, never did I think, as a proud Christian, as a proud Catholic, never did I think I would have to defend my faith in the People's House, in a G7 country. But that's what I'm forced to do today. And I'm absolutely proud and honored to stand shoulder to shoulder with all of my colleagues here today, a collection of veterans, a collection of my colleague Melissa Lantsman and I were elected in 2021, but a lot of new members who are stepping up and will continue to step up to fight for freedom of expression and freedom of religion. I think if one thing can be said right now to the Liberal bench is that we will never give up. We will be relentless. I will sit till Christmas Eve if we have to, if resources are available. I will sit between Christmas and New Year's Eve. I will sit post January 1st, 2026, and we will continue to fight for Canadians' right to practice, to preach without fear of this Liberal government's intrusion. I had the honor, since the announcement of this secretive deal being brokered last weekend, I had the honor of attending a Catholic Mass this morning, and it was an invitation by my colleague Garnet Genuis. It was held in the Father O'Sullivan Chapel in East Block. It was to commemorate the celebration of Juan Diego. Juan Diego is remembered as the first Indigenous saint of the Americas. The appearance of the image of the Virgin of Guadalupe on his cloak in the 1500s astonished the Aztec people and has inspired centuries of scientific study of the time, the image of Our Lady of Guadalupe, today honored in Mexico City. As I sat there, I was pondering the homily given by the Father, the priest. I listened to scripture read by a lay person. I looked around. Not only did I see Conservative colleagues, but I saw Liberal colleagues. And instead of being inspired by the word of the Lord, the first thought that came across my mind is, did that priest say anything that could be deemed to be offensive, that could somehow now attract criminal prosecution? And the reason I said that is because, you know, our Minister of Heritage and Culture, who did a disastrous job with our immigration file, had been promoted to the front bench, notwithstanding his vile, extremely offensive comments to any Christian in this country, to determine that various books in the Bible are deemed, in his words, to be offensive and worthy of prosecution. I was deeply offended by that. So, to echo the words of my colleague, Mr. Lawton, you know, we can continue this. We are not going to give up. I think the Liberal bench should know that by now. But what we can do as a committee is do something collaboratively and something that Canada has been asking for close to a decade. Something that I have championed over the last 4 years. So with that in mind, Mr. Chair, I am resurrecting my motion to prioritize the consideration of Bill C-14, the Bail and Sentencing Reform Act, and work together to report the bill to the House at the earliest opportunity, and I'm seeking unanimous consent at this time. And I just heard a no from the Liberal member, Anthony Housefather.
Thank you, Mr. Brock.
That says everything that we need to know, that they do not prioritize, have never prioritized
Thank you, Mr.
community safety. Thank you, Mr. Housefather.
Okay.
Thank you so much.
Mr. Are you done? Okay. All right. Enough. Ms. Lansman, you have the floor.
I'll take my time on the floor if the Liberal members opposite stop obstructing the
And your
the
colleague to
committee.
your left. It's happening on both sides, to be fair. So.
The obstruction on the committee, frankly, of studying and of looking at the Liberal bail system, which we have talked about over and over tonight, as not seen as a priority. In fact, it's odd to me that that Liberals would stand in the House and talk about the obstruction of their own Liberal bail laws while obstructing their own legislation at committee by prioritizing what we learned last week, and we'll start from the beginning. We learned last week as a secret deal between the Liberals and the Bloc to eliminate the obvious safeguards that we've had in this country for a number of years, for a number of decades, on the expression of religious freedom. And when you come to Parliament, I think if you grew up in a background like I think many of us grew up in communities, I was raised by my community and indeed my family who moved to this country, frankly, so they didn't have to practice religion behind a curtain, like candles under floorboards, which is both dangerous, but obviously what they would have had to do in the Soviet Union, to be able to practice freely. And I'll have to say, over the better part of the last 2.5 years, we've seen, particularly in the community that I represent, that I come from, an explosion of anti-Semitism. We've seen gunshots into schools. We've seen fire bombings into businesses, protests on a weekly basis in residential neighborhoods. And this is what this is predicated on trying to solve. The problem is that C9 doesn't do any of that, and it wouldn't stop any of that. And it is sad that trying to convince a community coming in at the 11th hour, remember when Bill C9 was introduced, it was a day after the government recognized a Palestinian state. That's exactly why C9 got to an announcement when it did, which is shameful in its own right, to try to distract from the absolute vitriolic relationship that this government has created with both with the Jewish community and a longstanding Democratic ally. That's why C9 was introduced. But particularly on this amendment, there is no reason why anybody should come here and fight on behalf of their community. Fight the scourge of anti-Semitism in the community, fight what's going on in the streets, fight what's going on in the schools, in our universities, in every institution, in labor unions, in our university faculty clubs, in police forces themselves now, if you don't do it on the basis of something that you believe. And taking away the right to believe that, I think, is a very, very big problem in the country. And I don't think that anybody would fight the fight that our party, that our leader, that I have been fighting for the better part of 2 years, if they didn't do it from a place of deep religious belief. Because this isn't about a state or a conflict on the other side of the world. It is rooted in the value of Torah and religious scripture. Not necessarily if you're Jewish, if you're Christian, if you're Muslim, if you're Hindu, if you're Sikh. If you're not fighting for the things that you believe in, and if you're not fighting on the basis of that, and you're not fighting to protect it, then there's no point of doing any of this at all. And that's why I think Mr. Lawton's amendment is important. What I don't understand is how it could be interpreted as anything other than the protection of freedom. Anything other than the protection of freedom to believe what you want to believe. Because none of what has been expressed by either the Bloc or, frankly, the Liberals now who have aligned themselves with the Bloc, who used to stand up against this stuff, none of this would have been none of what they have said would be prosecuted, would actually have been prosecuted. Like this was already against the law. And we see in communities over and over again, every weekend after every weekend, and I'm oftentimes the only one to stand up and denounce it. And at great peril. And it's because fundamentally I believe that you should be able to practice your religion in this country. You should be able to hear your religion preached. You should be able to teach it in school because it is a fundamental value of why we fight for the things that we fight for. I'll tell you, my background is not dissimilar to the background of so many other Canadians. My parents came here from the former Soviet Union. My father was an uncredentialed engineer. He drove a taxi, put my mom through school. And in one generation, you go from the front seat of a taxi to the front row of Parliament Hill. That can only happen here. And one of the fundamental reasons they moved here is so that they can be who they wanted to be, practice the religion that they wanted to practice out in the open. So they weren't subjugated into a corner where Jews, frankly, in the Soviet Union were subjugated to punishment or, frankly, much worse throughout history. They came here for one of those freedoms. They came here to be able to raise their children the way they wanted to be able to stand up for what they believed in, and to be able to have that protected in law. And to watch the party that once believed in all of those things too line up with the Bloc and put all of that in jeopardy, you have to wonder if saying anything at all against hate in this country is ever going to be worth it with members opposite in this committee. We've said these things, we've defended communities at great peril to our own safety, to the safety of our families, and I think all of that is worth it. And I think all of that is worth it, predicated on the fact that you would be protecting the fundamental freedom to believe what you want to believe in this country. And I don't have to believe what everybody else believes, and nobody has to believe what I believe, but I should believe in the right to protect it, because without that, we lose it all here. Mr. Chair, I think that Mr. Lawton's amendment on this is critical. And it is critical to send a message to all Canadians who have faith, those, frankly, who don't, to tell the world, to tell the rest of the G7, the G20, if you will, that this is a country based on the rule of law, democracy, freedom, the values that we used to hold as shared values. And I wouldn't want to think that the last 2 years of advocacy on behalf of any community, whether it's the community that I come from or any other one that I have stood up for and fought for, would be in jeopardy because the Liberals want to make a deal with the Bloc. I can't imagine that anybody who has stood up for their community could support such an amendment, would support making a deal to eliminate any of the safeguards of something that is the critical center of the way in which many of us were raised, in the way in which many of us live in our communities, interact with our communities. If the thought that you have ever going into a place of worship is what that person is saying, what the clergy at the front of the room saying, criminal or not, I think we have a big, big problem in this country. And we will sit here day after day and hour after hour. And I have spoken to 50 rabbis today, and I will speak to 50 more before tomorrow is over. And they too will express their concern on this. They too will express the same concerns that all clergy in this country will express on this piece of legislation, or on this amendment, frankly. We haven't even gotten to sort of how it all started in the rest of Bill C9. But to all of those watching, particularly in the Jewish community, if you think this legislation will protect you, it will not. It will be used against you. It will be used, the very same people who purport to protect the community will use this legislation against you. It happened on Bill C-63, and they were wrong on that. You cannot have freedom in this country when you curtail freedom. You cannot have safety and security for a community if you're going to pick and choose which verses out of which books you're going to defend. And I will not stop sitting here, not a single hour of a single day. My life has changed over the last number of years, and it's for standing up for a community and a community that I believe in. And there is no chance that being under 24-hour RCMP protection is ever not going to be worth it. I will continue to say the things out loud that many of my colleagues and many in government and far too close to government do not have the courage to say. And I will never be silenced from saying it, not by this amendment and not by any piece of legislation that we will ever allow to come through this House. So with that, Mr. Chair, I am happy to have other colleagues who have come here, who have canceled all of their plans, and I'm sure are happy to cancel all of the rest. And for those who can't do this on Christmas Eve, I am happy to fill that role. I can do it on Christmas Day. I can do it every other single day of the week, and I'm happy to sit in for my colleagues who have stood up for me when this government did not. So with that, Mr. Chair, I'm happy to cede my time to many of the other Conservative members that are here fighting for your rights.
You're here.
Thank you, Ms. Thompson. Okay, we have Mr. Jennis again, and then Mr. Viersen.
All right, Chair. I think I'm going to be brief again and go to the bottom of the list because I know Mr. Viersen is eager to get in on this, and I was going to preempt his comments by discussing how the investiture crisis was more important for the development of notions of separation of church and state than the Reformation was, and I know he would be interested in that. But I'll pick up on that later on. So if you can add me to the list again right after you update the committee on how you're planning and when you're planning on ruling on the Minister of Justice's violations of the privileges of this committee by leaking documents that were clearly the property of the committee. So if you can provide an update to the committee on when you're going to rule on the Justice Minister violating the privileges of this committee. And after that, I look forward to hearing from Mr. Viersen and then following up once it becomes my turn again.
I'm going to ask Mr. Lawrence to get a pen and paper and write down, it's under advisement, so every time Mr. Jennis speaks, you can just slide it in front of him for the rest of the evening. Thank you. Mr. Viersen, we're pleased to have you at the Justice Committee. I've been a member of this committee for some time, and we've been anxiously waiting you to appear. In fact, we're trying to get you to come here last year for your own private member's bill, which was the last time the Conservatives filibustered this committee. So thank you for joining us tonight.
Well, thank you, Mr. Chair. Mr. Chair, I'm not Wade Chang, so if I could just get, I did try to take it down, but I would just like it to be either moved over or out of the, thank you, sir.
What are you doing?
Well, sir, could you just, I'm not Wade Chang.
I'm a regular member of this committee.
That's.
Mr. Viersen, I addressed you as Mr. Viersen.
Yeah, thank you, sir.
Let's not make a mockery of the proceeding. You have the floor, please.
I'm not making a mockery.
You
I'm
are.
just noting.
Please go ahead.
I'm just noting that my name is not in front of me, and it says Mr. Wade Chang.
That's your business.
That is not my name. And so when it shows,
We've established that now.
Yeah.
You've known that for your whole life. We now all know that, and so does everybody watching the committee now. So if you want to address the amendment at hand, do so. Otherwise, I'll move to the next speaker.
Chair, is this another matter of privilege? Could you take this under advisement as well?
Mr. Chair, I appreciate that you know who I am and what my name is, and I'm appreciative that you recognize
now
me.
it's in front of you, so you'll make no mistake yourself. Go ahead. Just keep looking at it, and you remind us. Please move on to the amendment. Thank you.
If we're supposed to take this seriously, so are you, Mr. Chair.
Mr. Chair, with the absence of my name, there, it would look like Mr. Chang was speaking to folks that don't know who Mr. Chang is or who I am, and so I was just trying to remove his name from my shot. You will notice that he is not in this shot as I am. So thank you, and that is. However, my name is now there. We should be good to go forward, and that was never my intention.
Mr. Viersen, this is very enlightening, but please get to the point.
Your
name is there. We know your name. Everybody knows your name. Get to the point,
Mr. Chair, this was never my intention to raise this. I was merely trying to move his name out of the picture shot, and that started an argument that I was
And
not.
you did it in a very rude manner.
Well, I thank you, Mr. Chair.
I was a witness to it.
To my.
The only person rude is Mr. Chang.
I don't know. I had a plan of where to begin, and this is not it, and so I don't know where to begin now. Nonetheless, Mr. Chair, I would like to address the amendment brought forward by Mr. Andrew Lawton. I don't know about you, Mr. Chair, but I don't remember the first time meeting Mr. Lawton, but I do remember listening to Mr. Lawton on a podcast for a lot of time. And so now, even today, when I hear his voice, I think I'm still listening to a podcast, and oftentimes I'm listening to him through one of these earpieces, so it gets me a little discombobulated. But I'm really excited that he is our new colleague here in Parliament, and so I welcome him here. Now, I remember one of the first conversations I had with Mr. Lawton when he got here, and it's always fascinating to me to ask new members of Parliament what they did before and like what motivated them to come onto the field, so to speak. And he said to me, well, defending freedom of expression, freedom of speech, and freedom of religion have been major motivators for him. And I took that for what it was, and I appreciated that, as these are things that I care about as well. And I reflected upon what had motivated me to get involved in the defense of the province of Alberta, the defense of firearm owners, the defense of the Christian faith, were all things that had motivated me. And yet, often you do not get to tangibly capture those things. And so tonight we're debating an amendment by Andrew Lawton, which does precisely the thing that he came here, what he told me he came here to do, was to defend freedom of expression and freedom of religion. It is not often, Mr. Chair, that you get to come to Parliament and do, in as many words, exactly the thing that you came here to do. Now, the fact is that Mr. Lawton made this decision to become a member of Parliament and to pursue that probably many years ago, like probably at least 2 years ago. And Mr. Lawton knew that this was a threat. He knew this was a threat more than 5 minutes ago, more than whenever he got to draft this amendment. He knew that this was a threat, and that's what motivated him to run. And so I guess that speaks a little bit to the trajectory that the Liberal government has put this country on. That speaks to when we open our eyes and look around us, see what's happening to our country. Mr. Speaker, I sit on the Veterans Affairs Committee, and we've been dealing with veterans' mental health and the things that drive them to take extreme action. And one of the things that they say is that they don't know what they fought for. They don't know why. They don't recognize the country that they come back to. And I think that's what Mr. Lawton was motivated by as well, is that to build a country that's worth defending, to build a country that I don't know where his grandparents came from, but my grandparents moved here from the Netherlands after being liberated by the Canadians, and they moved to a country that was going to defend freedom, that was going to defend freedom of religion, and that was a motivator for many people. And so I appreciate that Mr. Lawton put his name forward to run for our party. As I think we have been the defenders of freedom of religion. I remember when I first got here, Mr. Speaker, one of the first things the Liberal government did was shut down the Office for Religious Freedom. It had a special ambassador dedicated to the defense of freedom of religion. One of the first things the Liberal government did. Now, the Liberal government has not been known to be a spendthrift government. They have been known to run deficits for as long as I've been around here. They said they were going to be modest deficits. That has definitely not been the case. But they did not seem to have fiscal responsibility in their repertoire. But nonetheless, the thing they had to cut right off the get-go was the Office for Religious Freedom. And so perhaps that was one of the tipping point, the thing that Mr. Lawton noticed is like the religious freedom of expression is under attack. We've seen multiple things coming through through the Liberal government, through the courts, and the Liberal government failing to defend it when it comes to religious freedom. We've seen prolonged attacks upon religious organizations with the summer jobs attestation. And again, in that situation, the Liberals deny and say that's not what's actually happening. And then when it eventually comes out that no, that is indeed what's happening, then they back down, pay millions of dollars out to organizations who had sued the government. And then you'd think that would have taught the government a lesson around that with the kind of summer jobs. But no, the next year they take a run at it again with a separate form, a checkbox, and on the Canada Summer Jobs Initiative. Now, it seems that they've backed down on that, but then at the Finance Committee, they brought forward two recommendations from the Finance Committee to revoke charitable organizations of their charitable, or religious organizations of their charitable status. And so those are just like the very tangible things. But I think Canadians from across the country have felt the push from this government to relegate religious practice, religious thought, to inside of buildings, inside of places of worship. And now they seem to be concerned about what even goes on inside those places. I do recall, Mr. Speaker, it was a tradition in the past that the police wouldn't enter places of worship. And then we've seen during the pandemic that police were ready to enter places of worship. So the state encroachment on places of religion, freedom of religion, I think it is with good reason that Mr. Lawton told me that when he first got elected that he was motivated to protect these things. And so I am happy to support the amendment from my colleague, and I look forward to the time when we'll be able to vote on this as well. So thank you very much, Mr. Speaker.
Thank you, Mr. Viersen. Mr. Gill.
I'll go to the bottom of the list and cede my time for other fellow members if they want to speak.
Okay, that takes us to Mr. Giovanni then.
Thank you, Mr. Chair. I speak, of course, in favor of Mr. Lawton's amendment. You know, tomorrow morning there will be hundreds, if not thousands, of churches across our country that open their doors to feed their neighbors. There will be hundreds, if not thousands, of churches across our country who open their doors to offer counseling to heartbroken couples at risk of separating. There will be hundreds of thousands of churches that open their doors to help people overcome addiction and a whole host of other challenges. And the message these churches should be receiving from their government is respect, encouragement, and gratitude for the services they provide for struggling people and for people who need hope. And instead, what they are getting from their government is ridicule, disrespect, and outright attacks on their foundational beliefs, the very beliefs that motivate them to be good citizens and good neighbors, good fathers, good mothers. It's kind of a crazy situation we find ourselves in to even be having this conversation. And in the process of disrespecting these very important Canadian institutions, we have seen hypocrisy exposed on the part of two political parties in this room. On the part of the Bloc Québécois, we see a political party who says they are very concerned about the overreach of the federal government, and yet comes here to Ottawa begging for that federal government to have more power over the people who send them here. Shamefully. Yeah. On you. You are a hypocrite.
Oh.
On the part of the...
All right, Mr. Giovanni, I know you just arrived an hour ago. We had a discussion, a thorough discussion earlier on about language and decorum. Oh. And people from all sides agreed not to be making accusations and using language like that.
Oh, so I wasn't here to make that agreement.
Well, okay, but nonetheless, you said it, and it's inappropriate. So I'm going to ask you to apologize.
Oh, that's not going to happen.
All right. Well, then we'll move on to the next speaker.
Mr.
Lawrence, you have the floor.
Point of order, Chair.
No. What's your point of order? What's your point of order?
It's a point of order, Chair. Chair, first of all, there is no precedent for calling the specific language that Mr. Giovanni used unparliamentary. Members are welcome to disagree with it, but the whole discussion in this bill, I think, is about the fact that speech you might disagree with is not necessarily speech that should be made illegal.
Yeah, Mr. Janice, you're now getting to debate. You've made your point of order.
I'm debating the matter of order.
No, you've made your point of order. You're now in a debate. I'm going to stop you from speaking now. Mr. Giovanni called a member of Parliament a hypocrite. He did not, and I'm moving on to the next speaker, which is Mr. Lawrence.
I was also going to call the Liberal Party a party of colonizers and imperialists, so just to add that to
the speakers list later on. It's
sure,
late
please
in the
add
evening.
me to the
We're
list.
not going to tolerate that type of behavior. Mr. Lawrence, the floor is
Happy
yours.
to say that again.
Point of order.
Fine, you can challenge my ruling. That's your right. Chair?
There is a standing order that allows us to be appealed directly to the Speaker if you deprive him of the floor. You probably don't know that, but it was adopted as part of a provision that Bardish Chagger brought forward.
All right, thank you, Mr. Jennis.
You're welcome.
Be sustained. Madame Latanzio.
In favor.
Mr. Chang.
Yes.
Madame Dillon. Mr. Housefather.
Oui.
Mr. Jackson.
No.
Mr. Brock.
No.
Mr. Gill.
No.
Mr. Lawton.
No.
Monsieur Fortin.
Oui. Hey, come on, Jim. Okay.
Your decision is sustained.
All right, Mr. Lawrence, you have the floor. All right. Mr. Lawrence, please.
I wish to confirm Mr. Giovanni's comment that the Bloc are hypocrites.
All right, we'll move on. We can do this all night if you want.
Point of order, Mr. Chair.
Mr. Holman, yeah.
Point of order.
Ms. Lansman, yeah.
Mr. Chair, is there a list of words that you can provide the committee that you're not okay with?
If you're going to sit here and call another member of Parliament a hypocrite, then yes.
I believe
we
that
can keep
he
doing
called
this all over.
he did not
did.
call
Anyway.
another member of Parliament
I've
a
ruled on
hypocrite.
it once. I've ruled on it a second time.
This is not the same thing.
We can.
Mr.
Well, what's
Chair.
your point of order then?
My point of order is whether there is a list of acceptable words in this committee. Is that where we're at now?
It's not an exhaustive list, so, all right.
What
Thank you.
is the list? Yeah.
Okay, Mr. Holman, you have the floor.
No, point of order. It's the same incident, but it's a different point of order.
Okay, let's hear it.
You ruled on Mr. Giovanni's comment. We
Yeah.
challenged your decision and moved on. The comment made by Mr. Lawrence was not impugning an individual member. He made a general comment about a party. There is no precedent at all that I'm aware of and no standing order that prohibits that, and it is certainly not the same as what you ruled on in the previous member's intervention.
Okay.
We are free in this House and in this committee to make a range of comments
Okay,
about parties
you've
broadly,
made
which
your
are not about
point,
people.
Mr. Lawton. That's no longer a point of order. We're getting into debate.
It is a point of order.
Mr. Holman, you have the floor.
Mr. Chair, I was really enjoying the speech that Mr. Giovanni was saying. I was wondering, may I yield my time to allow the gentleman to continue with his speech?
No, we'll continue with the speakers list if you want, though, if you don't want to speak.
Get back on it, Jamil.
Okay.
Monsieur le Président, point d'ordre.
Mr. Speaker, point of order.
Go ahead, Mr. Fortin.
Président, je n'ai
Mr. Speaker, I did not hear my colleague, Mr. Giovanni, apologize, and I didn't hear him withdraw his remarks. So I would call for him to withdraw his remarks and for him to apologize.
Thank you, Mr. Fortin, and that's exactly why I took his time away and moved to the next speaker. He refused to apologize, so that's why I moved on.
speak louder.
Oh, I'm sorry.
Yeah.
He refused to apologize. Yeah. He refused to retract his comment, and which is why I moved on to the next speaker.
This is, okay. Okay.
Okay, we're back to Mr. Jennis.
Thank you, Chair. I was wondering if I'd be allowed to read a scriptural text that calls someone a hypocrite, or if that would be also deemed unparliamentary and illegal under the relevant legislation. I actually wonder, since I think Mr. Giovanni is coming up on the list again, that I'll ask you to re-add me to the bottom of the list and strike my position for now.
Put it this way, Mr. Giovanni is not going to speak again until he retracts those comments.
Okay. Well, Chair, then I would like to raise a question of privilege, because it is not merely a matter of order, but it is a matter of privilege that members be able to speak before committee. It is clearly not. And I know, look, you're relatively new in your position, but your authority as chair is not in right of you as an individual. It comes from the rules. It is a reflection of the office that you hold. And there have been multiple occasions today when you have not respected established rules. And, you know, it is an established principle that members have a right to speak. And if you deprive members arbitrarily of the right to speak, if you end their time, deprive them of the floor, these are matters that are appealable directly to the Speaker of the House. I regrettably can't remember the specific standing order, but someone will tell me in due course, and I know it's in there, that when, uniquely in the case where a member is cut off in speaking, that members can appeal directly to the House, to the Speaker, who can overturn the judgments of the chair and nullify all subsequent proceedings. So, in any event, this is a matter of privilege. Mr. Giovanni is a duly elected member of Parliament. You're welcome to disagree with him. Mr. Fortin is welcome to disagree with him, but he has a right to speak, and there are plenty of instances where members, I can think of where Mr. Erskine Smith dropped a few F-bombs at a committee in the last Parliament, and he was encouraged to be more appropriate in his language, but he was not deprived of his rights as a member of Parliament. You cannot simply decide to deprive someone of their right to speak because you don't like what they said. That is a violation of their privileges. So I would encourage you to consider whether this is a matter touching on privilege, and if you find that it is, I will be prepared to move the appropriate motion.
Well, Mr. Janis, let's do it this way. I've been in this position of chair at this committee for a week now. I've served as a committee chair for over 6 years. I notice you've never sat in a position as a committee chair. There's a reason for that, I suspect. Nonetheless, I think that in the circumstances, suggesting that I've been denied anybody an opportunity to speak is verging on laughable, considering we've been here for 7 hours listening to people speak over and over again. This might be your 10th or 11th intervention. I've lost track. So it's an accusation with no merit. Having said all that, I think what is the best course of action right now, our resources end in a few moments. I'm going to suspend this meeting for the day.
Chair, I've raised a question of privilege. You got to rule on the question of privilege.
Meeting suspended.